as soon as we can. Thank you, folks. All right. Good morning again. How are you?
I'm good. How are you?
I'm well, thanks. All right. Your juror, let me just verify your juror number. You're in seat 55, your juror 807.
Correct.
Is that correct? All right. All right, ma'am, you said that you've heard about Mr. Loyd's case.
I have.
Can you tell me how you've heard about it?
I don't remember the date exactly, but you said it was January 2017. At that time, I was a travel nurse, and I was living in New York, and I was visiting my mother for about a month or two when that all was unfolding.
Okay.
So I was staying with her, and she always has the news on, so I did see pretty much everything unfold, on the news.
Okay.
And I was watching throughout, the week when they were looking for him.
And did you also talk to your mom about what you were seeing?
At the time, yeah.
Yeah. Okay. Since that time, have you watched any coverage or seen anything?
I feel like it's been a while since things were out in the news up until, recently when they were talking about the jury being selected.
Did you read any of the articles that were published right before jury selection or look at the news?
No.
And you said you had formed an opinion as to Mr. Loyd's guilt. Is that correct?
Correct.
And what is your opinion?
That he committed the crime.
Okay. Jurors have to be able to presume him to be innocent until and if the state can prove he's guilty beyond a reasonable doubt.
Correct.
And let me tell you that we're not looking for one answer or another. There are no right or wrong answers to these questions. We just need you to tell us the truth. Do you believe that you could presume him to be innocent, or are you pretty much convinced he's guilty?
Correct. I believe he's guilty.
I'm sorry?
I believe he's guilty.
All right. State?
State moves, Your Honor.
Defense? All right. Thank you, ma'am. I don't think this is the case for you, but we appreciate your willingness to serve. You are discharged as a juror and free to go.
Thank you.
Who did I just excuse? All right. So let's just go back to the beginning. Let's go to juror number 44, or I'm sorry, juror in seat 44, number 277. Morning.
Good morning.
How are you doing?
Good. How are you?
Just well, thank you. Okay, a few questions for you. You've heard about the case, correct?
Yes.
How have you heard about it?
I only recently, beginning of this year, moved to Florida. I was living in New York. That's where my family is from. And at the time, my sister has been down here for about 10 years, and she is a former NYPD officer. So when this case happened, it struck a nerve with her, so she told me about it.
Okay. How long did your sister serve with the NYPD?
10 years.
Did you and she used to talk about her job?
No, she didn't really talk about it that much. She had a lot of, tough situations, and she is permanently disabled because of the job.
Because of her job?
Yeah.
Was she involved, was she injured?
Yes.
And was she injured?
In an altercation with a suspect.
Okay. This case involves the shooting of a law enforcement officer. Do you believe that you would be able to be fair and impartial to both sides?
I think it would be a little difficult for me.
Okay. Did you form any opinion? I take it you and your sister talked about this case.
Yeah, when it started coming back up in the news that things were happening, that this was going to be coming up,
Okay.
She did start mentioning it to me, and I do watch the news in the morning, so I did see the preliminary information. So, and then when I got my jury notice, she was like, I hope, that you're not on that case because I know it's going to be difficult for you.
Okay. Well, did you form an opinion as to whether or not Mr. Loyd is guilty?
I don't know if I've formed an opinion, but I know that being from a law enforcement family, I can't say it sways, but it does make a difference to me, and especially since my sister has been disabled because of an altercation.
State.
State moved, Your Honor.
All right, ma'am, this isn't the case for you. We appreciate your willingness to serve. I hope your sister is feeling okay. Thank you, ma'am. You're free to go.
Thank you.
Next up, we have the juror in seat 46. Good morning.
Good morning, Your Honor.
How are you doing?
We're doing well, thank you.
Okay. All right, let me start by asking you, I know that you indicated you knew something about this case, but let me start by asking you some different questions, which is this. You had indicated you had some doctor's appointments with the VA.
Yes, ma'am.
And you were having. When are those again?
The sleep study is the 3rd and 4th of November.
Okay.
I have a hematology on the 20th of this month and a preceding phlebotomy before that.
Okay. And do you have any issues with sitting on a case like this for 3 weeks?
No, ma'am.
Okay. Are all of these appointments things that you could reschedule? Or do you need to go to any of them?
The only one that has really concern for me and my doctor is
The one on November 3rd and 4th?
Yes, ma'am.
Okay. And I remember talking to you about this on Friday, about your sleep apnea. Some folks, their sleep apnea causes them to just fall asleep suddenly. Like sitting at a traffic light, they just fall asleep. Is your condition that?
That's the way it used to be before I underwent CPAP therapy.
Okay.
Right now, they said that they've done as much as they can with tweaking the machine, and they're looking at a possible, I think he called it a central sleep apnea. Some doctor term that it goes outside of the normal breathing restrictions.
Okay. Is there anything about that condition that would affect your ability to sit in court and listen to the testimony? I mean, we normally go about an hour to an hour and a half before we'll take a break, but it's sitting in those chairs, listening to witnesses and, looking at whatever evidence, physical evidence is introduced. Can you do that?
As I said Friday, I'm kind of active, so sitting very long is not really part of my daily, but I do notice in the evening when I do sit down to watch TV or something, I will find myself nodding off at that time.
Okay. You also have heard something about this case. What have you heard?
Ma'am, it was just what was reported in the news.
Okay, can you tell me how much of the news you watched?
There was an incident, police shooting. There was an apprehended, and lost interest after that.
Okay. Anything about what you heard, or, well, let me ask you one other question. Have you ever talked about this case with other people, just in passing, just chatted about it?
No, ma'am.
Okay. Is there anything about what you heard that caused you to form an opinion about whether or not Mr. Loyd is guilty?
Yes, ma'am, I believe there could be an instance or two that was may cause me to preclude my decision.
Okay. So by that, do you mean that you think he's guilty? You think he's probably guilty? Help me out here. What are you thinking?
Based on what I've heard, I would say that he's probably guilty. I'm not going to say yes, but probably.
Okay. So the law requires jurors to be able to presume him to be innocent until the state proves he's guilty beyond a reasonable doubt. It's not his job to prove he's innocent. So based on what you just asked me, let me give you a couple scenarios. You tell me if any of them apply to you. If you were seated as a juror, would you start the trial believing, this guy's probably guilty, but I'm willing to listen and see if I'm right? This guy's guilty and he needs to prove to me he isn't. Or he's innocent, I don't think he did anything until and if the state proves to me he did. Any of those three apply?
Right now, I would think that
That he's probably guilty, but you're willing to listen?
yes, ma'am.
All right, thank you, sir. State. All right, sir, because of that, we appreciate your willingness to serve, but I don't believe you meet the standard for this case of presuming him innocent. And I can't tell you how much I appreciate your honesty. We all do. So you're discharged as a juror in this case. Good luck with your sleep apnea test.
Thank
All right,
you, ma'am.
thanks. Juror in seat 48, please. Good morning.
Good morning, ma'am.
How are you doing? I'm okay. All right. Got a few questions for you. Let me start with, you said you'd heard something about this case.
Yes, ma'am.
All right. What have you heard?
When it first happened, I would hear about it like at work. People talking about it like in team meetings. When I worked, we had work hours from 6 in the morning to 4 in the afternoon. So our supervisor and other coworkers would say things like, just make sure you have good situational awareness.
Okay, you're going to need to speak up a little because now I'm having.
I apologize.
That's all right.
Our coworkers would say like, make sure you have good situational awareness because at the time I believe it was a manhunt and they were looking for Mr. Loyd. So they just say, be aware of your surroundings. And I think once he was apprehended, they told us, hey, you can stand down, everything's okay. But that was the base of it.
Okay. So during that time that they told you to be aware of your surroundings and all of that, were you fearful?
No, ma'am, because at that time, I was still new to the area. So I wasn't familiar with where it took place in relation to where I was. So I didn't think that I was like near the area that was involved.
Okay. So did you follow the news coverage on the case?
I would see the notifications like on the phone, but I didn't read into it because I felt that I wasn't in the area that it involved, so I didn't pay attention.
So you didn't watch it on the news or read about it? You read the notifications?
I would see the notification, but I don't read all notifications that come up.
Right. So did you watch the local news at all?
No, ma'am, I don't watch local news.
Did you read anything in the newspaper, the internet, Facebook, anything like that?
No, ma'am.
Right. And once Mr. Loyd was arrested, did you ever discuss it again?
I don't believe that I intentionally engaged in a conversation about it. Once we were told to stand down, I felt okay.
Okay. Based on what happened back then, and people talking to you about the case, did you form any opinion as to whether or not Mr. Loyd was guilty?
No, ma'am, because I didn't have any information on it.
All right, the law requires you to be able to sit here today and presume Mr. Loyd to be innocent. Can you do that?
Yes, ma'am.
Okay. So let me talk to you a little bit about the death penalty. What is your position on the death penalty, ma'am?
It's my opinion that it's a tool that the state has at its disposal
Okay?
to impose it needs to be considered very carefully. And it would be a lot of factors that would go into asking for something like that.
Right, so do you have any religious or moral objections to the death penalty?
No, ma'am.
And are you someone who believes that there are types of cases where the death penalty should automatically be imposed?
No, ma'am, not automatically.
Okay. That is Florida law. There is no automatic death sentence in the state of Florida, okay? So let me explain a little bit more about if you got to a penalty phase, okay?
Yes, ma'am.
What you would have to do as a juror. It's almost like another trial. The state is going to present evidence of the aggravating factors. And as I explained to you, aggravating factors are reasons why the state believes it's appropriate for a death sentence to be imposed in this case. The defense then presents their mitigators. Mitigating factors are reasons they believe that a life sentence without the possibility of parole is the appropriate sentence. So you listen to all of that evidence. I give you the jury instructions, which is the law that you're required to follow on this. You then go back into that jury room where you've been waiting. You go with your fellow jurors. You guys can discuss it as much or as little as you want. You're free to discuss anything, but you do have to be able to weigh those aggravating factors and mitigating factors. Decide how much importance you personally give to each one. You can consider all the evidence in the case and the facts and those aggravating factors and mitigating factors. And as I said, you all are free to discuss it. We don't have nothing to do with what goes on in that jury room, as long as you all want to talk about it, okay? But in the end, it's an individual decision for you.
Yes, ma'am.
And so after you had looked at everything, weighed out all the factors, aggravating or mitigating, if you believed that the appropriate sentence was life without the possibility of parole, could you impose that sentence? Could you vote for that?
I could, ma'am.
All right. If at the same time, at the end of all of that, you believed that the appropriate sentence was death, would you be able to vote for that?
If I felt that that was what was warranted, yes, ma'am.
Okay. Moving on to the insanity defense. As I told you, Mr. Loyd has raised the defense of insanity. The defense has to, it's the only thing they have to prove. They have to prove that by clear and convincing evidence in the guilt phase of the trial. We're just talking about guilt phase now, when you're trying to decide whether or not he's guilty. If at the end of all of the evidence in the guilt phase, you felt that they had proved it, would you be able to return a verdict in this case of not guilty by reason of insanity?
If I felt that what they presented warranted that, yes, ma'am.
All right. And then lastly, as I told you, he's been convicted of the murder of Sade Dixon and her unborn child and sentenced to life in prison on that. Is there anything about that fact that would weigh in your mind? Actually, strike that. Can you follow my instruction about not using that in the guilt phase of the case?
Yes, ma'am.
Can you put it aside?
Yes, ma'am.
Do you think it would be weighing on your mind during guilt?
No, ma'am.
All right, because you can't use it during guilt. All right. Thank you very much, ma'am. I don't have any other questions for you, but the attorneys do state you may inquire. Mr. Buxman? Oh, it's perfect.
Good morning, ma'am.
Good morning, sir.
When you were talking with the judge earlier, you said you heard about the case when it happened and talked about it with your coworkers and supervisor.
In meetings, yes, sir.
Okay. Did you hear any of the details of the actual event?
No, sir. What it was like if we had like a team meeting, it would be people like to the side, up in sidebar conversations.
Okay.
And our supervisor as a whole would say, you know, to the crowd or to everybody there, you know, make sure you maintain good situational awareness. Don't go get gas like at 0 dark 30 or, you know, something like that.
Okay, so you heard about, you were aware of the generalities, but not the specific details. Am I correct about
That's
that?
correct, sir.
Okay. And I believe you said when your supervisor, when he was apprehended, your supervisor said, okay, it's okay, you can kind of go back to your
Yes, sir.
normal life. Did you hear any of the details of the apprehension, or just that he was apprehended?
No, sir, just that he was apprehended.
Okay. Based on your answers to the judge's questions a few minutes ago, it sounds like you're kind of neutral about the death penalty.
I would say I am neutral, yes, sir. It's a tool.
Okay. And on a scale of 1 to 10, 1 meaning that you would never vote for the death penalty regardless of the situation, 10 meaning you would always vote for the death penalty in any first-degree murder case, where would you fall in that spectrum?
I would have to sit at a 5, sir, until I hear everything.
Right down the middle?
Yes, sir.
All right. And I believe you indicated that you believe in the fact that there is no automatic death penalty in the state of Florida. Just because someone commits a first-degree murder, regardless of how bad that murder is or what the facts of it, there shouldn't be an automatic death penalty. Do you agree with that?
I agree with that, sir.
As the judge briefly indicated, if we get to that point in this trial, the state will present evidence of aggravating factors, which are factors that make this murder more egregious than other murders. Would you be able to listen to those aggravating factors, and regardless of how many aggravating factors are presented to you, how bad the evidence is to make this murder egregious, would you be able to hold off judgment until you hear evidence of mitigating circumstances?
Yes, sir, I would need that.
Okay. Regarding the mitigating circumstances, or those circumstances in which that might make this murder the proper punishment be life, this isn't the time to talk about the details or the facts surrounding the aggravating factors or the mitigating circumstances. That'll be during the trial. But would you be able to listen to any mitigating evidence presented to you, digest and analyze the evidence, and then only after analyzing that evidence, then come to a decision about the proper punishment?
Yes, sir.
Would you be able to do that regardless of what mitigating circumstances presented to you?
Yes, sir.
Do you think Mr. Loyd deserves to have a jury who is open-minded and would consider any and all mitigating evidence presented?
Yes, sir, he does.
Okay. Once you hear the evidence about the aggravating factors and the mitigating circumstances, you have a few options as far as what to do with that evidence. You could find that the evidence didn't prove the aggravating factor or the mitigating circumstance, or you could find that the evidence did prove it, but this piece of evidence really isn't important in my decision-making process. I don't give it much weight. Or you could say that this piece of evidence is really important in my decision-making process and give it a lot of weight. It's up to you to decide how much importance to give a certain factor. Does that make sense?
Yes, it does.
Okay. Once you get that information and you start assigning weight to these things, then your analysis is going to be, do the aggravating factors outweigh the mitigating circumstances? If you find that, then you are authorized to vote for the death penalty in this case. That make sense?
Yes, it does, sir.
Now, as the judge indicated, that the decision about what the proper punishment in this case is yours and yours alone. It's an individual decision. And if one person decides that the death penalty is not appropriate, that life in prison is the proper punishment, that's the sentence that gets imposed.
Yes, sir.
It would take all of you to come back and all unanimously vote the death penalty is the proper punishment for that sentence to be a potential sentence in this case. You understand that?
Yes, sir, I do.
Okay. And nothing ever requires you to vote for death.
Yes, sir.
All right. Looking into your heart and soul, and not talking about a situation where you're hanging out with your coworkers, talking about a case, thinking, yeah, I could vote for death in that case. I would think that person deserves death. In the real life situation, would you be able to, in the jury room, after you hear all the evidence, if you felt that death was the proper punishment in this case, come back in here and tell the judge that, and render a decision saying that this man deserves to die for his actions?
If what I was presented to use to make a decision warranted that, yes, sir, I would.
Okay. One of the issues in this case, as the judge indicated, is an insanity defense. which obviously plays into a mental illness issue. And forgive me for asking a few personal questions, but I think you realize why I kind of have to ask a few of those.
Yes, sir.
Has mental illness or mental health issues affected you or a close family member or a close friend?
Yes, sir, relatives.
Okay, and can you tell me, not the name of the person, but kind of the relationship of the person to you?
You say the relationship without the name?
Yeah, I don't need to know, I don't want to ask the specific name, but is it a friend, a family member?
A family member, sir.
Okay. Did that family member get any help or treatment for that issue?
Yes, sir.
Okay. So I would gather that if it's have you seen that family member go through the issues that he or she went through?
Yes, sir.
Based on that, I'm gathering that you believe that mental illness is actually a real thing.
Yes, sir, I believe that.
Okay. Did that, after that, I'll strike that, would you be able to listen to all of the evidence surrounding the insanity defense, specifically in the mental health issue and the ramifications of that if the mental health issue exists, and wait till you hear all that evidence before you make a decision as far as whether insanity has been proven?
Yes, sir.
Okay. Is there anything in your life or your background that jumps out in your mind that might make you think you wouldn't be a good juror for this type of a case?
No, sir.
Great. Okay.
Did she serve active duty in the Navy? Sounds like that's true.
I noticed on your jury questionnaire that your previous employer was the Naval Air Warfare Center.
Yes, sir.
What is that? What did you do for that in that position?
I was a business financial manager.
And what did that involve on a day-to-day basis?
It was accounting. If a program needed funding for a trainer that they were trying to build or that was being sold, I was the person who would coordinate the funding for the parts, make sure that the contractors or the government officials got paid or that they had funding available for them.
Okay. Was that a civilian position, or did you serve in the military, as active military?
Both, sir. I was active duty military.
I see.
But that job was as a civilian.
Okay. What branch were you?
Marine, sir.
Okay. Thank you for your service, ma'am.
Thank you, sir. My pleasure.
No other questions, Your Honor.
Thank you, Mr. Buxton. Mr. Lenneman, you may inquire.
Good morning, ma'am. How are you?
Good morning, sir. I'm well, and you?
So when did you serve in the Marines?
Sir, from July of 1989 until December of 2010.
Okay. So you did a couple tours?
I went to Iraq once, sir.
Okay. Now, Mr. Buxman spent a lot of time talking about the rules in regards to the penalty phase. Do you have any questions about those?
No, sir, not at this time.
Okay. So essentially, I just want to make sure you understand that the way the legislator created the decision-making process of the death penalty is that they were sure to make it mandatory that each individual juror gets to decide whether to vote for life or death individually through their own weighing process. They don't have to get around the table and talk about it. It's all up to you individually. Do you understand that?
Yes, sir, I do.
Okay. And the law says, I don't think Mr. Buxman, I think you did mention it actually. The law says that even if you find the aggravating circumstances outweigh the mitigating circumstances, you are never required to vote for death. You may have some reason, whether it's mercy or something else, but you are never required to vote for death. Do you understand that?
Yes, I do, sir.
Okay. And finally, if you are, this requires a unanimous jury, that means all 12 have to vote for death. If one person votes for life, that's considered a life verdict. You understand that?
Yes, sir.
Okay. And finally, do you understand that there may be an occasion, there has in the past, on certain kinds of cases where a juror will be not in agreement with your opinion, and sometimes people get pushy and try to kind of persuade other jurors of their opinion. If you have a firm opinion in your belief, will you allow that to happen?
For someone to make my opinion theirs?
To bully them, for them to bully you into saying, okay, you're saying X, well, let me tell you why, this is why, and blah, 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 and you have a firm opinion one way or the other, life or death. Are you going to let anybody change your opinion?
No, sir.
Okay, thank you very much.
Thank you, sir.
Either side need to approach?
No, Your Honor.
No, Judge.
All right, ma'am. We're going to bring you back for one final round of questioning, and it will be the final round. Can you hear me with this phone?
Yes, ma'am, I can.
Okay. We will be picking the jury the next time that you come to court. I'm going to change your color to purple. You're now a purple dot. And that's just because when you're calling the jury room to find out when you're supposed to come back, you're listening for the purple group.
Yes, ma'am.
Okay? We're giving you a sequestration package. The jury will be chosen the next time you're here, and they will be immediately sequestered. So you need to pack a suitcase, bring it with you to jury selection. Bring it with you to jury selection, but leave it in your car. You'll only need it if you're actually selected as a juror.
Yes, ma'am.
There's a slip of paper in there with the phone number that you're supposed to call. Don't even start calling until Friday after 5, this Friday after 5. Then call Friday, Monday, Tuesday. We won't need you earlier than next week, and it'll probably be towards the latter part of the week.
Yes, ma'am.
But just call after 5, and eventually you're going to hear the purple dots to report on such and such a time. It will be this courtroom, but you'll be reporting to the jury room. Okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right, thank you so much, ma'am. We appreciate your time this morning. Yes,
Thank you,
ma'am.
ma'am.
You're free to go. All right, the juror in seat number 49, please. Good morning.
Good morning.
Can you hear me through this mask?
Yes.
Can you hear me? Okay. If at any point you can't, let me know, all right? So, just like I said, we have a few questions for you. There aren't any wrong or right answers to these questions. There's just what you actually think and feel. So just be honest with us, and you'll be doing exactly what you're supposed to be doing. Let me start with, you said you had heard something about this case, is that right?
On the TV, I just heard about it on TV.
Okay, you're going to need to get that mic closer to you because I can't hear you.
I said I see the act on the TV, that's it.
You saw it on television?
Yeah, when it was happening.
Okay, how much did, it's okay that you saw it on TV. How much did you see?
How much?
How much did you see?
No, I see when the incident was happening and what happened.
Okay,
Everything they
can you
used to show on the
loosen your
TV.
mask a little bit?
Everything they used to show on the TV, that's all I see.
Okay. Did you see a lot of it? Did you watch it every day? What?
No, not really watch it every day.
Okay. Based on what you saw on TV, did you form an opinion as to whether or not Mr. Loyd is guilty?
For me, what he's doing, it was bad, but from my concern, my religious, I cannot judge someone to say if it's guilty or not guilty, because I don't know when the person doing the act, what was happened to him spiritually.
Okay.
That's why I cannot really decide about cases.
So if I understood you correctly, you said what he did was bad, but your religion prevents you from judging someone?
Yes, that's correct.
Okay. So what religion are you, ma'am?
I'm Pentecostal.
Are you a Pentecostal?
Yes.
All right. State.
Statement, Your Honor.
Any objection? I can't hear a word you're saying.
Just one or two questions.
Sure, go ahead.
How are you doing, ma'am?
I'm okay. I'm okay.
So the way a trial works is there's a possibility that there will be kind of two separate trials in this case. One has to do with the guilt or innocence of Mr. Loyd in regards to what he's accused of doing. The state would put on evidence, I would put on evidence, and at the end of that, you as a juror would have to decide whether he was guilty or not guilty. Can you do that?
No, I cannot punish someone guilty or not guilty.
Thank you, ma'am.
All right, any objections? Mr. Lenneman, any objection? Okay. All right, thank you, ma'am. Based on your religious beliefs, I'm going to excuse you from this jury, but thank you for coming in. You have a good day.
Thank you. Thank you.
The juror in seat number 50. All right, good morning, sir. How are you?
Good morning, ma'am.
All right, just have a few questions for you.
Okay.
As much as possible, try to relax. Can you hear me with this mask on?
Yeah, I
Okay.
can hear.
There aren't any right or wrong answers to the questions we're asking you. There's just what you actually think and feel. That's all we're looking for. So don't worry
Yes, ma'am.
about what the answer is. Just be honest with us. So let me start with, you said you'd heard something about this case. Can you tell me what you heard?
All I heard is, I watched the case, pieces of it when it first came out, and I don't really follow it, but I've seen different news on it sometimes, and maybe we discuss it with my wife or so, and saying that well, we don't know the reason why he did what he did. It could be insane, it could be. So that's pretty much what I know about it.
All right. Based on what you've seen, have you formed an opinion as to whether or not Mr. Loyd is guilty?
Well, I thought about it. I said, if he's great, I don't know if it's the right word to use, say that he's crazy, and, I have a brother that is mentally ill, and, I know he had put our family in situation already, but I said, I don't know what's the reason why he do what he do, so
Okay.
I don't really judge him unless I really see what he really do.
Okay. So does that mean jurors have to be able to presume he's innocent until and if the state can prove he's guilty? Can you do that?
I don't know. I've never been in this situation where I have to say, okay, I judge somebody unless I know on the other side hear from the other side what he do.
Okay. Maybe I'm not making myself clear. In a criminal case,
Yes, ma'am.
defendants are presumed to be innocent until the state can prove they're guilty beyond a reasonable doubt.
Okay.
You follow me so far?
Yes, ma'am.
So as you sit here today, can you presume Mr. Loyd to be innocent
Yes, ma'am.
until you hear the evidence, and if it convinces you he's guilty? But it has to be based on the evidence you hear in the courtroom. Can you do that?
Well, I believe he's innocent, and yes, I believe he's innocent until, but I know you say it's have to base on the evidence in court, but I don't know. I have to hear both sides of the case and see if he's really innocent or guilty.
Okay. Can you tell me, have you ever thought about the death penalty before?
Yeah, I thought about it, but between me and my religion, I don't really believe in the death penalty.
Okay.
I know I couldn't find somebody guilty on the death penalty because with my religion and I never believe. I raised up in a Pentecostal church, and I, never believe in it.
So you're Pentecostal?
Yes, ma'am.
So based on your religion, are you someone who could never impose a death sentence regardless of what the law says?
Yes, ma'am.
All right. State.
Statement, Your Honor.
Mr. Lenneman?
Just a couple of questions, Judge.
Sure.
How are you doing, sir?
Doing okay, sir. Good morning.
So the law basically says that if you are a juror on a case like this where the death penalty is being sought, that you have to have the ability to at least consider the death penalty to be able to sit on the jury. If you can never consider the death penalty in any form or fashion, then you can't sit on the jury. The law also says that you are never required to vote for death under any circumstances. But that doesn't mean you can sit on the jury if you can't follow the law, and one of the pieces of the law is to consider the death penalty. Consider death, consider life, and make an ultimate decision. Are you following me?
So far?
Okay. So you have these moral beliefs, right?
Yes, sir.
And you are part of, the state of Florida as a citizen who has civic responsibilities.
Yes, sir.
One of the things as civic responsibilities is jury duty and to participate in the system that is lawful in the state of Florida. You follow me?
Mm-hmm.
Okay. So is your belief so strong about never voting for the death penalty or not being able to find someone guilty because the death penalty is at play that you would disregard your civic duty in making a decision?
That's really a trick question, because I don't want to disregard my civil duty, and at the same time, I don't want to go against my religion, my belief, But, I've been with this religion from ever since birth, and I believe that, I just never want to find myself in the position where I have to decide between life and death of somebody.
Okay, I understand that. So I guess my question is your belief so strong that it's going to overcome anything else, including your civic duty?
Objection, formally question.
Sustained.
Okay.
Sir, you don't need to answer that question. Rephrase it.
Knowing what I have told you, are you going to be able to sit on the jury and keep an open mind in spite of your religious belief?
If I'm on the jury, I know I'm not gonna consider the death penalty.
Okay. Thank you, sir. I appreciate it.
All right. Any objections, Mr. Lenneman?
No.
All right, thank you, sir. Based on your religious beliefs, this is not the case for you, but we appreciate you coming down. You're excused.
Thank you, ma'am.
Juror in seat 51, please. What do we got? Okay, we're going to take a break after this, Juror. Okay. Good morning, ma'am.
Good morning.
Can you hear me with this mask on?
Yeah, I can hear you.
Okay, if at any time you can't, let me know, all right? All right, ma'am, we just have a few questions for you. There are no right or wrong answers to these questions. We're not looking for a particular answer. We need you to be honest with us, so don't worry about what your answer is, just be honest with us, okay? Let me start with, you indicated that you've heard something about this case. Can you tell me what?
It was on the news.
Okay, so how much of the news did you watch?
I don't watch that much of news, but that day it was a big impact, and I just heard it.
All right, so that day, what do you mean by that day?
Well, the day it was on the news.
The day it happened? Okay.
Yeah.
So other than that day, did you watch any more news coverage?
Yeah, because I work late, and, you know, not only that, in the news, you can hear other people talking about it.
Okay.
So that's how I know.
How much talking about it did you hear?
Not a lot.
Not a lot?
Not a lot.
Okay. Before you came to jury, to this courthouse, when was the last time you heard anything about this case?
The day I heard it, that was the last day.
All right. And based on that, did you form an opinion as to whether or not Mr. Loyd is guilty?
I would say not.
Okay. So can you presume him to be innocent until and if the state proves he's guilty?
Well, that I can't, because the reason I said he is not is because I don't know that day if he was going to anxiety, depression, or mental sickness, and my moral religious, I cannot prove him guilty.
All right, so what religion are you?
I am Baptist.
You're Baptist? Mm-hmm. All right, are you saying that your religion prevents you from sitting in judgment on someone?
Yeah. I not 100% know it, but I know, I believe on the death, the resurrection, and the judgment. And I know from there, I know that one person.
All right, so do you believe that your job as a juror is this, okay? If you're a juror on a case, in the guilt phase, you have to listen to the evidence that's presented. You have to have an open mind, and you need to listen until the very end of the case, all right? So at the end of that case, you would be asked to make a decision based on the law that I give you as to whether or not the state has proven that Mr. Loyd is guilty beyond a reasonable doubt, or whether Mr. Loyd has proven by clear and convincing evidence that he was insane at the time of the offense. You follow me so far? All right. So if at the end of all of this, you had heard all the evidence and you believed that the state had proven that Mr. Loyd was guilty, could you render a verdict of guilty?
No, because I believe on forgiveness.
Okay. And if you believed, well, actually, I don't have any other questions. State?
State moved, Your Honor.
Defense? Sure. We have one more. Okay, who is it?
How are you, ma'am?
52, yeah.
Hi.
Okay. So I understand that you have very strong religious beliefs. And you're aware that, or you agree with me that you have certain responsibilities as a citizen of the state of Florida and living in Orlando as a law-abiding citizen. You agree with that?
Yes, I do.
Okay. So one of the responsibilities is coming in to do jury duty, okay? And serving on a jury if you're qualified, okay? And on the other side, you have a strong religious belief.
Yes, sir.
And I think you said it was not judging someone.
Yeah.
Is that correct?
Yes.
So in a situation where your responsibility was to listen to all the evidence in the first part of the case, because you had said you thought, well, maybe there was something wrong with him, okay? In this case, we're putting forward evidence that there was something wrong, that Mr. Loyd was insane at the time of this incident, okay? So that would be one of your responsibilities to judge that, okay? So would you be able to listen to the state's evidence fairly and to judge the insanity defense fairly and keep an open mind? And at the end of that, make a decision to determine whether Mr. Loyd is not guilty by reason of insanity or guilty?
Yeah, I will listen to the case. If you guys go into medically proven that he was not having a sickness, mental sickness, or a depression, or
Okay.
anything like that. That's the only way I would find him guilty.
Okay, so if we put on evidence that he does have that, and you don't believe it, you don't believe he's mentally sick, you would be able to find him guilty because we didn't prove that, and the state proved their case. You'd be able to do that, right?
Yeah, the only way is the case, is the state just like testing his ability mentally.
Okay.
He was not sick.
Okay,
That's the only way I would
okay.
find the case.
Okay, and so you would be able to find him guilty if that wasn't proven to you about the insanity issue, right?
Yeah.
And you would be able to find him guilty if the state proved to you beyond a reasonable doubt that he did this. Okay, thank you.
All right, so let me follow up on what you said. You understand that the state does not have to prove that he's not insane. The defense has to prove he's insane by clear and convincing evidence. Do you understand that they have to prove the insanity, not the state? You understand what I just said?
I'm a little bit confused because I don't speak English very good.
Okay.
Yeah, I have a little problem understanding that when there's a lot of confusion. So
Let me take my mask off to make sure you can hear me clearly. The defense of insanity has to be proven by the defense, by clear and convincing evidence. It's not the state's job to prove that he's sane. It's the defense's job to prove he's insane. Can you follow that?
So you say it's not the state job, it's the defense job.
The insanity, all right? The insanity defense has to be proven by the defense. So the state's going to stand up and they're going to present evidence that they believe proves that Mr. Loyd is guilty of the crimes he was charged with. And you have to decide, did they prove that beyond a reasonable doubt? And I'll give you the definition of beyond a reasonable doubt. The defense is going to stand up and say, he was insane at the time, but it's their job to prove he was insane. Can you follow that?
No.
Is it that you don't understand the English, or you just don't understand the way I'm explaining it?
I just don't understand it.
Okay.
That's the first time I ever be involved in something like that. To be honest with you, I don't want to be like bringing up something and then that's not right. Because I do not understand, what is reasonable doubt is, and that's my confusion right there. Reasonable doubt.
Let me see the attorneys at the bench, please. All right. I'm going to ask you a few more questions, okay?
Okay.
I know that's not thrilling for you, but I'm going to ask you a few more questions, okay? Let me ask you about your beliefs about the death penalty. Can you tell me what those are?
Death penalty?
Yeah, the death penalty.
Yeah, when you put somebody to sleep?
The death penalty in Florida is by lethal injection. My question is, let me put it another way. Do you have a moral or religious objection to the death penalty?
My suggestion is forgiveness. Forgive.
I'm sorry, I can't hear you. You've got to have the mic next to your mouth. What-
Forgiving.
You believe in forgiving.
Yes, ma'am.
Okay. Does that mean that you have an objection to the death penalty?
Yeah.
Okay. Like I told you, you don't need to hesitate about your answers. You tell us what you actually believe.
Yes.
All right? All right. So if you found yourself in a penalty phase in this case, Mr. Loyd had been convicted, you have to be able, you never have to vote for death, but you have to be able to consider death as an option. Would you even consider the death penalty as an option? Or would you automatically vote for life?
Yeah, I would vote for life.
You would what?
I would vote for life.
You would vote for life
Yeah.
without considering death.
Yeah.
All right.
State moved, Your Honor.
All right. Thank you, ma'am. We appreciate your time and your willingness to come down here. You're excused as a juror in this case.
Thank you.
Thank you. Juror in seat 52, and this is the final one from 9 o'clock. The other two got moved into the 10:30 group. Good morning.
Morning.
Can you hear me through this mask?
Yes, ma'am.
All right. If at any point you can't, let me know, okay? Just have a few questions for you. Not looking for any particular answer. There really aren't any right or wrong answers to these questions. We just need you to tell us the truth, what you honestly think and feel, okay?
Yes.
Just to verify, you haven't heard anything about this case before you came to court, is that correct?
No, Judge.
All right. So, do you have any religious or moral objections to the death penalty?
No.
Okay. Are you a person that believes that if someone is convicted of first-degree murder, premeditated murder, that they should be automatically sentenced to death?
No.
The law in the state of Florida is very clear. There is no automatic death sentence in a first-degree murder case. In fact, the automatic sentence is life without the possibility of parole, unless and if the state can prove aggravators that a jury believes are sufficient to impose the death penalty. Follow me so far?
Yes, Judge.
Okay. In a case like this, the penalty phase is a second trial, basically. The state's going to put on evidence of the aggravators, why they believe the sentence should be death. The defense is going to put on mitigators, why they believe the sentence should be life without parole. I give you the law. The jury instructions are the law that you're supposed to follow. You and your fellow jurors go back in that jury room. We have nothing to do with what goes on in the jury room, okay? You all can discuss it, not discuss it. It's up to you. But you can discuss it if you want. But you personally have got to weigh the aggravators that you feel were proved and the mitigators. You have to weigh them and give them whatever weight you think they deserve. You've got to weigh that out, think about the evidence, the facts, either talk to or not talk to your fellow jurors, And in the end, you have to make a decision as to whether you think life or death is the appropriate sentence. So if at the end of all of that, you felt that life without parole was the appropriate sentence, could you vote for that?
Yes.
And if at the end of that, you felt death was the appropriate sentence, could you vote for that?
I'm not sure.
Okay. What is it that's causing you to hesitate?
I just don't have an answer at this time.
Okay. Is it the enormity of the responsibility of that vote that's causing you to pause? Okay. Because you told me you didn't have an objection to the death penalty. It's just the thought of you being the one to have to do it. Is that correct?
Yes.
Okay. What about the insanity defense? Mr. Loyd has raised the defense of insanity in this case. If at the, and that would be in the guilt phase, when you're trying to determine whether or not he's guilty. The burden is on the defense. It's the only time it's their burden. It's by clear and convincing evidence. If at the end of the guilt phase of the case, you felt that they had proven that he was insane at the time of the crime, would you be able to return a verdict of not guilty by reason of insanity?
Yes.
Okay, and then the last question I have for you is, you remember I told you that he's been convicted of the murder of Miss Dixon and her unborn child and sentenced to life in prison. You cannot use that to decide whether or not he's guilty of these charges. It's a completely separate case. Do you understand that?
Yes, Judge.
Can you follow that instruction and put it out of your mind in the guilt phase?
Yes.
All right, thank you, sir. I don't have any other questions for you, but the attorneys do. Mr. Paxman, you may inquire.
Good morning, sir.
Good morning to you.
A few minutes ago, you indicated to the judge that you couldn't give an answer as far as whether you would be able to actually make that vote for the death penalty. Did I understand you correctly?
Yes.
Okay. What's going through your mind? What's the, is it a religious issue, a moral issue, or an issue that you don't know if looking inside yourself, if you would be able to actually raise your hand and say, I think this person deserves to die for what he did? Is that the burden on your personally?
I believe so.
Okay. Can you think of any situation where, after listening to all the facts and all the evidence of the aggravating factors and the mitigating circumstances, can you envision yourself, not in a hypothetical sense, talking to friends, coworkers, and family, but actually sitting in a jury room after considering the evidence, raising your hand and saying, the death penalty is appropriate and you voting for it? Do you have a doubt in your mind you could do that? And it's okay if you do.
No.
No, you know what?
Can you ask the question again?
Sure. Do you have any hesitation that if you were back in the jury room after listening to all the details and the facts and evidence, would you personally be able to vote for death in any circumstance?
Objection is an improper question.
Can you rephrase the question?
Yes, ma'am. If you find yourself back in the jury room and you've heard all the evidence in this case, you've considered the evidence of the aggravating factors and the mitigating factors, would you ever be able to come into the courtroom and vote and say, this man deserves to die for what he did? Would you be able to be a part of that process?
Okay, I can only have one lawyer objecting. Mr. Lenneman started. Nope, you started. You have to finish. Go ahead.
Also a pre-committed judge.
Let me look at the question again. Hold on. Overruled.
Looking inside yourself, knowing you better than anybody else, would you be able to do that?
Yes.
So by your answer, I'm understanding that if you analyzed the evidence and you felt that death was the proper punishment in this case, you could vote for death.
Yes.
Okay. Is there any reasonable doubt in your mind that you may not be able to?
No.
Okay. Can you talk to me a little bit more about the struggle that you went through in coming to that decision?
I believe that if the verdict is, or my decision is death, I mean, that's final.
On a scale of 1 to 10, 1 meaning that you would never vote for death, ever, no matter what the circumstances are, and 10 being you'd always vote for death for any first-degree murder case that you would look at, where would you fall on that spectrum, that line?
Between the 7 and 8?
Between the 7 and 8?
Yes.
Meaning
Yes.
most of the time you would vote for death?
Yes.
Okay. The judge indicated a few minutes ago, I think she talked to you about this, that in Florida there is no such thing as an automatic death penalty. You agree with that?
Yes.
What would happen is the state would present evidence of aggravating circumstances, which are facts that make this murder more egregious than other murders. And no matter what the circumstances of the murder, no matter how many aggravating circumstances are presented to you or how bad those aggravating circumstances make this murder, would you still be able to listen to mitigating evidence presented to you?
Yes.
Okay. And would you be able to hold off judgment about the validity of those aggravating factors and mitigating circumstances until you hear all the evidence surrounding them?
Yes.
Once that evidence is presented to you, you have the option to do a few things with it. You can look at the evidence as it applies to an aggravating factor or a mitigating circumstance and say, look, the evidence just didn't prove those existed. That's one option. Another option is you could look at it and say, well, the evidence has proven those things exist, but this aggravating factor or mitigating circumstances really isn't important in my decision-making process as far as what the proper sentence should be, so I'm not going to give it much weight or importance. Or you could say this piece of evidence is really important in my decision-making process and give it a lot more weight or importance. Does that make sense?
Yes.
All right. Would you be able to go through that analysis and that weighing process?
Yes.
And once you go through that weighing process, then the ultimate decision is to be made. You individually make the decision of what the proper punishment should be. If you're never required to vote for death, the law is never going to say if you check these boxes and all these boxes are checked, you have to vote for death. You understand that?
Correct.
Okay. If one juror votes that life is the appropriate sentence in this case, that's what sentence will be imposed. Okay?
Yes.
It would require all 12 jurors to come back and vote for the death penalty for that to be a potential sentence in this case. Does that make sense?
Yes.
Now, knowing that you never have to vote for death, and knowing that if the jury unanimously comes to the conclusion that the death penalty is the proper punishment in this case, everyone will know you voted for it, obviously, right?
Yes.
Knowing that, I'm going to ask you just one last time, knowing that you never have to vote for death and that everyone would know you did, in fact, vote for death if it was a unanimous verdict, do you still think you'd be able to sign that paper or raise your hand and say, I vote for death?
Overruled.
Can you repeat that question?
Sure. Knowing that you never have to vote for death, and knowing that if the jury does unanimously vote for death, that everyone would know you did it, would you still be able to, in that jury room, raise your hand and say, that man deserves to die for what he did?
Yes.
If you believe that was the proper punishment?
Yes.
Okay. Is there anything in your life or background that makes you feel you may not be a good juror for this type of a case?
I don't recall that.
Okay. One of the issues in this case is insanity, and that comes into play some mental health issues. I'm going to ask you a couple personal questions, and forgive me. But do you or a close friend or family member have ever dealt with any kind of mental health issue that affected your life or their lives?
No, sir.
No?
That's a no.
Okay. Some people say or think that mental health issues are fake, they don't exist. Do you believe that mental health issues are real and legitimate in society?
Yes.
Okay. Would you be able to listen to all the facts of the case surrounding the insanity defense and whether a mental health issue exists, and if so, what the ramifications of that issue are before making a decision as far as whether insanity has been proven?
Yes.
Okay. So you can reserve judgment until you hear all the evidence?
Correct.
All right. One last question. I noticed in your jury questionnaire your occupation was a manufacturer engineer.
That's correct.
What do you do on a daily basis? What's that involve?
In my current position, I work in the clean technology. I work for Siemens, and the work includes building the structure for what we call the nacelle or the turbine. It's a tower.
You said building the structure for what we call
A nacelle. That's the turbine. And that includes fabrication, of course, to make the structure, then painting it to keep its lifespan for over 25 years. And of course, the internals for you to get up in the tower and all the power that brings it from the nacelle to the grid.
Okay. Thank you for that explanation. I appreciate it, sir. No further questions, Chairman.
Thank you, Mr. Bruxman. Mr. Lunneman, you may inquire. You started, you have to finish, okay? Sure.
Thank you, Judge. How are you doing, sir?
I'm doing fine.
I'm just going to talk to you about a couple of things, and then we'll be done. So Mr. Bruxman covered some of these, and I just want to make sure you understand what the rules are when it comes to the second part of the case if we get there, all right? So the only way we're going to get to the second part of the case, which is the penalty phase, is if Mr. Loyd is convicted of first-degree murder of Sergeant Clayton, okay? You follow me on that?
Yes.
Okay. So your responsibility then as a juror is there's going to be like a second trial. The state's going to put on evidence. The defense is going to put on evidence. They're going to put on aggravators. We're going to put on mitigators. And then after all that, we'll do closing arguments and give you our position on why they believe the death penalty is appropriate and why we believe it is not. Once you hear that information, as jurors, you go back, and the first thing you have to do is make a decision as a group, and this is the only time you do anything as a group. Make a decision as a group, first individually, whether you believe one or more aggravating factors were proven. If you believe that, and collectively each one of the jurors believe that, then you can go on to the next step. You follow me?
Correct.
So the next step is individual. Everything after this point is individual. The jury instructions and the law will make it clear that this is an individual decision by you. You're the one who makes the final decision whether to vote for life or death. There's some guidance on how you should do it, but it's only guidance because the law says you are never under any circumstances required to vote for death. And when the judge instructs you on that, that's exactly what she's going to tell you. But the guidance is this. Once you guys prove one aggravator beyond a reasonable doubt unanimously, then you have to look at the aggravation the state presents. You have to decide whether it was proven beyond a reasonable doubt. They may give you a number of different, what they call aggravating factors. You have to look at each of them, decide whether it's proven beyond a reasonable doubt. Then you have to decide, when we present the mitigation to you, you have to look at that mitigation and say whether it was proven. It's a lesser standard than reasonable doubt. It's a lower standard, but it still has to be proven. Once the mitigation is proven to you, then you have to weigh the mitigation and the mitigating factors. You may find one that is very, very weighty for you. You may find some that are in the middle range and some are in the low range, but you get to decide how much weight you give each individual mitigator. You also get to decide how much weight you give the mitigation collectively. Then you look back at the aggravation and you have to do the same. Weigh each one, how much weight, collectively how much. Once that's done, then you basically have two things, mitigation and aggravation. It's your responsibility then to weigh those factors and decide which one weighs heavier in your mind. If you believe the mitigation outweighs the aggravation, then the law says you must vote for life, period. There's no ifs, ands, or buts. If the aggravation in your mind outweighs the mitigation, the law says you may, M-A-Y, may vote for death, but you're never required to. Because as I told you earlier, there's a provision that the legislator has put in that says, listen, folks, you as jurors make the ultimate decision. We know death is a serious, serious thing to decide, and we're never going to force you to make a decision. So we're going to always give you a way out. And it could be for anything. You could have a moral reason, you can have another reason, but you never have to vote for death. So even if you feel the aggravators outweigh the mitigators, you never have to vote for death, period. Do you understand that?
Yes, sir.
Then collectively, you will get together as a group and you will cast your votes. In order for a death vote to take place, it has to be unanimous. Every juror on the panel, all 12, have to vote for death. If one juror votes for life, it's a life verdict. Not a death verdict, it's a life verdict. So all it takes is one juror to vote for life. Do you understand that?
Yes, sir.
Okay. So one other thing I wanted to talk to you about, and I don't think this is obviously going to be a problem with you, because I don't think you're a person who's meek or you're going to allow yourself to be pushed around. But there are circumstances in the jury room that will develop sometimes because this is such a serious case and there's a lot of emotion connected to it. Some of it's anger, some of it's other things, but sometimes jurors try to push other jurors into changing their decision. If you have a firm position and stance on your belief, one way or the other, are you going to maintain it?
Yes, sir.
Okay, you're not going to let anybody bully you.
No.
Okay. And if you see someone else being bullied, are you going to mention that, listen, we're not supposed to do that. Everyone has their own decision. Let a person make their decision.
Are you asking me if I would be making the call? And
Not making the call. If you're the type of person...
Sir, you need to put that mic up to your mouth. I can't hear you. Not you, Mr. Lenneman.
Oh, sorry.
That's all right.
I'm not saying making a call. I'm just asking you, if you saw a circumstance that you thought was wrong going on in the jury room, would you say something?
yes.
Okay. Those are all the questions I have. Thank you very much, sir.
Thank you, sir.
Thank you, folks. Anybody need to approach?
No.
All right, sir. We're going to send you through to a final round of questioning. The next time you come, we will be picking the jury that day. So I have a couple of instructions for you. First of all, you're now a purple dot, not a green dot. And that's just because when you call the jury room line that we're going to give you, you're listening for purple dots return on this date at this time. I have no idea what day it is yet because I don't have enough folks to know that. It'll be no sooner than next week. So start calling this Friday after 5. So call Friday, call Monday. Eventually, you're going to hear the call back. Because we're choosing the jury the day you come back, we're also sequestering the jury that day. So you will need to have packed a suitcase for sequestration in case you're picked. Leave it in your car. Don't bring it into the courthouse. We'll retrieve it if you're chosen for the jury. Do you have any questions?
So is it my understanding I should be coming with a packed bag? Is that my understanding?
You should be packed and ready to be chosen as a juror, because if you're chosen as a juror, you're being sequestered and you're going to a hotel. Okay? All right. Thank you.
Your badge for a second.
And once again, we're behind schedule. All right. Anybody need a break, including the court reporter? We have the 10:30s here, but anybody need a break? What? We're missing two 10:30s? Did the two 9 o'clocks arrive? Oh, so see, we're back up to 10. Juror number 9 is missing. And who else is missing? Okay. C12 is what? Does he think that will stop me from hunting him down? Because it won't. All right. All right, we're back on the record on State versus Loyd. He's present with his attorneys. The state attorney's office is present. This next group includes panel 3 and panel 4, and the 2 jurors from the 9 o'clock who were not here, so we have 12. Let's bring them in. Apparently we're not. It's fine.
solemnly swear or affirm that you will answer truthfully all questions asked of you as potential jurors, so help you God? Thank you.
All right, good morning, everyone. Have a seat, please. All right. Welcome back to day 2 of jury selection. Let me ask, can all of you hear me with this mask on? Is anybody having any problems hearing me? Nope? Okay. All right. As I told you, we do these cases, or the jury selection for these cases, in multiple groups or in multiple days. Today is individual questioning day. I'm going to instruct you and give you some facts about the case as a group. Then I'm going to send you back into the jury room and we're going to talk to you one at a time. We will be breaking for lunch at some point, but we're going to try and get through as much as we can prior to that. So, as I indicated to you on Friday, this is a death penalty case, or what we call a capital case. These cases are tried in 2 phases, the guilt phase and the penalty phase, if the penalty phase becomes necessary. The guilt phase is the same as all other criminal trials. It's where you decide whether someone's guilty or not. So I'm going to start by telling you what Mr. Loyd is charged with. And he's charged by indictment. This is a copy of the indictment in my hand. It's a piece of paper that tells him, this is what we're accusing you of doing. These are the crimes you're being charged with. You have to tell people what you're charging them with, what you're accusing them of doing. This is how Florida does it. This indictment is not evidence of guilt, and you may not use it as such. And by that, what I mean is, just because someone's been charged with a crime does not mean they're guilty, and you can't make any assumptions off of this, all right? So he's charged in count 1 with first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. And count 5, possession of a firearm by a convicted felon. And as I indicated, the case is tried in 2 phases. Phase 1 is the guilt phase. It's the same, it's conducted pretty much the same way we do all criminal cases. You're going to be asked to sit in the courtroom, listen to the evidence, listen to witnesses testify, see physical evidence. Same as you do in every criminal case. At the end of that, you'll be provided jury instructions from me, which are the law that you must follow, and you will be asked to return a verdict of guilty or not guilty on all counts. And your verdict must be unanimous on all counts, meaning each juror must agree to either acquit or convict on each count. Only the first count, murder in the first degree, qualifies for the death penalty if convicted of murder in the first degree. The burden of proof on the state is the same in the guilt phase of a capital case as it is for every other criminal case. It is proof beyond a reasonable doubt. The instruction you will receive on reasonable doubt is identical to the one given in all other criminal cases. The burden on the state is not higher because of the potential penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty or not guilty, or guilty of a lesser included offense. And we expect you, as jurors, to carefully consider the facts before you reach a decision. The fact that a defendant may face a death penalty is to play no part at that stage of the proceedings. If and only if a jury returns a verdict of murder in the first degree, the jury will then reconvene for the purposes of rendering a verdict as to which sentence, death or life imprisonment, without the possibility of parole, should be returned. That is the penalty phase. If that happens, a special set of rules and instructions come into play. I'm going to give you an overview of the penalty phase right now. There are detailed instructions that are given to you if that should happen. Because the death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty. So they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The prosecutor will rely on something called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt. They are limited in number by statute, and they are the reasons, the legal reasons they believe that the death penalty is the appropriate sentence. The defendant relies on something called mitigating circumstances or mitigators. Mitigating circumstances do not need to be proven beyond a reasonable doubt. They only need to be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute, and they may include matters relevant to the defendant's background or character and circumstances surrounding the offense. They will be offered as a basis for a verdict of a sentence of life in prison without possibility of parole. Life in prison without parole in Florida means exactly that. The defendant will die in prison. We do not have parole in this state. Before you may vote the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. Once all the evidence is presented to you, you will retire to the jury room to undergo with detailed instructions to undergo the process of weighing aggravating factors and mitigating circumstances to determine the proper punishment. This is not a mechanical or mathematical process. In other words, you're not back there to add up how many aggravators were proved and how many mitigators were proved. It's not how you do this. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, that verdict must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Again, this is just intended to give you a broad outline of the penalty phase, just in case you end up in a penalty phase as a juror here. Let me also say this. The fact that I'm talking about the death penalty is not to be taken by you as any indication, one way or another, as to whether or not this is a case that justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility, and we need to be sure that you can fulfill your duty as jurors should you be in a penalty phase. We're going to be asking you some questions, as I said, individually. I'm going to tell you what some of the questions are so that you can think about them while you're in the jury room, because some of these are not questions that you are normally asked in your life. So you're going to be asked if you have any religious or moral objections to the death penalty. You're going to be asked whether you're someone who believes that there are certain types of cases where the death penalty should be automatic, or whether you believe that in every first-degree murder case, the death penalty should be automatic. In the state of Florida, there is no automatic death penalty for any case, including death penalty, or including first-degree murder cases. We may ask you, what your position is on the death penalty, how you feel about the death penalty. Can you weigh the aggravators and mitigators, as I described, and vote for either life or death? And you may also be asked if you're so opposed to the death penalty for whatever reason that you could not consider it as a penalty under any circumstance. Many people have very strong feelings about the death penalty one way or another. The fact that you have such feelings does not disqualify you to serve as a juror, as long as you can put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of the state in delivering your verdict. Changing gears slightly, Mr. Loyd has raised the defense of not guilty by reason of insanity in this case. This is the one time the burden is on the defense in the guilt phase of a case. It's their job to prove by clear and convincing evidence that he was insane. I'm going to read you a small portion of the insanity instruction that's given to jurors. A person is considered to be insane when he had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. The instruction is longer than that, but that's all you need to know for today's purposes. We are going to be asking you about your feelings about that type of defense, and whether, if the evidence proved to you that he was not guilty by reason of insanity, you could vote not guilty in this case. And lastly, I'm going to read you a statement of facts about the case. This is a small blurb on this. On the morning of January 9, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. This last portion I just read to you about Sade Dixon and her unborn child and the conviction and sentence cannot be used by you in any way as a basis for finding Mr. Loyd guilty in this case. That evidence is being offered. It's a completely separate case. The evidence is being offered for a different reason that you will be instructed on. And so we'll be asking you about your ability to put that aside during the guilt phase of this case. All right. Now, by a show of paddles only, how many of you, prior to being called here for jury duty, have heard about this case? Just raise your paddles, please. Juror in seat 57, 58, 59, 1, 2, 4. You can put your paddles down once I call your number. 9, 10, and 12. So 57, 58, 59, 1, 2, 4, 9, 10, 12. Anybody I missed? All right. Those of you who have heard about the case, do you have an opinion about Mr. Loyd's guilt in this case based on what you've heard? If you do, raise your paddles. Juror number 2, juror number 9, juror number 12. Did I miss anybody? No. All right. Who? 58? Oh, 58. Sorry, sir. All right. So I've got 58, 2, 9, and 12. Correct? All right. Juror number 58, if you'll remain in the courtroom with us, the rest of you will retire to the jury room. There's coffee in there. We'll be back with you in just as soon as we can. Thank you. You're juror number 734, right? Yes. Okay.
Seated. Cool.
I got to wait till they're out of the court. Well, I guess I can start by telling you this. Number one, can you hear me with the mask on?
Yes.
Can you hear me clearly, or do you need me to take it off?
I hear you clearly.
Okay. You have your microphone, right?
Yes.
Okay. There aren't any right or wrong answers to the questions we're going to be asking you. There's just what you actually believe. So just be honest in answering the questions and you'll be fine, okay? So what have you heard about this case?
Just what's been on the news. Pretty much all the charges you mentioned, and then just conversations about back and forth about, what happened and whatnot.
You were talking to other folks?
Yes.
Family, friends?
Yes.
Coworkers?
Yes.
So how much news coverage did you watch?
Not sure, just basically whatever is on the news, like since that time and now.
Do you watch the local news regularly?
Yes.
So since this occurred, have you watched this on the news?
Yes.
Did you watch any of the first trial?
Some of it.
Some?
Yeah.
Okay. So you followed it fairly closely. Is that
I'd say
fair?
I saw some of it in passing.
Okay. You said you'd formed an opinion as to Mr. Loyd's guilt based on what you'd seen. Can you tell me what that opinion is, please?
I would say, I guess, opinion of guilt.
Okay. So jurors have to be able to presume that Mr. Loyd is innocent until and if he's proven guilty. Do you believe that you could make that presumption, or would you start the trial thinking he's guilty?
Sorry, I didn't hear the last part, second half.
I'm sorry, or would you start the trial thinking he's guilty?
I feel like Yeah, it would be difficult for me to not.
To put aside your feelings about
Yes.
him being guilty?
Yes.
All right. State?
State moves.
Defense? All right. Thank you, sir. I don't think this is the case for you because of that. We appreciate your willingness to serve and your being here today. You are free to go. Thank you. You see the juror in seat number 2, please? This is panel 4.
Here?
All right, ma'am. Good morning.
Morning.
You're juror 614, is that correct?
Yes, ma'am.
All right. There aren't any right or wrong answers, okay? We just need you to tell us the truth. As long as you're honest, you're fine. We're not looking for a particular answer from you. You indicated that you'd seen or heard something about this case, is that correct?
Yes, ma'am.
Can you tell me what you've seen or heard?
I saw when it was actually happening on the news around here about his girlfriend at the time and the baby, and then the officer that was shot as well at Walmart.
All right, so you watched it back when it first occurred, correct?
Yes, ma'am.
Talk about it with friends, family, coworkers?
Yeah.
Okay. Subsequent to that, did you watch anything on the news, see anything on the news?
I did not.
Did you read anything about the case, either in the paper, Facebook, anything like that?
I have not.
Have you talked to anybody about it?
Yes.
Okay. What brought up the conversation, if anything?
A couple of my coworkers just enjoy like crime shows and stuff, so they talk about it at work.
Okay. It's not that uncommon. You indicated you'd formed an opinion as to whether or not Mr. Loyd is guilty based on that.
Mm-hmm.
What is your opinion, ma'am?
I believe he's guilty.
Jurors are required to begin trials presuming Mr. Loyd to be innocent. Some folks can do it, some can't. Can you presume him to be innocent, or are you going to start the trial thinking he's guilty?
I'd probably start the trial thinking he's guilty.
All right, thank you. State?
State moves.
Any objections? All right, not the case for you, but thank you for your willingness to serve. You're free to go, ma'am. Thank you.
Thank you.
Juror in seat number 9, again, panel 4. She can just sit in the second chair coming in.
I got it.
There you go. Good morning.
Good morning.
Can you hear me?
Yes, ma'am.
All right. We just have a few questions for you. There aren't any right or wrong answers to these questions. There's just what you actually think or believe. So just be honest with us, okay?
Yes, ma'am.
You indicated that, let me verify, you're juror 667, correct?
Correct.
All right. You indicated that you'd heard something about this case. Can you tell me what you've heard, please?
Well, I've been following it from the beginning,
Okay.
and it's really, I don't agree with, everything that, I believe that it's a guilty thing.
You believe he's guilty?
Yes.
Do you believe that you could put that aside and listen to the case with an open mind and presume him to be innocent?
No, not from the very beginning.
All right, thank you, ma'am. State.
State moves.
Any objections? All right, thank you, ma'am. We appreciate your honesty. You're free to go. This is not the case for you.
Thank you.
Thank you. Have a good day.
You too. Oops, sorry.
Juror in seat number 12. Good morning.
Morning.
Can you hear me?
Yeah.
Okay. You're juror number 780, right?
Yes, ma'am.
All right. Ma'am, we're going to be asking you some questions. No right or wrong answers, just what you actually think or believe.
Okay.
Just be honest and you'll be fine, okay? You indicated that you had heard something about this case, is that correct?
Yeah, on the news.
Can you tell me what you've heard? You're very soft-spoken. Can you speak up a little bit?
It's just what happened, basically.
All right. How many news stories have you seen about it?
Like 3 or 4.
All right. And when did you first see a story about it? Approximately.
Around the time it happened, 2017.
Okay. And did you keep up with it after that?
Not until he's gone to trial again now. I know that.
Going to trial for this case or the other case?
This case.
Did you follow the other case?
Yeah.
Okay. Did you watch any of the other trial?
No.
Did you talk about this with friends and family and coworkers?
My grandma and my dad.
Okay. Were they following it too?
Yeah.
So you formed an opinion as to whether he's guilty or not?
Kind of, yeah.
It's okay if you have. Like I
Yeah.
said, all we're looking for is the truth. All right, so what is your opinion?
Guilty.
Jurors are required to be able to assume that Mr. Loyd is innocent until and if the state proves him guilty. Can you do that, or would you start the trial believing him to be guilty?
I would probably start the trial believing that he's guilty.
All right, thank you, ma'am. State. Any objection? All right, thank you, ma'am. You're free to go.
Thank you.
All right. Returning, did you have a successful? All right, returning to panel number 3, I need the juror in seat 57, please. Good morning.
Good morning.
How are you, ma'am?
I'm doing well, thank you for asking.
Can you hear me clearly with the mask on?
Yes.
Okay, great. We just have a few questions for you this morning. I'm going to start, then the lawyers will have a chance to ask you questions. As much as you can, try to relax. I know this is a strange situation, but we're not looking for a particular answer. There really is no right or wrong answers to these questions. There's just what you think and feel. So just be honest with us, okay?
Okay.
You indicated that you'd heard something about this case. What have you heard, ma'am?
It occurred, I know it occurred in 2019, because that's when my sister passed. I don't remember so much of the details. I don't watch really so much news. I have the internet, but I use just streaming channels, Hulu, Netflix, stuff like that. So I wasn't even aware of what you just disclosed
About Ms. Dixon?
Yes. So yeah. So I knew about it because it was when it around happened, but I don't know
When you
all
say-
of the details that surrounded it, if
So-
that makes sense.
When you say you knew about it, you knew about the shooting involving Lieutenant Clayton?
No, I just remember that there was a man who shot his pregnant wife or girlfriend, and then law enforcement officer was shot.
Okay.
But if you asked me the name, I couldn't tell you what name it was.
All right. So based on anything that you heard or anything that, did you ever talk about it with anybody that you can remember?
Not so much.
Okay. So based on anything that you've heard or any conversation you may have had, have you formed an opinion as to whether or not Mr. Loyd is guilty?
No, I have not.
All right. Jurors are required to presume him to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. Do you believe that you can presume Mr. Loyd to be innocent?
Yes.
Okay. So, moving on to the death penalty. Do you have any religious or moral objections to the death penalty?
I do not.
Okay. Are you someone that believes that if you're convicted of first-degree premeditated murder, death should be the automatic sentence?
I don't believe it should be the automatic decision. I do feel that's the most restrictive. So it would have to be something, in my opinion, just very egregious that most of society would agree of the crime to consider the death penalty.
Okay. You understand that in Florida, we don't have an automatic death penalty for anything, all right? Is there any case, when I say case, I mean type of case, where you would automatically vote for death?
I don't believe automatically.
All right. And this case involves a law enforcement officer. Is there anything about that that would cause you to automatically vote for death?
No.
All right. You heard me describe the process. You listened to all the evidence, then you go back, weigh the aggravators, mitigators. If you went through that whole process, you'd weighed the aggravators, you'd weighed the mitigators, you've got all the evidence, all the facts, and it's time to make a decision, for you personally to make a decision, because it's an individual decision. If you thought that life without parole was the appropriate sentence, would you be able to vote for that?
Yes, if I thought that was the appropriate sentence based on what was presented as evidence.
Right. And conversely, if you thought that death was the appropriate sentence, would you be able to vote for that?
Yes.
Right. You heard me explain that Mr. Loyd has raised the defense of insanity. Defense has to prove it by clear and convincing evidence. This is guilt phase of the trial. You're trying to decide whether he's guilty or not. If at the end of that trial, you've heard all the evidence, heard everything, you believe, you're convinced that he was insane at the time of the offense, would you be able to vote not guilty?
If they were able to prove that particular defense, that he was insane at the time of murder, yes.
Okay. And then lastly, as I told you, he's been previously convicted of the murder of Ms. Dixon and her unborn child and sentenced to life. You can't use that to decide whether or not he's guilty of this case. You understand that?
Correct.
Do you feel that you would have any problems putting that out of your mind during the guilt phase of these proceedings?
No.
All right, thank you, ma'am. I don't have any other questions for you, but the attorneys probably will. Mr.
Okay.
Williams, you may inquire.
Yes, Your Honor. Good morning.
Good morning.
So you are the grand prize winner because you filled out a little sheet of information for us when you first came in.
Yes.
And I go through that and I look for certain things and I circled like every one of yours.
Okay.
So I'm going to ask you some questions about that before we go any further about the death penalty. When you listed your current occupation, you listed clinician with OPD. Is that the Orlando Police Department?
Correct.
Okay. How long have you Well, do you work in-house for them, or is it contracted? Can you tell me the nature of your job as it relates to the police department?
My current role is the licensed clinician for the community response team. That started in February 28th. So basically what I do, I am a mental health first responder for mental health illness and substance abuse. We are dispatched by 911, and I assess for crisis whether the individual needs to be Baker Act or Marchman Act. If that is the case, then we request transportation by Orlando Police Department to transport to Aspire. So I am employed by Aspire, but the pilot program is funded by the Orlando Police Department.
I was going to say, you said you started in February of this year?
February 28th.
February 28th?
Correct.
Can I see the attorneys at the bench for one moment, please? Excuse me, ma'am, we'll be right with you.
Yes, Your Honor.
Sorry, ma'am. Go ahead, Mr. Williams.
We always wait for that nice young lady to sit down so she can start typing. Okay, so that's a new program, but if I understand what you're telling me, you go out and assist law enforcement on cases where there might be a individual suffering a mental illness and help evaluate that?
Correct. I am first on the scene, and if law enforcement is needed, per statute, they have to transport to Aspire.
So do you arrive before the police?
For the most part, correct, yes.
Okay.
They send us on nonviolent mental health calls.
Yes, ma'am. Whereas in the past, law enforcement would have gone out without you. Is that your understanding? Okay.
Correct.
Are you a licensed clinician in some way? Do you have a license?
Yes, I am a licensed mental health therapist.
Okay. And how long have you held that license?
I've been licensed for a year, but working in the mental health field for about 20 years since I graduated.
Did you have your own practice prior to that?
I have a business, not my own practice.
Okay, you have a business.
I have a business on the side, yes,
okay.
I do.
You were previously a juror?
I have served.
Okay, how many times?
Once.
Here in Orange County?
Yes.
How long ago?
I have to say over 7 years.
Over 7 years?
I would have, yeah.
Okay. That's it. You look like you're struggling with your memory, but that's a pretty specific number, so good for you. Was it criminal or civil?
It was criminal.
And do you remember the nature of the charge?
That particular was a convicted felon with ammunition.
Ammunition, right? Did you guys actually have an opportunity to deliberate on the charge?
Yes, we did.
Right. Were you the foreperson?
No, I was not.
Don't tell me what the verdict was, but did you reach a verdict?
Yes, we did.
What were your thoughts on that experience, on being a juror?
Throughout the entire process?
Yes, ma'am. Good, bad, anything you want to tell me?
It went as I would have expected. Prosecution, their case, the defense put on their case, and we deliberated. It was a half a day trial. Everyone was able to review the evidence, talk it through, and we were pretty much able to reach the same decision in a quick amount of time. So.
Okay. Good experience? Bad experience?
Yeah, it was a good experience.
Good experience. Okay. You also answered yes to the question, have you or a member of your family been accused, a complainant, or a witness in a criminal case?
Yes.
Can you tell me who you were referring to?
My sister, the one that passed in 2019, was a Orange County sheriff detective. My brother is actually incarcerated. He actually stole the weapon from my sister, the deputy sheriff, and he was convicted.
Is he incarcerated now?
He is.
Okay. And you said your sister was a deputy, and I'm sorry to hear about her passing.
Thank you.
Obviously, the court has already told you that we're here on the allegation the law enforcement officer was murdered, and your sister, who it sounds like you were close with, was a law enforcement officer.
Yes.
Would you be able to set aside any feelings you have about law enforcement and render a fair and impartial verdict on this case where the cop?
Yes.
Right? Anything about your brother's experience with law enforcement that you think would make it hard for you to believe or disbelieve law enforcement officers?
No, I am aware of what he did. So.
Okay.
He did the crime, so he had to face the time. So,
Yes, ma'am. Did you feel he was treated fairly? You kind of suggested that he was, but.
Yes.
Okay. You said that you had no religious or moral objections to the death penalty, but indicated that, in your opinion, just your opinion, it would need to be an egregious situation.
Correct.
Because it's the ultimate punishment, I'm assuming. Okay. But I think I also heard you tell the court that you believe that if you thought it was warranted under the laws as described to you by the judge, that you could personally, not hypothetically, but in a very real situation, vote to impose a sentence of death if that's the way you felt.
Yes.
All right. Do you think you would struggle at all with an insanity defense, given your, what I'm assuming is a significant knowledge base?
Do you think I would struggle in reaching that, believing the defense?
Let me ask a better question.
Okay.
How do you think your background would shape the way you approach that defense and listening to the evidence, if at all? There
are circumstances where insanity is a defense. So honestly, I would have to look at all of the evidence and determine at that particular time of the crime, was he innocent? I mean, I'm sorry, not innocent, but if he was insane or not. And like the judge said, that's going to come from the defense. So that's going to depend on the evidence that they portray as the for the insanity defense, honestly.
Are you familiar with the test for, or the elements of insanity through your career?
Actually, no, not so much.
Okay. The reason I ask is you said at the time, and actually that is the relevant question under the law is, was the person insane at the time of the crime, not if they ever have been in the past. So, but what I heard you say, I believe, is that you recognize that it is possible for a person to have a mental illness and for that mental illness to affect them in a way where they would not be criminally responsible.
That is possible.
If it's possible, well, have you ever encountered anyone in your career or personal life that you concluded was feigning mental illness for a separate purpose?
Yes.
So am I safe in assuming that you recognize that both of those things can happen?
Yes.
Which is why I'm assuming that that's why you'd want to review the evidence.
Correct.
Right. You've already told us a lot about your life, and I appreciate your openness. Is there anything that we haven't discussed that you think is significant, given the specific nature of what we're trying to do here, and that we're trying to find fair people, that you think we should know about you?
I guess for me, with my background, with experience with law enforcement, I honestly believe confidentiality. I believe, that there are cases that people are, sentenced, are declared insanity. Obviously, that is, considered evidence. I am a very fair person. I have to look at, even in my line of work with, making critical decisions. I have to be fair. I cannot let my own personal bias, affect any part of my personal job. And if I was chosen as a juror, it would be the exact same way.
Okay. I do have one more question, if it's okay, Judge. One more question. If on a scale of 1 to 10, if number 1 is you can't wait to get out of here and go do anything but this, and number 10 is you're very excited about the prospect of being a potential juror, where would you rate yourself on your desire to be a part of this process in this particular case?
Without taking the sequester part out.
No, you gotta include that.
I would say 7. I would say 7.
And why is that?
I do feel that because I don't know so much of the case, because I don't do a lot of social media, that I can be fair and rational. I have the time to do so. My job allows that. I don't have any other interference going on. I'm not distracted by anything else. So contemplating someone's, life is something to be taken seriously. And I just feel at this particular time in my life that I do have that fair and objective persona to do that.
Okay. Thank you so much, ma'am. Thank you, Your Honor.
Thank you, Mr. Williams. You doing it? Okay. All right.
Good morning.
Good morning.
My name is Allison Miller.
Are you mic'd up?
I am.
Okay. Go ahead.
I chalk with my hands, so there's a good chance I'm going to knock it off, but I will try.
Good.
I just want to follow up with a couple questions about your employment with the Orlando Police Department, if that's okay. Obviously, it's been made clear that this case involves the death of Lieutenant Clayton. And Mr. Loyd has pled not guilty by reason of insanity. And so the question is, you are a civilian who works with law enforcement, correct?
Correct.
But knowing that you work with law enforcement, would you be able to render a verdict of not guilty if the evidence supported it, knowing you got to go back to work with a bunch of police officers?
Yes.
Okay. The way you said that doesn't seem to indicate you have any hesitation about that.
No, I don't.
Okay. And the judge asked you at the very beginning of this if you would automatically impose a sentence of death once you, if you were selected as a juror, made a decision that the defendant was guilty of first-degree murder. Do you remember that?
Yes.
And so I just want to ask you a few follow-up questions about your feelings on the possible penalties for first-degree murder, which in Florida are only life without the possibility of parole or the death penalty, okay?
Yes.
And so I know we're on the same page, and I'm sure you probably know this. I just want to define first-degree murder a little bit further.
Okay.
It is the intentional, premeditated killing of an innocent victim. That defendant thought about it, meant to do it, and did it.
Yes.
With me?
Yes.
And if a defendant was convicted of first-degree murder, a jury would have unanimously rejected any defenses available to that person, okay?
Okay.
Those defenses might have included things like self-defense, defense of others, duress, somebody had a gun to his head and made him do it, heat of passion, did he walk in and catch his wife in bed with another man? But none of those things would have applied if the jury convicted that defendant of first-degree intentional premeditated murder.
Correct.
Similarly, if a jury finds a defendant guilty of first-degree murder, that jury would have excluded or rejected the defense of not guilty by reason of insanity.
Correct.
The defendant would have also not been intellectually disabled, what we formerly referred to as mental retardation. Along the same lines, that defendant wouldn't have been so drunk or so high that he didn't know what he was doing. Knew what he was doing, knew right from wrong, chose wrong. And lastly, it wasn't a mistake, it wasn't an accident, and the police definitely got the right guy. With me? So my question is, what are your feelings about the death penalty in that circumstance being the only appropriate penalty for that guilty murderer?
Objection.
May I respond, or would you prefer it sidebar? Yeah. let's back up.
Okay.
Did everything I ask or state make sense? Tell me where I was confusing.
I was trying to understand exactly what you're asking about the sentencing phase.
Okay. And so you understand for us to get to a sentencing phase.
Correct.
Or a penalty phase, the defendant has to be first found guilty of the intentional premeditated killing of an innocent victim.
Correct.
And so I wanted to make sure we understood that to even get to that penalty phase, if a jury finds a defendant guilty of first-degree murder, all of those defenses, excuses, justifications would have been eliminated by that jury in getting here.
Correct.
And so, do you understand what first-degree murder is?
Yes.
Okay.
So premeditated.
Yes, ma'am. The intentional premeditated killing of an innocent victim without legal justification or defense.
Correct.
So knowing that, does the death penalty become the automatic penalty, understanding the definition of first-degree murder?
No.
Why not?
Because there could be mitigating circumstances, and there, like the judge said, there is the option of life without parole. So I don't see myself going directly straight for the death penalty, if that makes sense.
It does. And I think a lot of people feel the same way. I just want to make sure I understand you. When you talk about mitigating circumstances, what comes to mind when you mention that?
Sustained. Rephrase.
Would life in prison be sufficient enough penalty for the guilty murderer of that innocent victim that we discussed?
I cannot, without all the evidence, I can't really say 100% for sure.
Okay.
If that makes sense as well.
It does make sense. And, it's tough because we're asking you to offer or share your feelings in kind of a vacuum. But this is my only opportunity to
do
speak
so.
to you, right? We may not even get to that second part of the trial.
Exactly.
Right? But the law requires that I have this conversation about possible penalty now. So please don't hold that against Mr. Loyd. When we talk about mitigating circumstances, if you were living on an island and you were the queen and you got to make all of the rules, are there things that you believe you would need to know or you should know to make a decision about whether someone lives or dies?
Yes.
And like what?
Background, and background just meaning in terms of perhaps trauma, prior criminal history, the person's character, significant things, medical issues, if they have substance abuse issues, if there's any type of neurological issues, traumatic brain. So, a lot of those things I would have to kind of, take into account.
And I just want to make sure we're on the same page. When you talk about background, you're talking about that defendant's background and all of those things, correct?
Correct.
Let me ask, and there's a lot to unpack there, and I want to do that. Before I go there, does the fact that a victim is a law enforcement officer make death the automatic penalty for you?
No.
Okay. Couple things you mentioned about the defendant's background, like prior criminal history. Tell me how that plays into your decision.
I would say the history, not necessarily the particular crimes or how if they were guilty or not guilty, but just that history of it. Is it a repeating factor? Did it start, in childhood, let its way up into adolescence? Is it a pattern, if that makes sense?
It does. And tell me, though, how that affects your decision about whether life or death is the appropriate penalty. If somebody has that pattern of criminal history, is that...
Well, that wouldn't be the only...
Hold on. Sustain. Move on.
That would be one factor you would consider in the totality of circumstances?
Correct, not the only one.
If you heard someone had a prior conviction for murder, would death become the automatic penalty for this murder?
Sustained.
Can we
Move
approach on that, Your Honor?
Nope. Sustained. Oh, I'm sorry. You can ask, I'm reversing myself, you can ask that particular question.
Would you mind repeating what the exact question was?
Ma'am, the question is this: if you heard someone had a prior conviction for murder, would death become an automatic penalty for this murder?
No.
Thank you, ma'am.
Thanks.
When we talk about the defendant's background, if a defendant has been exposed to the effects of racism throughout the course of his life, is that something that you would give meaningful consideration to?
Racism?
Yes, ma'am. The effects of racism.
In terms of the death penalty?
Right. So when deciding whether life or death is the appropriate penalty, obviously Mr. Loyd is African American.
Correct.
If you heard evidence about a defendant experiencing the effects of racism, and let me clear something up too before I ask that. Mitigation can be absolutely anything to anyone.
Okay.
Right? Aggravation is limited to one of 16 things by law in Florida.
Okay.
Mitigating circumstances can be anything to any juror and can include your own personal sense of mercy.
Objection.
Sustained.
Mitigation can be
Mercy,
anything.
yeah. And let me clarify. Mercy is not mitigation, ma'am, all right? Mitigation is anything that relates to the character of the defendant's background, or the circumstances of the offense. You may proceed.
And so relating to the defendant's background, understanding that mitigation is a much more voluminous idea than aggravation, it could include that defendant experiencing the effects of racism. And so I'm asking you if that's something you think you could give consideration to when deciding whether life or death is the appropriate penalty.
I try to see how to answer the question. If it's for insanity defense, I'm not sure how racism would play into that.
Let me clear that up.
Okay.
So insanity is something, if you're selected to be a juror, that you're going to decide in the first part of the trial.
Okay.
So if the defendant is able to establish that he was insane at the time of the crime, he would be not guilty.
Correct.
So we wouldn't even get to that second part when we're deciding sentence.
Correct.
With me? Mitigation is if we're in that second part, why any juror might choose life and not choose death. Does that make sense?
Yes.
And so mitigation is not an excuse or justification, but is a reason why a juror might say, I think life is the appropriate penalty in this case. With me?
Yes.
And that could include the defendant experiencing the effects of racism. You seem hesitant. Tell me what you're thinking, please.
Okay, so I guess what I'm thinking, I don't see racism playing a part in that factor.
Okay. Well, let me ask you, you mentioned trauma being something you would want to know about.
Correct.
Do you think the effects of racism could be traumatic to a particular person?
Objection.
Sustained. Move on.
This has been mentioned several times, but death is never required. Not in any case. Not in this case, not in the worst imaginable case you could think of. With me?
Correct.
And we've talked a little bit about this. Mitigation, we've thrown that around a lot, is why any juror would choose life or not choose death. And it does not have to be unanimous. Each juror could say, I find this to be mitigating, and another juror could totally disagree. Are you okay with that?
Correct, yes.
And the law gives great power to each individual juror in Florida, right? If one juror decides that life should be the penalty, then life will be the penalty. Are you okay with that?
Yes.
In order for a just verdict to be returned in this courtroom, all 12 jurors' individual moral assessments have to be reflected on the verdict form. So there's one signature from the foreperson, but that foreperson's really just signing off saying, this verdict reflects all 12 people's individual moral assessment.
Yes.
And it would be a miscarriage of justice if not all 12 people's individual moral assessments were reflected on that verdict form.
Correct.
It's your duty, if you're selected, to make sure your individual moral assessment is heard in this courtroom.
Correct.
Right?
Yes.
We're talking about whether somebody lives or dies.
Correct.
And you could do that.
Yes.
Sometimes these things can get contentious, right? You would imagine 12 people may not all agree on something like whether somebody lives or dies.
Absolutely.
And that the law encourages you to deliberate, which means to carefully consider. But if you have reached a verdict for life and it's not being respected, you can say, we're done here. Go ahead and write the verdict down, get the bailiff, get the judge, I've reached a verdict.
Yes.
You could do that.
Yes.
May I have just a moment, Your Honor?
Yes, ma'am.
I have nothing further, thank you.
All right, thank you. Either side wish to approach?
No, ma'am.
State?
No, Your Honor, we do not.
All
I'm
right.
sorry.
Thank you. All right, ma'am, we're going to send you through to the final round of questioning, and that is the final round. We will be choosing the jury that day.
Okay.
And that means that you are now no longer a green dot, you're now a purple dot.
Purple.
You're purple. We're going to give you a new dot.
Okay.
The colors are just for when you phone to the jury room, they call jurors by colors because there's too many of you to call the numbers, all right?
Okay.
So starting Friday after 5, call Friday, call Monday, listen for purple dots returned to the courthouse on this date at this time.
Okay.
Okay? Because it's final jury selection and we are picking a jury that day, you need to have packed in case you get picked. You'll be sequestered that day. Leave your suitcase in your car. If you get picked, we'll make arrangements for it. If not, you just go home and unpack.
Okay.
All right? Any questions?
No.
All right. Thank you so much. Have a good day.
You too, Your Honor.
Thanks. Can I have the juror in seat 59, please? He's going to be our last juror before the lunch break. Good afternoon. I'm sorry, she's requesting a hearing aid? Can you hear me? No? Okay. Can you hear me now? Okay, can you answer out, you have to answer out loud. Can you hear me? Is that a yes?
Yeah.
Okay. How are you this morning, or actually this afternoon? Do you speak English, ma'am?
No.
Okay. Is your native language Spanish? Do you understand?
Español.
Do you understand what I'm saying? No? Un poquito?
Poquito.
Okay. State.
State moves, Your Honor.
Defense. All right. Does anybody object if I explain in Spanish to her that she's excused so she knows what I'm saying? All right. Ok. Yo lo voy a excusar del jurado. Que tenga buen día. Muchas gracias. Okay. All right. All right. That's it for now. I did send that is the end of panel 3. When we come back, I've asked panel 3 to return at 1:15. We'll start with panel 4. Lunch break. Court's in recess.
Your Honor, the cite to the case regarding the Colorado method hypothetical that was just discussed is OGMV State 3077.
Wait. Can't hear you. Hold on. And what the heck did I just do with my pen? All right, here's one. Go ahead.
The citation to the case dealing with the Colorado method hypothetical that defense counsel just tried to use is OJMV State, HOJAN 307 Southern 3rd 618, Florida Supreme Court 2020.
And which hypothetical? She used a couple of hypotheticals. Which one?
If, let's say he killed an innocent person, it wasn't self-defense, there's no intellectual disability.
Okay. All right, thank you. Anything else? All right, have a good.
You didn't have an opportunity to sidebar. I would object for sustaining the state protection of right to mercy. The case of Goodson, I don't know if we're asking for response, but I disagree with the state's assessment of what OJAN stands for. But as the court's ruling on not being able to suggest mercy is a mitigating circumstance. Goodson v. North Carolina, 428 U.S., specifically at 303. I'm sorry, can you repeat? I'm sorry. Oh, I don't know.
Yeah, you guys have to remember to turn your mics on.
Sorry. The case that stands for mercy as a mitigating circumstance is Woodson v. North Carolina, 428 U.S., specifically at 303. Quote, "The jury must always be given the option of extending mercy."
I did not say that they could not extend mercy. What the court's ruling was very clearly is mercy is not a mitigator. I did specifically tell the juror you can extend mercy. All right, I just wanted to clarify the record on that. All right, thank you, folks. Lunch, 1:15.
10's here, starting at 5. Yeah, 5. 10's here.
We're just missing 5? All right. Okay, we're back on the record on State versus Loyd. He's present with his attorneys. I failed to describe this morning. Mr. Loyd remains in custody. He's dressed in a button-down, sort of burgundy-colored shirt. He's got on dress pants. He is wearing jail shoes and shackles. His feet are underneath the table and cannot be seen by the jury. He's been dressed like that all day. Huh. All right, we're missing Juror 5, but I'm going to start without him because I can just skip that one and move on. All right. So next up, we have the juror in seat number 1, panel 4. From here on, it's panel 4, folks, for the rest of the day.
We can have a seat right here. You are, sir.
Good afternoon, sir. How are you?
I'm fine, thank you.
Did you have a good lunch?
I did, thank you.
All right. Since the last time you were here in court, have you heard anything, read anything, or has anybody tried to talk to you about this case?
No.
No? Okay. All right, we're going to be asking you some questions. I'm going to go first, then the attorneys have a chance to ask you the questions. We're not looking for a specific answer. You looking for your glasses? Yeah, there you go. We're not looking for any specific answer. There aren't any right or wrong answers to these questions. There's just what you honestly think or believe. Now, let me start with, do you know anything about this case? Have you heard anything other than what I've told you this morning?
I remember live here.
You are. It depends on where you hold the mic.
Oh, okay.
There you go.
I do remember some news coverage of it back when it occurred.
Okay.
Yeah. So normal news coverage, but I didn't do any deep dives into the facts of the case.
All right. Did you listen to a lot of it, a little bit of it?
I wouldn't say any, no more than any other normal news report.
All right. Do you remember a lot of it?
I remember the global nature of the two crimes. I'm going to talk the Dixon crime and the alleged crime that occurred at the Walmart. So because I know where those locations are, having been from the area, I was able to kind of timestamp that a little bit.
Okay. Did you form any opinion about whether or not Mr. Loyd is guilty based on what you heard?
No, I just knew that it involved a police officer, and it involved someone who was being sought after by the police.
So let me talk to you a little bit about the death penalty. Do you have any moral or religious objections to the death penalty?
No.
Are you someone that believes that certain types of cases, not people, but certain types of cases should, if convicted of first-degree premeditated murder, folks should be sentenced to death automatically?
Yes.
Okay, and what types of cases are those?
I've written some down.
Okay.
Number 1, mass murder. Number 2, murder of a child.
Okay.
Number 3, murder of a police officer or a teacher or other defenseless person. Number 4, rape and murder. Number 5, torture and murder.
Okay.
And number 6, repeat offenders and murder.
So let me focus on police officer. This is The allegation is first-degree murder of a police officer. So my question to you is, if Mr. Loyd was convicted of first-degree murder of a police officer, would you automatically vote for the death penalty?
No.
Okay. What would be different about this from the list that you just gave me, about this case?
Maybe the circumstances surrounding the action, maybe some of the impacts that other actors had on the crime.
Okay.
For better or for worse.
Okay.
And any other thing that may be a mitigating factor for me that would lighten my view of that.
All right. So you heard me describe the process of a penalty phase. There's
Correct.
states presented aggravators, defenses presented their mitigators. You're required to, with an open mind, weigh those. You can assign whatever weight you wish and you believe is correct to a mitigator or an aggravator, but you have to be able to at least listen and weigh them fairly. If at the end of that you felt that the evidence, the facts, the mitigators, the aggravators, all of it led you to believe that the appropriate sentence was life without the possibility of parole, would you be able to vote for that sentence?
Yes.
And same, if you felt that the appropriate sentence was death, would you be able to vote for that sentence?
Yes.
All right, let me move on to the insanity defense. I explained to you that Mr. Loyd has raised that defense, and this is in the guilt phase when you're trying to decide whether or not he's guilty of the crimes he's charged with. If the burden's on the defense, this is the only time it's on them to prove by clear and convincing. If they prove to you that he was insane at the time of the offense, would you be able to return a verdict of not guilty by reason of insanity?
Yes.
Okay. And lastly, as I indicated to you, he's already been convicted of the murder of Miss Dixon and her unborn child, and sentenced to life in prison. Those facts cannot be used in determining whether or not he's guilty. You'll have to put that out of your mind. Do you believe that you can do that?
I understand that I'm supposed to do that, but it's hard to unring the bell when you hear something. So I can't say with 100% certainty that that would not be a quiet voice in my head, that had also occurred.
When you were deciding whether or not this was, the charges, first-degree murder, attempted murder?
Correct. Okay. I see. It's hard for me not to formulate a pattern there.
Okay.
That a prior act, even though it's not supposed to be a consideration in a current trial, would not be something that would lean into my thinking a little bit.
All right.
State moves.
Any objections? All right, you're doing this one, Ms. Miller? Yes. You're okay. All right, sir. Based on that, I think this isn't the case for you. We appreciate your time and your willingness to serve, but you're excused.
Thank you.
Thank you. I'm sorry, he's juror number, let me not do this without my glasses.
386.
386, thank you.
Okay,
All right. All right, the juror in seat number 3, please. Okay, great. Juror number 5 has arrived.
Hello.
Hi, how are you?
I'm good. How are you?
I'm well, thank you. Welcome back. Did you have a good lunch?
Yeah, I did.
All right, since you were here last on Friday, has anybody talked to you? Have
No,
you
they
seen
have
any
not.
stories about the case, anything at all?
No, they have not.
All right. Had you previously heard anything about this case prior to coming here?
No, I have not.
All right. I noticed that you're a full-time student And I'm sorry, just for the record, you're juror number 914, correct?
Yes, I am.
Okay. I notice that you're a full-time student, okay? Is being here for, let's say you were picked for the jury and you're sequestered for 3 weeks, is that going to interfere with your studies?
I have some classes that I have to be at, but for now, no.
For now, no? Okay. Tell me about the classes you have to be at.
I have classes on Thursday that I have to attend at from 9 to 11, and then I have other classes that are online, but I have to be in the online class too, at a specific time.
If you're chosen as a juror in this case, you can't be at that Thursday class and you can't be on the online ones. And the only time you can be in class is after we've recessed for the day. And most days we run till 5:30 or 6.
Oh, okay.
So is that going to be a problem for you?
I will have to ask my professors about it.
Okay. Do you have any moral or religious objections to the death penalty?
I believe that the death penalty is justifiable.
You don't believe it's justifiable?
No, I do.
You do?
In certain cases, yes.
Okay. So, are you someone who's opposed to the death penalty in all cases?
Not, well, yes and no.
Yes and no? What does that mean?
So, yes, if it's a certain case that needs to be the death penalty, but in other cases, no.
Okay. Let me take this off because you heard me describe the process that jurors go through.
Yes.
If we reach a penalty phase in this case. You know, you have to listen to the state's evidence of the aggravators, the reasons they believe death is appropriate. The defense has mitigators, the reasons they believe life without parole should be your vote. Then you go back into the jury room with instructions from me on the law. You all can discuss it as much or as little as you like, but you are required to weigh those aggravators and mitigators with an open mind. Think about everything you've heard, and in the end, you have to vote. You yourself have to take an independent vote on whether or not you believe life or death is the appropriate sentence. If after going through that process and weighing everything and taking as much time as you need to make a decision, you decided that life was the appropriate sentence in this case, could you vote for that?
Yes.
And if, on the other hand, you decided that death was the appropriate sentence in this case, could you vote for that?
It would depend.
On what?
On the evidence.
Okay, well, it does depend on that, all right? The aggravators, the state has to prove at least one aggravator beyond a reasonable doubt before you can even consider death, all right? You're not required ever to vote for death. Even if you think it's the appropriate sentence, you can vote for life just because that's what you want to do. That's what you think should be done, all right? But my point is this: if the evidence and everything that you've heard in court led you to believe that death was the appropriate sentence, you've listened to everything, you have all the evidence, and based on that and the aggravators and the mitigators, you believe death is the appropriate sentence, could you vote to impose a death sentence?
Yes, I could.
All right. The insanity defense, as I explained, Mr. Loyd has raised that defense. That would occur in the guilt phase, not the penalty phase. In the guilt phase of the trial, when you're trying to decide whether he's guilty or not. The burden is on the defense. It's the only time it is in the guilt phase. They have to prove it by clear and convincing evidence. But assume hypothetically at the end of the trial, of the guilt phase, you believe they had proved it and that Mr. Loyd was insane at the time of the offense. Would you return a verdict of not guilty?
Yes, I would.
All right. And then lastly, as I told you, he's been previously convicted of the murder of Miss Dixon, Sade Dixon, and her unborn child. She was pregnant at the time. And he was sentenced to life in prison without the possibility of parole. Those facts cannot be used by you to decide whether he's guilty or not of these charges. Do you understand that?
Yes, I do.
Can you follow that instruction?
Yes, I can.
You can put it out of your mind.
Yes.
All right. Thank you, ma'am. I'm going to turn this over to the attorneys. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon. What is it that you are studying in school?
I'm studying to become a teacher.
Okay, do you know what subject or even age group you want to teach?
First elementary.
Okay, you want to teach elementary school. And I noticed on your, the questions you filled out, the answers for jury selection, that you've only lived in Orange County for about a year.
Yes.
May I ask where you came from? What other place you came from?
I came from West Palm Beach, Florida.
Okay. Is that where you grew up?
Yes, yes.
Did you come for school?
Yes, I came here for school.
Okay. So, are you in your first or second year of college?
I'm in my second year.
Second year. So let's just say that you went to class next week and you were not selected as a juror. And the professor told all of the students, you have to write a paper, a page in length only, and you have to take a position on whether or not the state of Florida should have the death penalty, either pro or con. You have to be able to defend your position with reasons. You with me?
Yes.
You can't pick both sides and do both in the same paper. You have to choose one, and everybody will choose something different. Which side would you select to defend and why?
Con, because I believe the death penalty is, like, not good. It's not good.
Okay. And so you would pick con. What would your explanation or reasons be for why the death penalty is not good?
The death penalty, I believe, does not do good for the human, like, justice system. And in some cases, the death penalty is justifiable, but in most cases, no.
And I heard you use that phrase with Judge Marquez, so I apologize, I wasn't looking at you the whole time, I'm trying to take notes. Justifiable? What circumstances do you have in your mind when you say that in some cases it's justifiable?
In some cases, if the person who did the wrong thing had a lot of evidence built up to them that I believe was not good, then yes, the death penalty would be good for them.
So what do you mean specifically, okay, as specifically as you can, when you say that the death penalty is not good for society? What aspects of it and its impact on society are you referring to?
The moral side.
The moral side, okay. And when you say the moral side, flesh that out for me, just like you would if you were writing that paper and the professor's like, no, you have to provide justification for your answer. That
Like
kind of.
morals would be in yourself, like your beliefs. So religion in that sense.
Okay. Does it impact your moral or religious beliefs?
Yes.
All right. Tell me about that. Let's start with, because those are two different things. Let's start with the religious belief. What religious belief do you personally hold in regards to the death penalty?
Well, I'm a Buddhist, if that is good, and I believe that death penalty is not good in my beliefs.
It's not what? I'm sorry.
It's not good for my beliefs.
Okay. And forgive me, but I don't really know what Buddhists believe about the death penalty. What aspect of your religion or faith, what does it say about the death penalty?
Well, in my religion, it says that the death penalty should be, like, justifiable, but in my sense, like, I believe that the death penalty is not good.
Not good. Okay. From a moral standpoint, how are you thinking about the death penalty as that it's not good morally?
Say that question again, sorry.
Sure. So I asked you first about the religious standpoint, and then I said that moral is different than religious. So how is your moral belief framed about the death penalty?
I believe that in my morals that the death penalty is not good, but it is justifiable.
Okay. So some people in some religions say a version of this. We as humans don't have the right to decide another human dies. Have you heard that phrase?
Yes, I have.
Do you agree with that phrase?
It depends.
It depends. What I'm hearing you say is that most of the time you agree with that phrase. Is that a yes?
Yes.
Okay.
Yes, sorry.
That's okay. She has to take it down. I didn't mean to get on you. But I also hear you saying that, and I'm paraphrasing. If I'm wrong, tell me. If it's really bad, then you could do it.
Yes.
Okay. Is that an accurate summary of where you are on this?
Yes, I am. Yes.
Okay. So what does really bad mean?
Really bad is if they killed a lot of people, they did like bad stuff. They are serial killer, like a shooter.
So serial killers, genocide, things like that.
Yes.
Is that a yes?
Yes. Okay. Sorry.
But do I hear you saying that anything short of that enters that moral and religious problem that you have?
Yes.
Okay. Could I have a moment, Judge?
You may.
Those are the only questions I have. Thank you very much, ma'am.
Thank you.
Thank you, Mr. Williams. Ms. Miller, any questions?
Good afternoon.
Good afternoon. Hello.
Hi. I just want to clear up a couple things. The law in Florida requires for a juror to serve on a capital case, one where death is a possible penalty, that juror to be able to give meaningful consideration to both possible penalties for first-degree murder. The life penalty and the death penalty.
Yes. Yes.
I'm hearing you say, can you give meaningful consideration to both possible penalties if we end up in a penalty phase in this case?
Yes, I could.
Okay, thank you. And I think that we maybe got hung up. I think I heard you say that death would be the appropriate penalty if somebody was guilty, or you felt very strongly of that person's guilt.
Yes.
Okay. And so I think you heard the judge, or did you hear the judge ask, is there a certain type of, scratch that. If someone is convicted for premeditated first-degree murder, would the death penalty be automatic? And you said
Yes.
no.
Yes.
Okay. Let's just break that apart a little bit. All right. First-degree murder in Florida is the intentional, premeditated killing of an innocent victim.
Yes.
Okay? If somebody was found guilty of first-degree premeditated intentional murder, any defense that was available to that person would have been rejected by the jury that found him guilty.
Yes.
Okay? Things like, just for example, self-defense, heat of passion, walks in, catches his wife in bed with another man, duress, none of those things would have applied because that jury would have found him guilty. No mistake, no accident, the police definitely got the right path. Okay? That's what, if we're talking about penalty, that person is unequivocally guilty of intentional, premeditated first-degree murder.
Yes.
So is the death penalty automatic for that person who committed that intentional killing without legal excuse, justification, or defense?
Grounds? Without facts, just short.
This juror will never be presented with that scenario.
Overruled.
You can answer that. So the question is, for somebody who's guilty of intentional premeditated first-degree murder without legal excuse, justification, or defense, is death the automatic penalty for you?
Yes.
May I have just a moment, Your Honor?
Sure.
Thanks. I don't have any further questions. I have a motion for the court.
State, you have a motion?
Yes, but I'd like to approach if possible.
She's making a motion also. I think you're.
I understand.
But
I'd
you
still
want
like
what?
to approach- If the court were permit, I'd still like to approach.
Sure, come on up. right, ma'am. I don't think this is the case for you, given that it's a death penalty case, so we're going to excuse you with everyone's thanks for being willing to serve.
Okay,
All right?
thank you.
Good luck to you. Thanks.
So I don't have to come back anymore then?
You don't. You're free to go.
Okay, thank you so much.
You're very welcome.
Thank you.
Thank you.
Have a good day.
Thank you, you too. Juror in seat number 4, please. Good afternoon. How are you?
Good.
Can you hear me clearly through this mask?
Yes, ma'am.
Okay. As I said, we have a few questions for you. I'm going to go first, then the lawyers are going to get to ask you some questions. Try to relax. It's not as painful as it appears. We're not looking for any particular answers from you. We just need you, there's no right or wrong answers to these questions. It's just what you actually think and feel. You understand that?
Yes, ma'am.
Okay. Let me start by asking you, you said you'd heard something about this case. Can you tell me what you've heard?
All I remember is the name and seeing something maybe, I don't watch TV or anything. We don't even have cable. So I just remember seeing something maybe on my phone pop up.
Okay.
But I don't really remember any details because I don't keep up with a lot of things like that.
Over the years, has anybody talked to you about the case? Have you heard people talking about it?
No, ma'am.
All right. As a result of what you heard, did you form any opinion as to whether or not Mr. Loyd is guilty?
No, ma'am.
All right. Jurors have to be able to presume he's innocent until and if the state proves he's guilty beyond a reasonable doubt. Can you do that?
Yes, ma'am.
Do you have any moral or religious objections to the death penalty?
I don't have strong feelings either way, really. It's nothing I've ever thought much about.
Okay. In cases like this, if you ended up in a penalty phase, as I explained to you, the state's going to present their aggravators. The defense is going to present their mitigators. You're going to go back in the jury room with instructions from me on what the law is. You and your fellow jurors can discuss it as much or as little as you'd like. It's really up to you. But in the end, you're going to have to make a decision, an individual decision. You're going to have to weigh the aggravators and the mitigators, and you assign whatever weight you feel is important to each of these factors. You can consider everything that you've heard throughout the case, weighing those aggravators and mitigators. You have to reach a verdict. So if after going through that process, you felt that the appropriate sentence was life without parole, could you vote for that?
Yes.
And the same, if after you went through the process, you felt that the appropriate sentence was death, could you vote for that?
Yes.
Do you have any doubt in your mind about your ability to do one or the other?
No.
The insanity defense. As I told you, Mr. Loyd has raised that defense. So this would be in the guilt phase of the trial, the first phase, when you're trying to decide whether he's guilty or not. If after you've heard all the evidence, and again, the defense has to prove that. It's the one time in a guilt phase that a defendant has to prove something by clear and convincing evidence. Let's say they put on all their evidence, state put all their evidence on. It's the end of the guilt phase, and you believe he was insane at the time of the offense. Would you be able to return a verdict of not guilty by reason of insanity?
Yes.
And lastly, as I told you, he has been convicted of the murder of Sade Dixon and her unborn child. She was pregnant at the time. And he was sentenced to life in prison without the possibility of parole. You can't use that in any way, shape, or form to decide whether or not he's guilty of these charges. Do you understand that?
Understood.
Do you have any doubt in your mind that you can put that aside and not think about it during the guilt phase?
No.
All right, thank you, ma'am. I don't have any other questions for you. The attorneys might. Mr. Williams, you may inquire.
Thank you. Thank you, Your Honor. Good afternoon. So I take from your response that there's never been a time where you had the opportunity or chose to sit down and think about the death penalty?
No, sir.
Okay. So in that circumstance, I'd like to walk you through the process a little bit to see if maybe that allows you to think about it and how you feel about it. So that only becomes an issue if Mr. Loyd is convicted of first-degree murder, right?
Yes, sir.
And what would happen next is you would sit with the other jurors and the state would present evidence of what are called aggravating factors. And those are things that are just like they sound. Things about the way the murder was committed, or maybe the nature of the victim, or even something about the defendant's past that make the commission of this first-degree murder more severe than one that lacks those aggravators, which makes sense because that has to be proven for the death penalty to be an option as opposed to not. You understand?
Understood.
Okay. And I'm not trying to talk down to you. I know that it's a lot to take in. After we present the evidence of those aggravating factors, the defense, if they wish, would have the option to present evidence of mitigating circumstances. And those are just like they sound, things about Mr. Loyd's background, character, or life that they believe are reasons why a life sentence without possibility of parole will be more appropriate. If and only if the jury unanimously finds that at least one aggravating factor is proven beyond reasonable doubt, you'd be asked to weigh the aggravating factors against the mitigating circumstances. You as a juror, as an individual, will decide how much weight to give to each aggravating factor and each mitigating circumstance. It's not a mathematical formula where you add up the number of ags against the number of mitigators. Make sense?
Yes, sir.
As you can imagine, some things about some things are going to be more important to you than others. And if you believed that the aggravating factors outweighed the mitigating circumstances, you would be authorized under law to vote to have a sentence of death imposed upon Mr. Loyd. Does all that make sense to you?
Yes, sir.
Anything about that process that you think you could not participate in given your life experiences?
No, sir.
Let's say you go through that process and at the end of it, you believe that we've proven one aggravating factor, and you believe that the aggravating factors outweigh the mitigating circumstances, and you believe your reasoned moral judgment is that a sentence of death is appropriate in this case. Could you go back to the jury room and raise your hand and say, yes, I vote that a sentence of death be imposed?
I believe so.
Okay. And the last part of my question, on another human being. And I say that because believe so is a little bit of an equivocation. So tell me about the I believe so part.
Just that I do value life, but I also believe that we could be accountable for our actions.
Right.
And I do have a strong moral compass, I believe. So I've never had to make that decision, but I believe I could, if needed to.
So even though, am I accurately stating it that that decision would be difficult?
Correct.
But you think if moved in that direction by the evidence that you could vote for death?
Correct.
All right. Conversely, even if you were really emotionally struck by the evidence from the state, could you vote for life if you thought that it hadn't been proven or you thought that's what was appropriate? Life without parole.
Right. Could I go for that if what? I'm sorry.
Yes. You're right. Could you
I
vote
just want to
for-
make sure I understand the
Yes,
question.
ma'am. Yes, ma'am. Could you vote for a sentence of life in prison without parole, even if you thought that you were emotional about what you had heard? If you thought it wasn't the right sentence to vote for death, could you vote for life?
Oh, yes, sir.
Given that an insanity defense may be raised, I need to ask you some questions that are a little more personal.
Okay.
As if this isn't personal enough to begin with. Have you or anyone in your family ever suffered with mental or dealt with mental illness?
No, sir.
Okay. There are those who would say something like, I think mental illness is fake. People use it as a justification to do whatever they want. Do you agree with that statement?
I believe there really are people that struggle with mental illness, but I believe it can be taken advantage sometimes, so.
So it depends on the facts.
Correct.
All right. And do you feel that with your life experience, you could weigh the the insanity defense as it was presented to you, and if the defense were to present evidence to you that proved it, that you could find that Mr. Loyd was not guilty by reason of insanity?
Yes, if it was proven.
Conversely, if it wasn't proven to you, you could set it aside.
Oh, yes.
All right. Is there anything in your life or background experiences that we should know about you, given that we're trying to select the most clear and impartial jury in this case? And by way of example, sometimes people say, you know, my loved one was murdered 10 years ago, and I went to the trial, and it's something I've never forgotten. Hopefully nothing like that has happened to you, but I have to ask anyway.
I have not extreme like that that's happened in my life. No, sir.
Okay. I lied. I have one more question. On a scale of 1 to 10, 1 being you're extremely anxious to get out of here and never come back to the Orange County Courthouse, and 10 being you can't wait to be a member of this jury, where would you rank your desire to be a participant as a juror in this case?
I would say a 5. Okay. I believe in our. I want to fulfill any responsibility, but at the same time, I have a family and children.
Right.
So.
Right. And I assume because the judge asked you and you didn't speak up that if sequestered, you'd be able to handle, you or your spouse would be able to handle that situation to the best of their ability until you got back.
Yes, thankfully I have a village of people that can pitch in and help.
Awesome. Awesome. Thank you very much. Thank you, Your Honor.
Thank you, Mr. Williams. Who's next? Ms. Miller? You may inquire.
Good afternoon.
Good afternoon.
So I want to talk to you a little bit more about your feelings on the possible penalties for first-degree murder. There are only 2, life in prison without the possibility of parole and the death penalty. The judge asked you earlier if death would automatically be the penalty if you found somebody guilty for the crime of first-degree murder. Do you remember that?
I think so, yes.
Okay. It's okay if you don't. I know we're all tossing a bunch at you, right? So that's generally...
Ma'am, can you move that mic up closer to you?
sorry.
I can't hear you. Okay, go ahead. Thanks.
Big courtroom. So let's break that down a little bit. First-degree murder in Florida is the intentional, premeditated killing of an innocent victim. That defendant thought about it, meant to do it, and did it. And if he or she was found guilty of first-degree murder, the jury would have rejected any defense, right? Guilty of the crime of intentional, premeditated killing. So the question is death the automatic penalty for someone who is guilty of the intentional, premeditated killing of an innocent victim? For you.
Is it the automatic? Yes. I would say it varies by case in my mind. I'm sorry? It varies by case.
Okay.
I would say.
Okay, and is there a type of case where it is the automatic penalty?
I mean, like I said, I believe that people should be held accountable for their actions. And so if it was clearly premeditated, and I've never had to think of this before, but I mean, I just, all I know to say is I feel like it would depend on the case and what's being presented.
Okay. Well, and that's why, right, we may not even get to a penalty phase in this case, right? That's only if somebody is found guilty of first-degree murder do we consider the possible penalties being life or death. But this is my only opportunity to speak to you.
Right.
And the law requires that we have this conversation now. And so, unfortunately, I can't give you a lot more facts, and I'm asking you just to look inside your heart of hearts and be as honest as you can. And I know that you don't sit at home thinking about...
I've never thought of this before today, honestly, or before this whole experience.
And so that's why it seems to me that the part you're getting hung up on is premeditation. Right? You mentioned premeditation?
Right.
Right? And so that's where if somebody is guilty of first-degree murder is intentional, premeditated killing without legal justification, excuse, or defense. Tell me what your feelings are about death.
Asked and answered. Objection.
I would disagree.
I'm going to overrule. I'll allow her to answer this, but I may have some follow-ups for her. Go ahead.
Just like I stated before, I believe someone should be held responsible. And I don't know what else to say other than I feel like it varies according to if there was truly a severe, maybe mental illness to be considered, then I think it's fair for it to be considered, but only if the evidence is there for it.
Say the last part again, I'm sorry?
Only if the evidence is there for it and it's clear.
And when you say if there is a severe mental illness, do you mean if the defendant has a severe mental illness, that would be something you would potentially consider in weighing whether to give life?
Correct.
Okay. In the scenario that I've described, intentional premeditated killing without excuse, justification, or defense, would life in prison without the possibility of parole be a sufficient enough penalty for that person?
You're saying if they did have the mental illness?
Right. If we're just talking about first-degree murder conviction, is life without the possibility of parole a sufficient penalty for someone who commits intentional premeditated murder?
Objection, same question reversed.
The objection is sustained as to sufficient enough. It's overruled as to sufficient.
Okay, same question, no enough. So let's rephrase. Intentional premeditated first-degree murder, is life in prison without the possibility of parole a sufficient penalty for somebody who commits that crime?
You're saying if there's a mental illness?
No, we're just talking about somebody who's guilty of intentional premeditated murder.
I'm not sure that I can answer that right now without thinking more about it. I don't know if that's a answer I can give.
Okay.
That is an answer you can give, ma'am.
Okay. There are no right or wrong answers. If you're picked as a juror, you'll take a different oath, but right now the only oath you've taken is to tell the truth, right? And so that's totally fair. But we do need to have more of a conversation about it. Tell me what you're struggling with or what your thought process is.
I guess like I said, I've never been in this situation before, and so it's a lot to take in, and I believe I can do the job if needed. That would be at hand, but I've never dwelt on all of this before, so.
Let me ask you this. If the victim, so it's still intentional premeditated killing of an innocent victim, that victim is a law
Officer.
is death the automatic penalty for someone who premeditated intentional way to kill a law officer?
I believe a life is a life. Either way.
Okay. So then it's not making it, not that there is such a thing as better or worse murder. It's not leaning you one way or another because the victim is a law enforcement officer.
No, it's still a life either way.
Okay. What if the defendant committed intentional premeditated first-degree murder had also committed another intentional premeditated first-degree murder? Is death the automatic penalty? I didn't finish the question.
Yeah, finish your question and then, were you done?
No. Is death the automatic penalty for somebody for this intentional premeditated first-degree murder who has a prior conviction for an intentional premeditated murder?
I'll overrule the objection. You can answer that question.
If I don't know anything about this, then I'm not sure that I could let that way.
Okay, let's assume you know everything about it.
Right.
Tell me.
I mean, if you're saying so, if they murder more than one individual.
Yep.
So then it may make it harder to say that guilty if they premeditated multiple murders, if that's what you're saying.
Okay.
Hold on, let me intervene because I think you're getting confused, ma'am, all right? It's not the person is facing multiple murder counts. It's they're facing a murder count in this one and are convicted of it, and in their background there was another murder. Okay? Do you understand the difference? Okay.
So that's what we're kind of confusing two different things, right? So the judge has talked to you about Mr. Loyd and him having a prior conviction for murder, and you as a juror, if you're selected, are instructed you can't use that to decide his guilt for this case.
Right. I believe I could be fair and
heard you. You got it. Different question, right? We're talking about now somebody who's been found guilty of first-degree murder, and we're in that penalty phase, right, where we're deciding life or death as the appropriate penalty. And you know that person that you're deciding what the appropriate penalty is, has a prior conviction for intentional premeditated first-degree murder. So is death the automatic penalty for this person for this intentional premeditated murder?
I believe I could go off of what we're doing right now versus and block out whatever.
Okay. Let me ask you a different question. You are on an island, and you are the queen of that island, and you make up the rules as the queen. What are the rules for you to make the decision about whether life or death is the appropriate penalty?
Objection.
Sustained.
Can we?
Sure. Spend 15 minutes on that.
Okay. I want to ask you about some things that we call mitigation, right? And it's a legal term that just means why any juror would decide to give life or not give death. Okay. And aggravation is limited to one of 16 things by law. Mitigation can be absolutely anything to any juror. I think, yes, you have to answer loud. If you heard that a defendant had been subjected to the effects of racism over the course of his life, do you think that's something you could give meaningful consideration to deciding whether the appropriate penalty is life or death?
If they had been exposed to racism,
yes.
I don't feel like that would make a difference in life or death for murder.
Okay. And the legal standard is be able to give meaningful consideration to, right? And you seem like a thoughtful person. I don't think you're going to sit there and be like, la, 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 not listening. But if I'm hearing you correctly, that isn't something that, if you're being honest, that you're going to consider meaningfully as to what would be the appropriate penalty.
No, I don't think so.
Okay. Similarly, if a defendant had been well behaved in jail pending trial, is that something that you're going to give consideration, meaningful consideration to when deciding whether life or death is the appropriate penalty?
I'm not sure that that would make a difference in my mind.
Okay. The defendant having a tough upbringing, is that something that you're going to give meaningful consideration to?
I would give consideration to it, but I believe we all have struggles and have to learn how to overcome them.
Sure. And so from hearing you, it's, everybody has some hardships. Okay. You would not be surprised to learn that 12 people selected for a jury on something like this often have very differing opinions. Fair?
Yes.
And the law allows that and contemplates, right? So if we get to this penalty phase, each juror is expected to render an individual moral assessment about whether the penalty is life or death. Fair?
Understood.
Okay. And death is never required, not in any case, not in this case, not in the worst imaginable case, okay? And what's important for justice to be heard in this courtroom, all 12 jurors have to have their individual moral assessment reflected on that verdict form. There's one signature, but it's the foreperson saying, this reflects all 12 of our individual moral assessments. With me?
Yes.
Sometimes things can get a little heated, right? People feel strongly. And so the law also, has some rights that you have as jurors, and one of those is not to be bullied or badgered by a fellow juror. Fair?
Yes.
You would not bully or badger a juror to agree with you, correct?
Correct.
And you're not going to stand by while somebody else bullies or badgers somebody to change his or her.
That is the opposite of who I am.
Okay. May I have just a moment, Your Honor?
Yes, ma'am.
She can't consider any of the mitigation. Right, and do I have more questions for this juror? I have no more questions, but I do have a motion for the court.
All right, let me see she says she has no more questions, but she has a motion. Let me see the attorneys at the bench. All right, ma'am. You've been more than patient. We appreciate your time and your effort. I'm going to excuse you from this jury. We appreciate your willingness to serve, honestly,
you.
more than you even imagined. So you are free to get on with your life. You're discharged as a juror in this
All right,
case.
and thank you all for all what you do.
Juror in seat number 5.
Have a seat here.
Good afternoon, sir. How are you?
I'm doing good.
All right. You were going to check and see if your employer would pay you if you were here for 3 weeks. Is that correct?
Yeah.
And did you check?
Yeah, I checked.
Do they pay you if you're here for 3 weeks?
No.
And if you're not getting paid, can you afford to pay your bills?
I mean, I pay car insurance for myself, but
I can't hear you,
I
sir.
pay car insurance for my car, so I don't think so.
So you don't believe you can pay your bills?
No.
All right. State.
State moves.
Defense. You may, yeah. All right. Thank you, sir. You're free to go.
All right, thank you.
Juror in seat number 6, please. Good afternoon, ma'am. How are you?
I'm good. How about you?
Just fine, thanks. Sorry it's taken so long to get you in here. Did you have a good lunch?
Yes, I did.
Okay, good. So we have a few questions for you. Try to relax. I know that's hard to do in this situation, but try to relax. It's not a test. There aren't any right or wrong answers. We just need you to be honest with us, okay? First of all, I just want to clarify, you're Juror 880.
Yes.
And you've not heard anything about this case. Is that correct?
Well, after lunch, I pretty much kind of like remember hearing something.
Okay.
But not clearly, because I don't have cable at my house. Just,
Okay.
coworkers talking about it, but didn't Google it or something like, okay, what's about
You just
it? Well,
vaguely remember somebody talking about this
Exactly,
case.
yeah.
All right. So is there anything about that, well, let me ask it this way. Is anything that you've heard made you think that Mr. Loyd is guilty of this of the charges?
Again, I don't know much of the details, so I just hear like pretty much what was
All right.
over coworkers were chatting about, and that was pretty much it. I don't know facts. I don't know any much about the case.
All right, so as you sit here today, the law requires you to presume him to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. Can you do that?
If I have the facts and if I have proof or something, that will show.
You haven't heard anything.
Oh, yeah.
Okay? So you have nothing. I read you a little tiny blurb that isn't evidence. Evidence comes from the witness stand and from things that are introduced in court. So having heard nothing, can you presume Mr. Loyd to be innocent?
If I have, correct, yes.
Okay. Let me talk to you a little bit about the death penalty. Do you have any religious or moral objections to the death penalty?
I do not.
Are you someone who believes that if someone is convicted of first-degree premeditated murder, the intentional killing of another person, that they should automatically be sentenced to death?
I do.
Okay. How long have you held that belief?
Pretty much since, pretty much been from a long time. Because I don't think no one have the right to take someone else's life.
Okay. The law in Florida is the exact opposite of that, which is we don't have an automatic death penalty for first-degree murder. We just don't. It's only special cases. The state has to prove at least one aggravator. So, and you have to be able to weigh aggravators and mitigators with an open mind. You heard me explain all that to you. So if there was a conviction for premeditated first-degree murder in this case, the intentional killing of another human being, would you be able to consider a life sentence, or would you be automatically thinking this is a death sentence?
I will consider it to be pretty much the first thing that you mentioned. Not death penalty, but the first analogy that you use.
I can't put words in your mouth, so you have to tell me.
Can you repeat then what you said,
Yes,
please?
ma'am. If there was a conviction for first-degree murder, the intentional killing of another person, and you've got to, be able to fairly consider life versus death. You just told me that you think premeditated murder, it should be death. Would you be able to fairly consider life, or would you be thinking, no, it's a premeditated murder, death is the appropriate sentence?
I can consider it to take life.
You can consider a life without the possibility of parole?
Correct, yes.
Okay. So you could weigh the aggravators and the mitigators fairly with an open mind. You've got to be open to them. You don't have to accept them, you just have to be fair about it. If in the end you decide they don't mean anything to you, that's fine. But you can't start out with, yeah, I'll just sit here until I can vote for death. Okay,
Yes.
You understand the process?
Yes, I do.
And do you believe you can do that?
Yes, I do believe I can do it.
Right. The insanity defense, Mr. Loyd has raised a defense of not guilty by reason of insanity. That's in the guilt phase when you're trying to decide whether he's guilty or not. It doesn't have anything to do with the penalty, okay? If at the end of that, this defense has to prove that. It's the only thing they have to prove in the guilt phase. And it's by clear and convincing evidence. If at the end of all the evidence, the state's put their case on, defense has put theirs on, you're sitting back in the jury room and you're convinced he was insane at the time of the offense, could you return a verdict of not guilty by reason of insanity?
Can you please repeat?
Sure. Are you having trouble hearing me?
Yes, it's
Okay.
hard. It's hard to hear you.
The defense of not guilty by reason of insanity. It's the defense's burden to prove that in the guilt phase. This is when you're trying to decide if he's guilty or not. It's the only time they have a burden in the guilt phase, and that is by clear and convincing evidence. So it's the end of the trial. The state's put all their evidence on, the defense has put all their evidence on, and you are convinced that he was, by the defense's evidence, you're convinced he was insane at the time of the offense. Would you be able to return a verdict of not guilty by reason of insanity?
Yes.
All right, and then last question I have for you. You heard me tell you that he's already been convicted of the murder of Sade Dixon and her unborn child. She was pregnant at the time, and has received a life sentence without the possibility of parole. You can't use that information to decide whether he's guilty or not of these charges. That information comes later on to be used. Can you put that out of your mind in deciding whether or not he's guilty of these charges?
Yes.
All right, thank you, ma'am. I'm going to turn this over to the lawyers. Hold on.
Oh, sorry.
The lawyers get a chance.
Okay.
All right. Mr. Williams, you may inquire.
Thanks, Your Honor. Yeah, this is just getting started, unfortunately, so.
No, you're okay. I thought it was fine.
So What types of projects do you engineer at your job? It says project engineer.
Yes, it's a defense company.
Okay.
So pretty much missiles and
That's enough. I know what
sensors.
you mean. I don't want to put you on the spot, given what you do. So the process that we're asking you to potentially go through can be complicated. So I want to go through it to make sure that we're on the same page. And then I understand what you're saying. I heard you say something to the effect of no one should have the right to take a life. Did you say that?
I did.
All right. And does that mean that you sort of believe in an eye for an eye? In other words, if you take someone's life, your life should be taken?
It depends on the case. Because
Okay.
you cannot have revenge, right? So
Right. Okay. All right. Well, that's why I wanted to ask, to make sure I wasn't misunderstanding. So if and only if Mr. Loyd is convicted of first-degree murder, then all of the jurors would sit down and listen to evidence of what are called aggravating factors. And those are things about how the murder was committed, potentially about the victim in the case, or their sensitivities, or even about things about Mr. Loyd and his background that make this particular murder more severe under the eyes of the law. Does that make sense?
Yes.
That's why they're called aggravators. And they have to be present, at least one of them has to be proven beyond a reasonable doubt to the jury for the death penalty to be an option. Then, after we present that evidence, the defense would have the option of presenting evidence of what are called mitigating circumstances. And those are things about Mr. Loyd's life, background, or character that are reasons they believe that a sentence of death is not appropriate and that life without parole is more appropriate. Make sense?
Yes.
So you have the chance to hear both sides of the equation. If an aggravator is found beyond a reasonable doubt, then you all would be asked to weigh the aggravators against the mitigators. In other words, to decide how important those pieces of evidence are. And only you can make that decision. You're not going to be told how much weight to give anything. If the aggravators outweighed the mitigating circumstances, if that was your individual conclusion, then you'd be authorized to vote for a sentence of death, or that a sentence of death be imposed. Does that make sense?
Yes.
Conversely, if the mitigators outweigh the aggravators, or you just don't believe, for whatever reason, that death is the appropriate sentence, then you would be authorized, or you could always vote for life. Make sense?
Yes.
You can always vote for life. All right. That is the process. So I want to hone in on one part of it, because I'd like you to think about a scenario where you listen to the aggravating factors and you find that there are multiple aggravating factors proven, right? And you find it to be offensive, even, the crime that was committed. You would still be obligated to listen and give meaningful consideration to the mitigating circumstances. You know what I mean?
Yes.
So that doesn't mean you have to agree with them. It doesn't mean you have to find them to be important to you, but you would have to listen to them and give them consideration before you made your decision. Could you promise to give meaningful consideration to anything you heard, even if you disagreed with it?
Yes.
Even if it seems trivial to you, you would still give it meaningful consideration?
Yes.
All right. And then you could decide if it was important. Does that make
Yes.
sense?
Yes.
Okay. Anything about that process that you think you would have a difficult time going through? With the understanding, let me back up, with the understanding being that it's a very important decision. But other than that, go ahead, I'm sorry.
Yes. If everything is explained, down to legal to not legal terms, yes, perfectly.
Okay. All right. I believe you have you have at least one child under 18 at home with you.
Yes, he's 5 months.
5 months?
Yes.
Okay. Will you be is somebody there to take care of him or her for you if you're asked to be with us for 3 weeks?
Yes.
Okay, you can swing that.
Yes, I can.
Awesome, awesome. Because insanity is a possible defense in this case, I need to ask you if you or anyone close to you have ever suffered through or experienced mental illness.
No.
No. Do you believe that mental illness is a real thing?
Yes.
Right. So would you be open to listening to evidence that Mr. Loyd is not guilty by reason of insanity?
Yes.
Okay. My last question for you is there anything about your life or background experiences that you think we should know about, given that we're trying to select the most fair and impartial jury for this case for Mr. Loyd? And like, as an example, some people say, my cousin was murdered 10 years ago, and that left an impact on me. I don't know that there is, but I wanted to ask in case I forgot to ask you. Anything like that?
No, luckily I'm being blessed with a
right. Okay.
family.
Thank you very much, ma'am. Thank you,
welcome.
Thank you, Mr. Rowley. Ms. Mill, you're up.
Good afternoon.
Good afternoon.
Just want to follow up a little bit where you left off. You have a 5-month-old baby?
I do.
Okay. I think you probably heard the judge explain the sequestration process. You would stay at a hotel for 2 to 3 weeks. The court would make some allowances for you to be able to see your family, but limited?
Yes.
And that would work?
That will work, yeah.
Okay. Would you be concerned at all about childcare or anything of that nature?
No, luckily I have my mom around and he will be in good hands.
I get it. The judge asked you if death would be an automatic penalty for someone who was found guilty of the intentional premeditated killing of an innocent victim. Do you remember that?
I did.
And you said yes.
Correct, yes.
And then it changed. Tell me what changed.
So, pretty much my background, I was born here in New Jersey, Elizabeth, and I was raised in South America, in Ecuador. So over there is like all this, it's very natural, very common, all this kidnapping and killing and blah, blah, blah. So of course, hearing all this news in the background, like, okay, if no one has the right to go and pay someone to go kill someone, right?
Right.
So that's pretty much what I grew up with that mindset, like no one has that right. But of course, if things change, could be reasons of yes or reasons of no. So you need to have a proof, you need to have evidence, you need to know and hear both stories to see actually what happened.
Okay. Well, and so the first part of this trial, or any trial where the state is seeking the death penalty, is where if you're selected as a juror, the jury makes a determination about whether the state has proven the defendant guilty beyond a reasonable doubt of the crime of first-degree murder. With me?
Yes.
The second is when the jurors decide what the appropriate penalty is only if the defendant is guilty of the crime of first-degree murder, right?
Right.
And so when you talk about proof and evidence and those things, if we're in this second part of the trial where you're deciding if you're selected as a juror, life or death, the defendant is guilty beyond a reasonable doubt of intentionally, in a premeditated fashion, killing an innocent victim. Right? No doubt, that person.
Mm-hmm.
Then, for you, is death the automatic penalty once you've decided that person is guilty of the intentional premeditated killing of an innocent victim?
It depends on the case, I will say.
Okay. When you say that, what do you mean?
Like, what was the intention? What was like the background of the person? The communication between the case and if the two individuals or the family, I don't know, and just hearing what happened. So I can change my mind.
Okay.
Or my opinion.
And so you're talking about like the relationship between the defendant and the victim?
Yeah.
Okay. And so I also want to make it clear too, if somebody is guilty of first-degree murder, any defense that would have been available to that person would have been rejected by the jury who found that person guilty. Right?
Yes.
So like self-defense.
Mm-hmm.
Wouldn't have applied. So it's guilty murder, innocent victim.
Yep.
And let me say this, there are no right or wrong answers. The judge has said that as well, right? If you're selected as a juror, you take a different oath, but the oath you have taken as a prospective juror is only to tell the truth.
Yep.
And I can assure you, we all want to follow the law and follow the rules. I do. But for some of us, just from our own backgrounds, it's more difficult. And so that's where I don't know you, and so I'm just asking you, based on your upbringing, to look inside yourself and say, you know, I hear the judge and I hear the state and I hear you, but for me, whether or not death is an automatic penalty for somebody who's guilty of the intentional premeditated killing of an innocent victim without excuse, justification, or defense.
I'm going to object, asked and answered.
I think we've had.
Sustain. Move on.
Can we approach, please?
Nope. Move on.
What are your feelings about the death penalty generally?
Well, it's the max penalty that you can get. And it's something that really, something for a life-change event that happened, right? So yeah, like, can you rephrase like it to like what it means to me?
Yes, I mean, if I'm hearing you when you talk about your upbringing in South America, that because you were exposed to a lot of violent crime, right, it's had an effect on your feelings on punishment.
Yep.
Okay, and so death penalty, good thing, bad thing?
Good thing.
Okay, and so would it be fair to say that because, you know, you have this background that was exposed to violence, that you lean towards the death penalty?
Yes, and just let me rephrase. I wasn't involved in any violence.
Oh, I'm sorry.
Yeah, it's just hearing the news and, you know, being raised, and it's very common over there, but yes.
Okay, and so for somebody who's convicted of first-degree murder, would you say your starting place or the presumptive penalty for you is the death penalty?
I will have to hear more about the case, but things could change, but I will say yes.
Okay, and then either myself or my colleague, they're gonna have to do something to compel you to give a life penalty?
Correct.
Okay. Would it be fair to say that the thing we'd have to do would be fairly significant?
Not significant, but just explain a little bit more, like the cause and the effects.
Okay. What do you believe the death penalty should be used for?
Objection, relevance.
Rephrase.
That's what I'm trying to interpret what you're saying about your background. And it seems to me that you have a feeling on the death penalty and its purpose because of things you were exposed to growing up in South America. And so I'm trying to understand that better. If you could share with me.
Yeah, like for example, like kidnapping of kids and then violation for innocent big kids. Like, to me, right off the bat, that should be like a no, not acceptable. And major prison and whatever major penalty that person could get. Another one, I don't know, a killing of someone, an innocent person. Why they did that? Again, major penalty, or if it's a major penalty, death sentence, might as well.
Might as well what, I'm sorry?
Receive the death penalty.
Okay. You brought up a couple things I want to mention. So the judge read the indictment to you in Mr. Loyd's case. Do you remember that?
Yes, I did.
And there are several charges that he's on trial for.
Yes.
One of which is first-degree murder. There's also another count of attempted murder of a law enforcement officer, carjacking, right? So let me ask you this question. If somebody is guilty of not just premeditated intentional first-degree murder, but also carjacking, other attempted murders, does death become the automatic penalty then?
No.
Objection.
Overruled. I'm going to allow her to answer this question.
You can answer that one.
On the answer
Yes.
she's been giving.
I say no.
What makes you say that? That's what I'm having some confusion based on the answers you've given thus far.
Well, because the action of the person reacting is like, okay, oh shoot, I wasn't on purpose doing this. I don't know, the gun itself, I was nervous, stressed, or whatever it should, and then, oh crap, let me just run because I wasn't on purposely doing it.
Okay.
So my reaction is like, oh, let me just, run.
And that's where the disconnect is. For somebody to be guilty of first-degree murder, it wasn't an accident. It wasn't a mistake. There is no defense. It was with intention and with premeditation, right? So all those things you just mentioned would not apply to someone found guilty of intentional, premeditated first-degree murder. And so that's what, when the judge initially asked you that question, you said death was the automatic penalty.
Okay, I'm going to stick with death. With
Okay.
death, yes.
May I have a moment, Your Honor?
You may.
I feel like I have really beaten this dead horse. I have nothing further, but I do have a motion for the court.
State you need to approach?
Yes, we object.
All right, ma'am. Thank you very much. You hung in there like a trooper. I appreciate it.
Thank you.
I think I'm going to excuse you from this case. You should go home and spend time enjoying your family. All
Thank
right.
you.
Thank you so much for your service. You're excused. And the last juror from the 1030 group is in seat number 10, please. This is juror number 759.
Row right in the center.
Good afternoon, how are you?
I'm okay.
Is it on? Yeah, it's on. It depends on where you hold it, whether.
Oh, okay.
Can you hear me clearly through this mask? Okay. We just have a few questions for you, ma'am. You did say that, oh, I'm sorry. You need to tell us the truth. Don't worry about what your answer is. All we're here to find out is what you actually think and feel. There really aren't any right or wrong answers to these questions, okay?
Okay.
So you did hear about this case, is that correct?
Yes, I saw it in the news.
You saw it on the news?
Mm-hmm.
How much did you see?
Just I guess the first 2 weeks.
Okay, you're really soft-spoken. What?
I guess the first 2 weeks.
Try it now.
The first 2 weeks.
Okay. So when it first happened?
Yes.
How much did you watch?
Not much.
Not
It's
much?
just I used to stay with my mom at that time, and she was watching the news, so I don't really look at the news. I don't care for the news.
You what?
I don't care for the news, so I don't look at the news.
Okay. It's depressing. So at that time, your mom was watching it all the time?
Yes.
Was she talking to you about it?
No.
No? All right. So you watched some of it. Did you talk to your mom? So you and your mom didn't talk about it?
No.
Did you talk to anybody else about it?
If I talk to anyone else?
Yes, ma'am.
No.
All right. So other than the news, anything on the internet, Facebook, anything like that?
I mean, I scroll past on Facebook, but I don't go through or read and stuff like that because...
You just kind of see the blurb and move on?
Yeah, and then just keep scrolling.
So based on what you saw, did you form an opinion as to whether or not Mr. Loyd is guilty?
No.
Okay. You have to presume him to be innocent until the state can prove he's guilty beyond a reasonable doubt. Can you do that?
Yes.
All right. All right, let me go over the death penalty with you. Do you have a religious or moral objections to the death penalty?
No.
Are you someone who believes that if somebody's convicted of first-degree premeditated murder, intentional murder of another person, that they should automatically be sentenced to death?
No.
Okay. Would you, in this case, it involves the death of a law enforcement officer. Because it was a law enforcement officer, would you automatically vote for death if Mr. Loyd was convicted?
No, ma'am.
What?
No, ma'am.
You would not? Okay. So you heard me describe the process of the penalty phase.
Right.
Aggravators by the state, mitigators by the defense.
Right.
You weigh them. You're required to weigh them. You have to listen to them with an open mind.
Right.
You don't have to accept them, but you have to be open-minded about it. You may go back in the jury room and go, I just don't think this is important, or I don't believe this, but you at least have to be in the courtroom listening with an open mind.
That's correct.
And you weigh them, look at everything that's gone on, and then you make a personal decision, life or death. So if at the end of all of that, you believed life without parole was the appropriate sentence, could you vote for that?
Yes, ma'am.
And if you thought death was the appropriate sentence, could you vote for that?
Yes, ma'am.
All right. The insanity defense that's been raised by Mr. Loyd, it's in the guilt phase, meaning when you're trying to decide whether or not he's guilty. This is the one time in the guilt phase, it is the defense's burden to prove that. They have to prove he was insane at the time of the offense. Let's say you get to the end of the guilt phase. You've heard all the state's evidence, you've heard all the defense evidence, and you believe he was insane. Could you reach a verdict of not guilty by reason of insanity?
Yes, ma'am.
And lastly, I told you that he's been convicted of murdering Miss Dixon and her unborn child, and that he was sentenced to life without parole. You can't use that to decide whether he's guilty or not in this case. You understand that?
Yes, ma'am.
Do you have any worries about putting that out of your mind in the guilt phase of this case?
No, ma'am.
All right, thank you so much. I'm done asking you questions, but the lawyers are going to have some for you. Mr.
Okay.
Williams?
Thank you, Your Honor. Good afternoon.
Afternoon.
Took a second to figure out where we are, right? We're coming from all directions. I heard you say that you do not have a religious or moral objection to the death penalty.
Correct.
But I also heard you say that if you believed it was proven and appropriate, that you could vote for a sentence of death.
Correct.
All right. So there's a lot of area in between those two things. So I'll ask the question this way. Do you believe the death penalty is fair?
If it's warranted.
I'm sorry?
If it's warranted.
And when you say if it's warranted, what is it in your mind, a circumstance where you think it's warranted?
Well, I can't choose a side unless I hear both sides of the story.
Right.
So if I hear both sides and it's deemed necessary for him to be sentenced to death, then I'm sorry.
Try again.
Better?
Yes, go ahead.
So I have to hear both sides because I don't know exactly what happened or anything like that. So I can't choose whether or not he should or should not unless I know exactly what happened.
And I'm not talking about Mr. Loyd, because we're not going to tell you about the facts of his case because we want you to remain fair and impartial.
Right.
But when you say that you believe it's fair if warranted, that leads me to believe that you have considered a set of circumstances where it would be warranted.
Well, if it's part of the, I'm sorry. Let's see, I'm trying.
It's okay, take your time.
There's a lot of people here.
There are a lot of people. I know it's easy for me to say to try to relax, but truly, there is no wrong answer. We just want to know how you feel about it. However you feel is fine as long as it's the truthful answer.
I'm actually nonchalant.
You actually do seem pretty relaxed. That's why I was surprised you said that.
Because I'm used to like kids, like you gotta choose a side.
Right.
So I don't choose sides until I hear his side, her side, and the truth. So I have to actually listen to see what's going on, because we all know he could probably be innocent, he could be guilty, but I don't know. I'm sorry.
I believe you said he could probably be innocent.
He could be probably innocent, he could be guilty, but I don't know. I don't know what happened. I don't know the case. I wasn't watching the case, so I don't know exactly what's happening. So I'm just in the air.
And this portion of our proceeding is worried less about the guilt, but more about what your thoughts are as to a penalty or a punishment if we get there. Because this is the only circumstance, first-degree murder, where the state is seeking death, where the jury has anything to do with the punishment. Normally, the judge imposes the punishment. Does that make sense?
Yes.
And the jury is not involved at all.
Okay.
So what I'm trying to figure out is, when you say warranted, I take that to mean that there are certain cases where you believe that death would be appropriate.
Well, I don't know how this case went.
Not this case.
Oh, well, let's see. Yeah, so actually, yeah.
Okay, and when you say yeah, what are you referring
yes,
to?
I'm sorry.
No, I wasn't criticizing the use of yeah, but when you say yes, there are cases where you think it's appropriate. What are those cases? Let me try to help you with an example, right? Sometimes, and it has nothing to do with this case.
Okay.
Sometimes people say, and this is serious and graphic, and I apologize, but the rape and murder of a small child, right? There are people who say, yeah, if you do that, I don't care what background you have, you deserve the death penalty.
Right.
Is there a case like that for you?
No.
Right. But are there cases of a similar nature where you think death would be appropriate?
Yes.
Yes. Okay. But I gather from our conversation that you do not believe that death is appropriate in every first-degree murder.
Right.
In other words, you can think of somebody intentionally killing another person where it wouldn't be fair to sentence them to death. Or am I wrong about that?
So we're not talking about this case because I don't know about
We're not
this one.
talking, nope, we're not. We're talking hypothetically or more generally speaking.
Okay. If they intentionally kill someone, then they just be sentenced to death? Is that what you're saying?
No, I'm saying if they intentionally kill someone, could you imagine a circumstance where life would be appropriate? A life without parole as opposed to death?
Yes.
Right. Because I think you told me a moment ago that there are circumstances, not this case,
right,
where someone could intentionally commit murder and you would think death would be appropriate?
Yes.
Okay. Do you have any preference, or do you lean either way towards a sentence of death or a sentence of life in a case where a person has been proven beyond a reasonable doubt to have committed premeditated first-degree murder?
No.
You're straight up and down, straight up the middle?
Yes.
Okay. Open to either one?
Yes, sir.
I'm almost done talking about this. I appreciate your patience.
That's fine.
It is one thing to think hypothetically about participating in this process. It's another thing to be selected and have to make this very important decision. So if you believed that we had proven what the state had proven what we need to prove under the law, could you, if appropriate, raise your hand and vote to impose a sentence of death upon another human being?
And I'm going to object. That's a misstatement of the law as to the juror's responsibility in this case.
Oh, you need to add in the mitigators. She's weighed. You need to rephrase the question.
Sure, Judge. If after you've listened to all of the evidence and you've weighed the aggravating factors that the judge referenced, and you've weighed the background, life, and character of Mr. Loyd, and you believe that after doing that, death is the appropriate sentence, could you personally raise your hand and vote to impose a sentence of death on another human being?
Same objection.
Overruled. Go ahead.
You can answer the question.
Oh, okay. Yes.
Yes. Okay. On a scale of 1 to 10, 1 being that you don't want to be here at all, 10 being that this is the most exciting thing that's ever happened to you, where would you rate your desire to be a participant in this process?
Overruled.
Go ahead, ma'am. You can answer.
I'm straight down the middle, 5.
5. Okay. And is that based, are you interested in the process?
It's a learning experience.
Okay. But I'm assuming you have other things going on in your life.
Yes, I do.
Yes, ma'am. Okay. Because the issue of sanity has been raised, I need to ask you if you or anyone close to you has ever suffered or dealt with mental illness in any way.
No.
No. There are people who believe that mental illness is fake or made up and is just an excuse for their behavior. Do you think that's true, or do you disagree with that statement?
I don't think it's true.
All right. So I take that to mean that you believe that mental illness is real.
Yes.
So if Mr. Loyd were to present a defense of not guilty by reason of insanity, could you fairly consider that if it was proven to you?
That he was insane?
Yes.
Yes, sir.
Okay. Last question. Anything about this process, you don't believe me, do you? Anything about this process that you think, anything about your background or life experience that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case?
No.
All right. Thank you, ma'am. Thank you, Your Honor.
Thank you. Ms. Miller, you may inquire. Yes, ma'am.
afternoon.
Good afternoon.
I just have a couple follow-up questions about your feelings on the penalties for first-degree murder, the life penalty, life without the possibility of parole, or the death penalty.
Okay.
We already talked about, is death the automatic penalty for somebody who's found guilty of intentional premeditated first-degree murder? And your answer was no.
Correct.
Okay. Let me add a different factor to that. What if the victim in the case was a law enforcement? So is death the automatic penalty for somebody once he's found guilty of intentional premeditated killing of a police officer?
I can't hear you.
You can't hear me?
The mic keeps cutting out.
Sorry. It's the first time anyone's ever said that to me. Better?
Yes.
Okay. Same question, different factor?
It cut out.
Yeah, it cut out again.
What I'm doing wrong, I apologize.
Do you have the actual mic portion in your pocket?
No?
No, I'm talking about the other portion.
Oh, yes.
Yeah, pull that out for a second and see if you can clip it, or just hold it and see if that's better.
We're just going to hold it. Can you hear me now?
Yes.
Okay. Intentional premeditated killing, the victim is a law enforcement officer. So does death become the automatic penalty once you have found someone guilty of the intentional premeditated killing of a police officer?
No.
Okay. Why not?
Like I said before, there's both sides, one side and the truth. So I don't know, whatever, regardless of which case it is, I have to hear both sides first. I just can't choose a decision because it's out there.
When you say both sides, is it both sides at why this happened, like in determining if the person is guilty or not?
What I mean both sides is, it could be his side, her side, and then there's a truth between both sides. So I stand in the middle of everything. I don't just choose because of hearsay or he said or she said. Right. I actually have to do some, well, of course we can't research, but I have to actually listen and choose a side. I just can't say here today that, oh, okay, he's guilty, he's about to die.
Right. No, and you shouldn't, right? That's the whole point, is we're trying to find folks that can hear the evidence and decide if the state has proven Mr. Loyd guilty beyond a reasonable doubt, or if the defense has proven him not guilty by reason of insanity, okay? The questions we're talking about now, right, I know this is a lot. The first part of this trial, if you're selected as a juror, you'd be asked to decide guilt or innocence. Has the state proven him guilty beyond a reasonable doubt, or has the defense proven him not guilty by reason of insanity? Okay?
Okay.
So if we're talking about possible penalties, life penalty or death penalty, we've already made the determination that he's guilty.
Okay.
You with me?
With you.
And so that's why I just wanted to be clear when you said you have to hear both sides of, and I said there's usually three sides to any story.
Right.
His, both sides and the truth and this in the middle. I get that. But so if we're talking about penalty, you have already made a determination at that point that the person is guilty of the intentional premeditated killing of an innocent victim.
Okay.
With me?
With you.
So what are your feelings about the death penalty then? Appropriate penalty for that person who's already been found guilty of the intentional premeditated killing of an innocent victim?
I don't have any feelings, honestly.
What do you think about the death penalty? You're doing great. I promise. There's no right or wrong answers, and I know we're putting you on the spot, and it's a lot. But we have to ask these questions. I think you can appreciate why.
Right. How do I feel about the death penalty?
Just honestly, what comes to mind?
Actually, nothing comes to mind.
Do you think it's a good thing? It's a bad thing?
No, I mean, death is not a good thing because obviously someone's gonna miss you, but I don't want to sit down. But if that's the last resort to it, then that's what it's got to be.
Okay. What does that mean when you say that?
If once we get all the evidence or whatever, we see everything and hear what's going on, if that's what it turns out to be, then that's what it's got to be.
Okay. Let me tell you this. Death is never required. Not in any case. Not in this case.
Right.
Not in the hypothetical case Mr. Williams was talking about. Not in the worst case you can imagine.
Right.
Never required. Right? So there's no set of circumstances where you're going to have to apply the law and then you have to vote for the death penalty.
Okay.
And so that's what, when you say, like, if it is what it is, or that's how it turns out, figure out what you mean by that.
After hearing whatever, the sides, and if, not this case, right? I could talk about any other case.
Right, because we don't know anything about Mr. Lloyd's case.
Okay,
So as Mr.
good.
Williams said, we're talking in hypotheticals.
Okay.
Right, just your feelings on the death penalty.
I'm actually straight down the middle of it. Death is never good, like I said before, but if, well, I honestly don't have a clear answer for that.
Okay. Well, and we kind of got off on a tangent. Let's go back to, if the guilty person, the guilty murderer of the innocent victim, killed a law enforcement officer, is death the automatic penalty?
No.
Objection, asked and answered.
Sustained.
If the guilty murderer who killed the innocent victim, right, so we're deciding what the appropriate penalty is for this person. If that person also has a prior conviction for murder,
Okay.
is death the automatic penalty?
No.
Okay. Is life in prison a sufficient penalty for the person who committed this murder that's already been convicted of another murder?
Objection.
Sustained.
The court allowed that one before.
Yeah. And I shouldn't have. Let me see the attorneys at the bench.
Go back. Is life in prison a significant penalty? Significant penalty.
Significant, yeah.
Is life in prison a significant penalty for somebody, when you're deciding what the appropriate penalty is on this murder, who's been previously convicted of murder?
Yes.
Okay. In determining whether life or death is the appropriate penalty, would you be able to give meaningful consideration to whether that defendant had suffered the effects of racism throughout the course of his life?
Yes.
Okay.
Yes. Yes.
You kind of hesitated. What were you thinking?
If the mic is on,
okay.
I can hear myself.
I can hear you.
Okay, great.
Okay. Mental illness. Could you consider whether the defendant who committed this murder suffers from mental illness in determining whether the appropriate penalty is life or death?
Yes.
Okay. Let me tell you a couple things, and we already talked about this a little bit. Death is never required, not in any case, right? And we've talked about mitigation a lot, and it's just a legal term that means why anyone would choose life or not choose the death penalty, okay?
Okay.
Mitigation can be anything, you okay?
Yes.
All right, mitigation can be anything to anyone. And it doesn't have to be unanimous. Each individual juror could find something mitigating to himself or herself, and every other juror could disagree with it.
Correct.
And aggravation is limited by law to one of 16 factors in Florida. But mitigation can be absolutely anything. It can even be something as seemingly small as observing a smile between the defendant and his mother.
Okay.
Okay?
Yes.
Okay? All right? In order for a just verdict to be returned, all 12 jurors selected for this case have to have their individual moral assessments heard in this courtroom.
Correct.
It would be a miscarriage of justice if someone on that jury's individual moral assessment wasn't heard in this courtroom.
Correct.
That's your duty, your right, and your responsibility if you're selected to be a juror.
Right.
Can you do that?
Yes, ma'am.
It's obviously a huge responsibility, and somebody's life is on the line.
Yes, ma'am.
Sometimes these things can get a little contentious in the jury deliberation room, right? And so we encourage people to deliberate, which means to carefully consider, but it doesn't mean to out-debate or bully or badger each other into just agreeing, right? And so that's your right as a juror to be treated with respect.
Right.
And you're going to treat other jurors with respect.
Correct.
And if you have reached an individual moral assessment that the verdict should be life and it's not being respected by your fellow jurors, you can be like, we're done here. Write it down, foreperson. If you're not the foreperson, get the bailiff, get the judge. We're going home.
Right.
Because if one person thinks the verdict should be life, then it will be life.
Right.
There's no such thing as a hung jury in the penalty phase of this trial because it's 12 individual moral assessments.
Okay.
You okay with that?
Yes.
Can I have just a moment, Your Honor?
Yes, ma'am.
I have nothing further.
Thank you. Either side have a motion?
No, Your Honor.
All right, thank you. All right, ma'am, we're going to bring you back for one last round of questioning. It's on another day.
Okay.
So you're no longer a green dot, you're now a purple dot. We're going to give you a purple dot. And that's because, remember I told you the colors are when you call into the jury room, you're listening for them to call a color group. There's too many of you for us to call you by number, we just call you by color.
Okay.
Okay? So now when you call, you're listening for purple dots report on such and such a date. We're not going to need you before next week at the earliest.
Okay.
It is the final day. We're going to pick the jury from the group, from the purple group. So when you come to the courthouse, you need to have packed a suitcase because if you're picked for the jury, you'll be sequestered right then and there. Just leave it in your car.
Okay.
Don't bring it to inside. Just leave it in your car, and if you need it,
Sorry.
deputies will go out and help you get it. all
Okay.
right? Starting Friday, call the number that's on the slip in there after 5. So call Friday, Monday, Tuesday, until you hear that you're supposed to come back for the final day of jury selection.
Okay.
There's also a package in there about sequestration. It tells you, kind of suggests some things to bring and what we suggest is, what are the rules of sequestration and all that. So you have some ideas of what's going to happen.
Okay.
Do you have any questions?
No, ma'am.
Thank you so much for your time today, ma'am. We will see you next time.
All right.
Thank you.
Bye.
You're just going to follow them. All right, do we have the other group in there? They're all in the jury room? You guys need a break? You need a break, Rebecca? Do you need a break? You can have 10. I'm going to start back up at 3:30. I put the 1:30 and the 3 o'clock together. Thank you. Back on the record on State versus Loyd. He's present with his attorney. State Attorney's Office is present. We got the next batch. This is the 1:30 and 3 o'clock. Let's bring them in. 1:30 in the front row, 3 o'clock in the back row. All right, have a seat, folks. Welcome back, everyone. I'm sorry for the delay in getting to you. As I indicated, this is a capital case, so sometimes it takes longer, but it's a serious case. We need to take our time doing what we're doing. So I do apologize for the wait. I am going to work through to make sure that none of you have to come back tomorrow. So we may be here a little bit later, some of you may be, but we'll try and get you out of here as soon as possible. This is the second phase of jury questioning. As I told you, jury selection. We do these cases, these capital cases, the selection of the jury in phases for a reason. Today I'm going to give you a little bit more information about the charges, the case, and the difference in these types of trials versus other trials that you may have sat on as jurors or even seen on TV. After I'm done with that, you're going to go back in the jury room. We're going to bring you out here one at a time to ask you some individual questions. I ask questions, then the lawyers ask questions. What I'm telling you now is an overview of the case and of the instructions that you're given as jurors. There are detailed instructions that are provided to people on juries at every stage of a case. Is anyone having trouble hearing me or understanding me through this mask? Everybody good? All right. Let me start with telling you what the charges are in this case. Mr. Loyd's been indicted and charged with certain things. An indictment, this is a copy of it in my hand. An indictment is a piece of paper that tells someone what they're being accused of doing. You have to tell people, this is what we accuse you of doing. These are the crimes we think you committed. This is what we're charging you with. The state of Florida does it by indictment. This is not evidence of guilt. In other words, just because someone's been charged with a crime doesn't mean you can assume they're guilty. In fact, you're required to assume he's innocent until and if the state can prove he's guilty. So, by indictment, Mr. Loyd was charged with first-degree murder with a firearm of a law enforcement officer, attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, and possession of a firearm by a convicted felon. The first count, first-degree murder of a law enforcement officer, is the only count for which, if Mr. Loyd is convicted, the death penalty may become an option and therefore requires a second part to this trial. The first part of this case, the guilt phase as we call it, the second part's called the penalty phase if we get to it. The guilt phase of the trial, that's where you have to decide whether or not the state has proven beyond a reasonable doubt that Mr. Loyd is guilty of the charges. That phase of the trial is exactly the same as every other criminal trial, okay? You're going to be asked to return, you're going to sit in the courtroom, listen to the evidence. Evidence comes from the witness stand, it comes from physical evidence that may be introduced, videos, just everything that's presented to you in the courtroom. At the end of that, you're given detailed jury instructions by me. That's the law that you're required to follow. You're going to go back in that jury room with your fellow jurors and you're going to reach a verdict on each one of these counts. You're required to reach a verdict, or you'll reach a verdict on either acquittal or conviction on each count. In this phase of the proceedings, the verdict has to be unanimous, meaning each juror must agree to the verdict on each count. As I previously said, the only count qualifying for the death penalty, if he's convicted, is the first count. The burden of proof for the government, or for the state, in the guilt phase of the trial is the same as in every other type of criminal case, and it is proof beyond a reasonable doubt. The instruction you will receive on reasonable doubt is exactly the same as in every other criminal case. The burden on the state is not higher because of the possible penalty. When you are deciding guilt in this phase of the case, you are instructed that you must ignore any possible sentence. In other words, we're asking you to decide whether the defendant is guilty on each count on their own merits, including the first-degree murder. And you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree as well as the other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you as jurors to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury will then reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. That phase is what's called the penalty phase. If that happens, there's a special set of rules and instructions that come into play, and I will give those to you at that time. Right now, all I'm giving you is an overview of the penalty phase. The death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree. The legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which jurors are to consider in reaching a verdict in a death penalty case. The automatic sentence in first-degree murder is life without the possibility of parole. In these types of cases, capital cases, where the state is requesting the death penalty, there are special circumstances that have to be proven by the state in order for the death penalty to even be an option. Those are called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt, and they are limited in number by statute. The defendant relies on things called mitigating circumstances. Mitigating circumstances do not need to be proven beyond a reasonable doubt. They need only to be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute and may include matters relevant to the defendant's background, character, or circumstances surrounding the offense, and they will be offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without the possibility of parole in the state of Florida means exactly that. The defendant will die in prison. There is no parole for this in the state of Florida. Before you may vote that the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. Once all the evidence in the penalty phase has concluded, you will retire to the jury room with a set of jury instructions from me giving you the law at this stage of the proceedings. You're going back into that jury room with your fellow jurors to undergo the process of making the decision. It involves weighing aggravating factors and mitigating circumstances to determine the proper punishment. This process is not a mechanical or mathematical process. And by that I mean you don't go back there and add things up and say, well, there's this many aggravators and this many mitigators. That's not how it works. The law contemplates that different factors, different mitigators or aggravators, may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Your decisions at this stage of the proceedings are individual. Each juror may give individual weight as they see fit to each aggravator and mitigator. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, your verdict for death must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. That's a very broad outline of the penalty phase. We'll be explaining things to you a little bit further during individual questioning as needed. Let me also caution you about one thing. The fact that I'm talking about the death penalty is not to be taken by you as an indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility. It doesn't presuppose anything. We just have to be ready in case it happens to make sure that you would be able to do your job as jurors if you were in a penalty phase. We're going to be asking you some questions about the death penalty. I'm going to tell you what some of them are just so you can think about them a little bit, because these aren't questions that you normally face. We're going to ask you if you have a moral or religious objection to the death penalty. You're going to be asked if you're someone who believes that death should be automatically imposed for certain types of cases. For example, in a first-degree premeditated murder, I'm going to tell you right now and instruct you that there is no automatic death penalty in the state of Florida, including for first-degree premeditated murder. We're going to ask you if you can weigh aggravators and mitigators and listen to the evidence in the penalty phase with an open mind, go through the weighing process, and vote for either life or death, whichever one you believe would be the appropriate sentence. We're also going to ask you if you are a person who is so opposed to the death penalty that you simply can't impose it no matter what the law or the circumstances are. People have very strong feelings about the death penalty, both for and against it. The fact that you may have such feelings does not disqualify you as a juror, so long as you can set those aside and follow the law as I instruct you. In other words, you have to be willing to be bound by your oath as a juror to obey the laws of the state of Florida. Moving on, Mr. Loyd has raised the insanity defense in this case. I'm going to read you the definition. And I'm also going to tell you that this is the only time, this would occur in the guilt phase, when you're the first phase of the trial, when you're trying to decide guilty or not guilty. This is the only time that the burden is on the defense to prove this, not the state. The burden is on the defense to prove insanity, and it's by clear and convincing evidence. I'm just going to tell you what in the instructions the definition is. We will have some questions for you about this defense. A person is considered to be insane when he had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. The instruction's a little bit longer, but that's enough for today's purpose. We will be asking you about your feelings about that defense. In other words, can you listen with an open mind, and if it's proven, could you vote not guilty by reason of insanity? And lastly, I'm going to read you a statement about this case. It's a little bit about the facts. It's a very little bit about the facts of the case. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. Those facts about Ms. Dixon and her unborn child and that conviction and the life sentence may not be used by you as evidence of guilt in this case. It is being offered for a different purpose, and you would receive specific instructions from the court as to what to do with that testimony. But we are going to be asking you questions about whether you can put those facts aside in determining guilt on these charges that he's facing now. All right? So let me ask you some quick questions by show of holding up your paddles only, please. How many of you have heard about this case prior to today? All right, so I have, once I call your number, you can put it down. 22, 34, 36, 46. Are you holding up your paddle? 50, 52, 53, 55, 58, and 60. All right, of those of you who've heard about the case, how many of you have formed an opinion about Mr. Loyd's guilt or innocence? Anybody? Nope? Okay, thank you very much, folks. So, I'm going to start with your juror number 14, right? All right, if you'll stay in the courtroom, the rest of you go into the jury room. We'll be with you just as soon as we can. All right, ma'am, you're juror number 950, right?
Yes.
Can you hear me through this mask?
Yes.
Okay. And you haven't heard anything about this case, correct?
No.
Okay. I'm going to be asking you some questions, then the attorneys will have a chance to ask you questions, okay? There aren't any right or wrong answers to this. You're not getting graded. All we're looking for is for you to be honest with us. You understand?
Yes.
So just answer the question and don't worry about what your answer is, okay? You haven't heard anything about this case, correct?
No.
You haven't talked to anybody about it? You don't know anything about it other than what I've just told you?
No.
All right. Do you have any religious or moral objections to the death penalty?
No.
Are you someone who believes that if someone is convicted of first-degree premeditated murder, the intentional murder of another person, they should automatically be sentenced to death?
No.
Okay. In the state of Florida, there is no automatic penalty for, well, there's no automatic death sentence for intentional first-degree murder. You understand that?
Yes.
You heard me describe what the process is of trying to decide whether you want to vote life or death. Let's say you've listened to all the evidence, you've listened to the state's aggravators, the defense's mitigators, the things the state believes are the reason you should sentence someone to death. The mitigators are the reasons the defense believes you should sentence someone to life. You're going to go back in that jury room. You can discuss it with your fellow jurors. You're going to weigh the aggravators and the mitigators, think about all the evidence, everything that you've heard throughout the trial. If at the end of that process, you believed that the appropriate sentence was life without the possibility of parole, could you vote for that?
Yes.
If at the end of that process, you believed the appropriate sentence was death, could you vote for that?
Probably.
Probably? Okay, why is the answer different? You said yes to life and probably to death. What's concerning you?
Just that I would have to sentence someone to death.
You are really soft-spoken. Can you speak up a little bit?
Just that I would have to sentence someone to death.
Okay, you would have to vote for the court to impose a sentence of death?
Yes.
Okay. So it's the responsibility of it that's weighing on you?
Yes.
It's a scary thought when you first hear it. I understand that. It's a huge responsibility to decide to vote life or death. So the question is, as you sit there, just think about it for a minute. Could you do it if you thought that was the right sentence?
I believe I could do it if it was right.
Now, remember what I told you, you're never required to vote for death, but you have to be open to it, and if you believed that was the appropriate sentence, be open to voting for death, but you're not required to do it. You understand that?
Yes.
Okay. The insanity defense. If at the end of the guilt phase, when you're trying to decide whether he's guilty or not, you felt the defense had proven to you that Mr. Loyd was not guilty by reason of insanity, could you return that verdict?
Yes.
All right. And can you follow my directions about not using the Sade Dixon murder conviction and that of her unborn child and the life sentence as a basis or anything to decide whether he's guilty or not of these charges? Can you put that aside?
Yes.
All right, thank you, ma'am. I'm going to turn this over to the lawyers. Mr. Foxman, you may inquire.
Thank you, Your Honor. Good afternoon, ma'am.
Hi.
A few minutes ago, the judge and you were talking about if you felt the proper punishment in this case was death. He said, I think I could vote that way, or I probably could, or I think. You were a little hesitant. Now, a judge friend of mine uses an example of if you're going to go and get in a plane to go have a trip to New York, you're going to get in a plane and you get in there and the pilot's greeting you when you walk on the plane, and you say, Mr. Pilot, we're going to have a good flight, we're going to land safely, and he goes, I think so. Would that instill a lot of confidence in you as a passenger on that plane that he thinks he could land the plane?
Not really.
Okay. See where I'm coming from? I'm going to talk about a few other things, but kind of put in the back of your mind, think down into your heart and your soul. It's a daunting task, and this is a heavy situation, especially for someone, I believe you're 18, right? This is a heavy task for people twice as old as you. So I'm going to put that on hold and go through a few other things. We're going to come back to that, okay? The judge, you indicated to the judge, and she told you that there's two stages to this trial. And the first stage is called the guilt phase. Now, in that phase, your job as a juror would be to determine if the defendant is guilty or not guilty of the crimes charged. If the jury unanimously finds the defendant guilty of first-degree murder, then only then would we move to the second phase of the trial, which is called the penalty phase. That make sense?
Yes.
Okay, and I'm not trying to talk down to you. There's a lot of information we just threw at you. I'm just trying to walk through it step by step, okay? No matter how bad the murder was, how egregious it was, how premeditated it was, if there wasn't any defenses, that doesn't matter in the penalty phase. What matters in the penalty phase is what is the proper punishment for this case. okay? Now, you're going to be able to, if we get to that point, you'll be able to consider the facts of the homicide, but there is no such thing as an automatic death sentence, no matter how bad the murder is. Does that make sense?
Yeah.
The system says that a defendant convicted of first-degree murder is entitled to a jury that can listen to additional evidence to see if this specific case warrants the death penalty. Okay, so would you be able to follow the law that just because someone is convicted of first-degree premeditated murder, that person still is entitled to a jury to listen to additional facts before making the ultimate sentence?
Yes.
Does that make sense?
Yeah.
Okay. If we get to the point where we're talking about a sentence in this case and the jury's asked to decide the sentence in this case, the state will introduce evidence that are called aggravating factors, which are factors that make this murder more egregious than other murders. No matter how many aggravating factors are shown to you, no matter how horrible those aggravating factors may be in your mind, will you still be able to listen to the mitigating factors presented to you by the defense?
Yes.
Okay. So can you hold off your judgment until you hear the other side of the story, the mitigating evidence, the evidence that suggests that life may be the proper punishment in this case?
Yes.
Okay. Do you think that Mr. Loyd would be entitled to have a jury, who would hold off judgment and listen to all of the evidence before you form an opinion?
Yeah.
This isn't the time to talk about the details and the evidence that you'll hear about each of the aggravating factors or each of the mitigating circumstances. That's during the trial, because we can't talk about the actual evidence in this case. But can you promise me that you would be able to listen to all the evidence before you come to a decision? So if I stood up here and asked you about 100 different mitigating factors, am I correct that your answer would be, I would listen to that evidence, I would consider that evidence, and then only after I hear it all would I make a decision?
Yes.
Now, once you hear the evidence dealing with an aggravating factor and a mitigating circumstances, you can then decide to do a few things with that information. You can find that the evidence didn't prove that those factors were even applicable. Or you could say, well, the evidence proved that the aggravating or mitigating factors exist, but this factor really isn't important in my decision-making process, so I'm going to give that a little weight, little to no weight. Or you could say, this piece of evidence is really important to my decision-making process as far as what the sentence should be, and give it a lot of weight. That's up to you. Can you go through that process and that analysis before making a final decision in this case?
Yes.
Once you make that analysis, and if you decide that the aggravating factors outweigh the mitigating circumstances, then you'd be authorized to vote for the sentence of death in this case. Does that make sense? That is an individual determination made by you and each of the other jurors. And no matter what, you never are required by law to vote for the death penalty. If all 12 jurors agree that death is the proper punishment in this case, then it has to be unanimous, and then it could become a potential punishment here. Okay, but it would take all 12 people to vote for death in this case. Does that make sense?
Yes.
All right. Now, back to where we started. I'm going to ask you that airplane example with you, and you said, I think I can. If, after going through this whole process, you're back in the jury room and you consider all the evidence on the aggravating factors, and you think that evidence outweighs the mitigating circumstances such that you think death is the appropriate sentence. And I'm talking in a situation where, a real-life situation where you are the one having to make the decision, not you hanging out with your friends, talking to your coworkers, saying, I could vote death in that case, but a real-life situation. Looking down into your heart of hearts into your soul, you know you best. Would you, if you found that the evidence supported the death sentence in this case, and you felt that that was the proper sentence, could you come into this courtroom, raise your hand, and by your vote, say this man deserves to die for what he did?
I'm sorry? The statement of the law as to this man's role in this case.
Overruled.
You think you could do that?
Yes.
Yes? What were your thoughts about going through that process, what we just talked about, and you answering, yes, you could now, as opposed to before you said, I think I can? Kind of what changed in your mind?
No.
Okay, no, that's fine. Are you nervous?
Yeah.
Okay, don't be nervous. It's just us talking. It's okay, don't be nervous. Was there something in the beginning of this that caused you some hesitation about the responsibility of having to make that decision? Okay. Is there something that, since we've been talking and going through the process, that changed in your mind about your ability to make that ultimate decision?
Yes.
I'm sorry?
Yes.
Okay, what was that?
That's not like guaranteed.
You get us together.
That's not guaranteed.
What do you mean?
Like my vote wouldn't necessarily like guarantee the death penalty. It would just be a possibility. Is that correct?
The law is that the court cannot impose a death sentence without the jury unanimously voting for it. The sentencing of Mr. Loyd is done by me.
Okay.
Now, none of us want you there thinking that because the judge does the ultimate sentence in this case, that your vote is not important. Okay, your vote is very important. It might be one of the most important decisions you'd have to make. So please don't think that it alleviates your responsibility to consider the evidence and make the proper decision in this case simply because the judge makes the decision.
Let me follow up on that.
Thank you, Your Honor.
Mr. Buxman. You have to take this as seriously as you've ever taken anything in your life, okay? Without a unanimous vote from the jury for death, the sentence is life without the possibility of parole. It's an automatic sentence. But when a jury votes for death, that then comes to the judge, and it comes to the judge with a presumption that you have to respect, that the jury has said death is the appropriate sentence in this. All I'm trying to tell you is ultimately you're not pronouncing sentence on Mr. Loyd. I'm pronouncing sentence on Mr. Loyd, okay? But your vote is your vote, all right? And I can't sentence him to death unless I get 12 jurors saying I'm voting for death. You understand?
Yes.
All right, so Mr. Buxman is right. I don't want you to think that this isn't serious because you're not the person who has to say anything, okay?
Yeah, I understand.
All right.
Knowing that your vote is incredibly important, and we can't be thinking that someone may bail you out or something like that if you vote death and somebody else could take that responsibility away from you. That responsibility lies on you and your 11 other jurors. Knowing that the weight of that responsibility, would you still be able to go back in that jury room, deliberate, and if you felt the sentence was appropriate for death penalty in this case, would you be able to come in here, raise your hand, and say the death penalty should be imposed on another human being?
Yes.
Okay. As far as the insanity issue that the judge mentioned earlier, one of the components of the insanity defense is a mental health, mental illness. I'm going to ask a couple personal questions, and I apologize. But is there any, do you have either you, a close friend, or family, any experience, significant experience with a mental illness?
No.
No, okay. Do you feel that mental illness is a legitimate part of society and legitimately affects certain people?
Yes.
Okay. Would you be able to listen to all the evidence regarding whether a mental illness exists in this case, and if so, what the effect of that mental illness is, before coming to a conclusion as to whether insanity has been proven?
Yes.
You could do that, okay. Is there anything in your life, your background, that may, in your mind, make you feel uncomfortable and make you feel that you're not a good juror for this type of a case?
I'm 18 and I'm a college student. I guess that's it.
Okay. You're in college right now?
Yes.
Okay, are you taking, we may have gone through this, and forgive me if I don't remember, but do you take online classes or in person?
They're all online.
They're all online? Can you do those online classes anytime, or are there specific times you have to be present online?
I can do it anytime.
Okay. And being an online student, would you still be able to keep paying attention to this case if you were selected as a juror and not wondering, God, when can I get out of here? I have online classes to do. I'm getting behind.
Yes.
Okay. If I could have one moment, Your Honor.
Sure.
Last question for you, I promise. You mentioned a minute ago, I'm 18. Are you comfortable that you have the life experience to take on this responsibility?
I think so, because I'm 18 and I haven't experienced this before.
Okay. I believe, and forgive me if I couldn't quite hear you. You said, I don't think so.
And I haven't experienced this before.
Okay. Well, not many people have experienced this situation before, but does the fact that you're 18 concern you as being a juror in this case? Why?
Because I'm young.
Okay. Okay. Do you think that would interfere, just you being young, being 18, would make it difficult for you to follow the trial, follow the legal concepts involved, anything like that? A little? Okay. In what way? Can you? I told you it was one question, but I apologize. In what way?
I don't know.
Okay. Okay, fair enough. Nothing further, Your Honor. Thank you, ma'am.
Thank you, Mr. Bell. Who's up? Ms. Miller? You may proceed.
I don't know where to go.
Hi. So Mr. Buxman gave you, right? I just want to have a conversation with about your feelings, okay? You are selected as a juror in this case, sworn, and you will take an oath to do something different than the oath taken thus far, which is just to tell the truth. And I can promise you, you're going to get it on paper, and the judge is going to give you all the instructions you need, okay, if you're selected. So this is really the time where we just talk about your feelings on the two possible penalties for first-degree murder: life without the possibility of parole or the death penalty. Okay?
Okay.
and I know you're on the spot, but nobody can see you, I promise, other than who's in this courtroom, okay?
Okay.
The answer I think you gave the judge initially was that you could impose death, and your quote was, "I believe I could if it was right." Do you remember saying that?
Yes.
Tell me what you mean by that.
Like if there was enough evidence to support that they deserved the death penalty.
Okay. And I'm not asking you to tell me what you think is aggravating or mitigating. I'm trying to get a better understanding of what you mean when you say, what evidence to support the death penalty?
I don't really know.
Okay. Well, so let's start at the beginning. In order to even get to this second part of the trial, we may not even get there, right? The second part of the trial is only if Mr. Loyd is found guilty of intentional premeditated first-degree murder, okay? So intentional first-degree murder in Florida is the intentional premeditated killing of an innocent victim without legal excuse, justification, or defense, right? That's how we get to the second part, is only if somebody is guilty intentional premeditated killing of an innocent victim without legal excuse, justification, or defense. With me? So how do you feel that somebody who's guilty of the intentional premeditated killing of an innocent victim should be punished?
I guess with life.
Say again, I'm sorry?
I guess with life and without parole.
Okay. That is right. That's instinctively right where you start. And then the state would have to prove the existence of an aggravating factor before somebody's even eligible for the death penalty. Okay? So if somebody's guilty, and we're in the second part of this, right, the state has to prove the existence of at least one aggravating factor before you can even consider death as a possible penalty. Okay?
Yeah.
And that's what the law requires for you to serve as a juror in this case, to be able to give meaningful consideration to both possible penalties, life without the possibility of parole or the death penalty. And you can do that, right?
Yes.
Okay. I believe on your questionnaire, you talked about having family and law enforcement, family or friends in law enforcement. Is that correct? Okay. Tell me who of your family or who you know that's in law enforcement, please.
My uncle who lives in Massachusetts.
Okay. Would you say you're close with that uncle?
Yes.
Like, do you talk frequently?
Well, only like if we go on vacation.
So you don't call and chat?
Sometimes.
Okay. The judge told you this case, Mr. Loyd is accused of killing a police officer, Lieutenant Clayton. Do you think you would have trouble finding him not guilty of this crime if the state hadn't proven that he was guilty beyond a reasonable doubt, or if we proved that he was not guilty by reason of insanity because you have a family member who's in law enforcement?
No.
You could conceive of finding Mr. Loyd not guilty and still having those conversations with your uncle who's in law enforcement and being able to say, listen, you know, this is why I did this, or whatever the case may be.
Yeah.
Okay. Again, no right or wrong answer. Some people say, listen, I have a sister who's in law enforcement, and this just isn't the case for me, right? I'm just trying to figure out what your relationship is with your uncle, if it's one that would make it difficult for you to sit as a juror in this case. What do you think?
I don't think it would be that difficult.
Okay. So we talked about your feelings on how someone should be punished who's guilty of the intentional premeditated killing of an innocent victim, right? What are your feelings on how someone should be punished if that innocent victim, the intentional premeditated killing of the innocent victim, the victim was a law enforcement officer? Sure. does the fact that the victim was a law enforcement officer, right? So it's an intentional premeditated killing of an innocent victim, but the innocent victim, for the purpose of this question, is a law enforcement officer. What are your feelings on how that defendant, how he should be punished?
I don't really know, like, how he can be punished.
Okay. Do you think because the victim is a law enforcement officer that makes you think death should automatically be the penalty?
No.
Say again, I'm sorry.
No.
No, okay. This murder, we're talking about what the appropriate penalty is once you found somebody guilty of the intentional premeditated killing of an innocent victim. If that defendant also found guilty of another murder, does death become the automatic penalty for this murder?
Maybe.
You're doing great. Just tell me what you're thinking. What's in your head? Go ahead and say it out loud.
I don't really know.
You don't really know? Well, let me ask you a little bit differently. First, we're talking about this murder, but knowing that defendant also has been previously convicted of murder and is serving a sentence of life in prison without the possibility of parole. Is life in prison without the possibility of parole a significant penalty under those circumstances?
Yes. Yes. Yes.
Yes. Tell me, if you heard about this defendant who's been found guilty of the intentional premeditated killing of an innocent victim, being exposed to racism throughout the course of his life, would that have any effect on your decision making as to what the appropriate penalty is?
No.
No?
No.
Okay. You have talked to Mr. Buxman about mental illness, and you believe mental illness is a real thing, but you don't know anyone, or you've never met anyone who has a mental illness. Is that fair? Okay. Do you think mental illness, or is mental illness something you could consider or contemplate when deciding whether life or death is the appropriate penalty? Why do you think your responses are different about mental illness and the effects of racism?
Wait, what?
So one, you said that would play some role in your decision making as to what the appropriate penalty is, right? Life or death?
Yes.
Okay. And one, you said it would not. Is that fair?
And that they would play a role.
The effects of racism and mental illness? I'm sorry, I don't understand.
Can I see the attorneys at the bench, please?
Yes, ma'am. Okay, just a couple more things, okay? Oh, I'm sorry. I think we fully hashed this out, but if you are selected to be a juror in this case, the decision and responsibility about whether or not Mr. Loyd lives or dies is unequivocally yours as a juror. You understand that?
Yes.
And that's what I'm not trying to overstate it or understate it, but it is an awesome responsibility. With me?
Yes.
Death is never required, not in any case. It's not automatic. There's no set of circumstances where if you apply the law, as Mr. Buxman discussed with you, that you come to the end of it and you have to vote for death. That is never the case. With me?
Yes.
Not in this case, not in the worst possible case you can imagine. Okay?
Yeah.
Where does the decision to give life come from? We call it mitigation. We've thrown that word about a bunch, and it is literally why any one person would choose life or not choose death. Okay? It can be unique to each individual juror. You could find something mitigating and every other juror could disagree with you, and that's okay. It doesn't have to be unanimous. Not all of you have to agree on things like mitigation. Okay?
Yes.
The state, when they present aggravating factors or present evidence of aggravating factors, they're limited to one of 16 things set out in the law in Florida, but mitigation can be absolutely anything. It can be even something seemingly insignificant like a smile you observe between the defendant, his mother, or a family member. With me?
Yes.
Okay? And if any one juror decides that life should be the verdict, then life will be the verdict. Okay?
Yes.
And that's what the law contemplates and calls for. In order for a just verdict to be returned, all 12 jurors' individual moral assessments have to be reflected in that verdict. So there's one verdict form, one foreperson who signs the verdict form, but it should be reflective of all 12 individual moral assessments of the folks on that jury. With me?
Yes.
And so it's sometimes a difficult challenge that it is your duty, your right, and your responsibility to make sure your individual moral assessment is heard in this courtroom. Right? It would be a miscarriage of justice if somebody were able to bully or badger you into changing what your individual moral assessment is. You know what I mean?
Yes.
And so if you have reached a verdict and it's for life and other jurors aren't respecting that, you can say, we're done here, write that down, we're going home, I'm going to get the deputy to get the judge, we've reached a verdict in this case. With me?
Yes.
Thank you, ma'am.
Either side need to approach?
Yes, Your Honor.
Don't worry, I know to wait for you. All right, let me ask you one final question, and this is a non-painful question, I swear. You are a full-time student. Do you want to be excused from this jury?
Sure.
I'm sorry?
Sure.
Sure? Okay, you're excused. Thank you very much. I'm citing the full-time student statute. She's entitled to be excused. It's 41 something. I forgot the end of it. She's entitled to be excused upon request, so I'm excusing her. All right. Take out your pens and take some notes, folks. Jurors have indicated to the deputies that they have certain issues with serving, so I'm going to call them into the courtroom. I'm going to tell you who they are and what their issue is. Juror number 760 in seat 34 has no one to watch her children for 3 weeks. Juror number 931 in seat 44 is indicating this would be a financial hardship. Juror number 584 in seat 50 is indicating that he is scheduled for a hip replacement on November 15th. Juror number 583 in seat 53 is indicating two things: financial hardship and that there is no babysitter for her 4 children. She's given me some additional information that I'll relay to the attorneys at the bench. And lastly, if it becomes necessary, and lastly, I have juror number 553 in seat 60 who is indicating religious beliefs prohibit him, I think it's a him, from sitting in judgment. It's a he, it's a she, him? It's a him, okay. All right, everybody got the notes? So bring me juror 760 in seat 34, please.
Juror 760, 34.
760. Good afternoon. How are you?
Good, how are you?
I'm well, thank you.
Good.
Ma'am, I have some information indicating that you have a problem with childcare if you're selected as a juror in this case.
I do. My caregiver is my mother, but my father recently got sick yesterday, so she has to watch over him now versus the kids.
Okay, because your mom was your caretaker, so
Correct.
she's no longer available to do that.
Yes, ma'am.
Is there anyone else who could watch your children if you were sequestered as a juror for 3 weeks?
No, ma'am.
And what are the ages of your children?
6 and 11.
Okay. State, do you wish to inquire?
State moves, Your Honor.
Any objections from the defense? Sure, no problem. All right, thank you so much, ma'am, for your willingness to serve. I hope your dad feels better and you're free to go. You're excused.
Thank you.
The juror in seat number 44, juror 931.
Juror 931, 44.
All right, good afternoon, sir.
Good afternoon, Your Honor.
You were supposed to find out if your employer was going to pay you. Did you find that out?
Yes, Your Honor.
And are they going to pay you?
No, Your Honor. They're not going to pay me.
Can you pay your bills if you're
No,
here?
Your Honor.
All right. Any objections from state?
No, Your Honor.
Any objections from defense? All right, thank you, sir. You're free to go. You're excused.
Thank you, Your Honor.
The juror in seat number 50, juror number 584.
Juror 584.
He can have a seat in the first chair. I don't care.
First chair. First chair. Yeah. Change their mind. We'll switch.
Good afternoon, sir.
Good afternoon.
All right, you're juror number 584, is that correct?
Correct.
And you're having a hip replacement in November?
Yes, ma'am.
How long has it taken you to schedule that?
About 2.5 months.
Okay. Are you in a lot of pain?
Not really, but it's time to replace it.
Okay. If you had to reschedule it, how long would it be before you could do it?
Well, based on what we had here, it's probably another 3 months, and I'm scheduled for retirement in February, so I need to get it done before then.
Okay. Is that for insurance reasons?
Pardon?
Is that for insurance reasons you need to get it
Yes.
done before then? All right, state.
State moves.
All right, thank you, sir. Good luck with your hip replacement. I hope you feel better. You are free to go.
Thank you, ma'am.
All right. This is the juror in seat 53. Let me see the attorneys at the bench, please. Just very quickly, I need to tell you something. All right, may I have juror 583, seat 53? Oh, he's wearing them. Okay, great, thanks. Good afternoon, ma'am. How are you?
I'm doing good. Good afternoon. How about yourself?
All right. I understand that you don't have a child care available for if you were sequestered as a juror for 3 weeks. Is that correct?
Also, I'm the one that go and pick up my kid, because from the house, I wake up and drop them to the school and bring them back.
Right, so you have nobody who can help you take care of these kids?
No, my mom don't drive.
All right. How old are your children?
I have one that's 4 years old, one 2, and one 14.
All right. Any objections, State?
No, Your Honor.
Any objections, defense? All right. Thank you, ma'am.
Yes.
You're excused. We appreciate your coming.
Thank you so much.
All right, thanks.
I could go home now, right?
You're all done, yeah. Juror in seat 60, number 553, please.
Juror 553.
Good afternoon, sir. How are you?
Good afternoon, Your Honor.
All right. Sir, I've been advised that you have some religious beliefs that make it impossible for you to sit as a juror. Is that correct?
Yes, Your Honor.
All right. Can you tell me what religion you are, please?
I'm Hindu.
You're Hindu?
Yeah.
All right, sir, I confess that I know a tiny little bit about your religion, but not that much. So can you tell me what it is about this case that your religion, that you can't fulfill your duty as a juror?
I look at this case a lot of times on television. I saw it too much times. I'm not saying that, the person did right things, but for my religion, lifetime in prison is no good for me.
All right, so
that cannot affect me. I'm not fit for this case.
All right, I understand that. You don't have to apologize for your religious beliefs, sir, I assure you. We're just going to discuss them a little bit. So the automatic sentence for first-degree murder is life without the possibility of parole. So let me start with the guilt phase. If you found Mr. Loyd guilty of first-degree murder, the least sentence he could get under the law is life without the possibility of parole. So would your religious beliefs prohibit you from participating in finding him guilty or not guilty?
I don't know what I'm going to find him, because that's what I'm telling you. I'm not fit. I don't want to be a juror and then give the other one some problem.
Okay, so let's say he had been convicted of the first-degree murder, and now you have to decide between life without possibility of parole or the death penalty. Do your religious beliefs prohibit you from imposing let me finish the question, from voting for a death sentence?
No, ma'am.
No,
Your Honor, no.
You can't do that.
No.
Okay. State.
State moves, Your Honor.
Defense. All right. Thank you, sir. Thank you for coming in. You're free to go.
You're welcome, Your Honor.
All right. So, the juror in seat number 15, please. Juror number 720.
Right here. Thank you.
Good afternoon, sir. How are you?
Fine.
Okay. We have some questions for you. As I indicated, there aren't any right or wrong answers to this. Right? There's just what you actually think and feel. We're not looking for a specific answer. If you could just tell us the truth, you'll be fine, all right? So let me start with, have you ever heard anything or seen anything or read anything about this case?
No.
You got to answer out loud.
No.
No? Okay. So as you sit here today, can you presume that Mr. Loyd is innocent until and if the state proves he's guilty beyond a reasonable doubt? You need me to repeat that?
Yes.
Okay. The law says that all defendants are presumed to be innocent until and if the state can prove they're guilty beyond a reasonable doubt. As you sit here today, can you presume Mr. Loyd is innocent?
No.
You cannot?
No.
Can you tell me why not?
I don't know. I just don't know.
You don't know, you just think he's guilty?
I think so.
Is it because he's sitting in a courtroom charged with a bunch of things that you think he wouldn't be here if he wasn't guilty or if he hadn't done something?
I think so.
Okay. Do you think you could put that aside, or would you start the trial thinking, yeah, I think he's guilty, but let me see if he can prove to me he isn't?
I'm not sure.
You're not sure? Okay. So let me give you 3 scenarios, and you tell me which one applies to you, all right? It's day 1 of the trial. You're a juror. You're sitting in the chair. You're quietly thinking, you know, the judge told me to presume he's innocent, so I'm going to do that, and I'm going to see if the state can prove he's guilty. Number 2, you're sitting in the chair, quietly thinking, okay, I think he probably did this because he got charged with it, but I'm willing to listen and see if I'm wrong. And scenario number 3 is, I really think this guy's guilty, but I'll sit here because the judge told me to. Do any of those 3 apply to you?
Yes.
Which one?
The first one.
The first one?
Yeah.
You can presume he's innocent and you'll wait to see if the state can prove he's guilty?
Yeah.
Okay. So, Do you have any religious or moral objections to the death penalty?
Yes, Your Honor. I don't believe.
You don't believe in the death penalty?
No.
All right. Is that based on a religious belief or
Religious,
just your
yes.
personal belief?
My personal belief.
Your personal belief. How long have you had that belief?
I think since I was a kid.
Since you were a child?
Yeah.
Okay. So because of that belief, would you ever be able to impose a sentence of death on someone? Or to vote, excuse me, let me rephrase that. Would you ever be able to vote for a sentence of death on someone?
I mean, I should be, to me, I should, I should vote or do anything to kill someone.
All right. So you remember the process I described to you. You listen to all the evidence. You go back in the jury room. You weigh the aggravators and the mitigators. If you did all of that, and in that weighing process, would you ever consider a death sentence?
No.
All right. State.
State moves, Your Honor.
You may. Yes, ma'am. All right, Ms. Miller's going to ask you a few questions, sir. All right? Thanks.
Hello. Let's start where you left off, talking about the death penalty or life without the possibility of parole. In order to serve as a juror on this case, a juror is required to give meaningful consideration or be able to give meaningful consideration to both possible penalties, the life penalty and the death penalty. Okay?
Mm-hmm.
No one is signing you up to have to give a death verdict. Death is never required, not in any case. But you do have to be able to give consideration to both penalties to be able to serve. Do you think you could give consideration to both penalties?
Not death penalty, no.
I'm sorry, I can't hear you.
Not death penalty. I don't like that. I don't like to be.
You couldn't even consider it as a
No.
possible penalty? Okay. I have just a moment.
Yes, ma'am.
I have no objection to the state's
All right,
motion.
thank you. All right, sir, this is not the case for you, but we appreciate your honesty, so you're free to go. Thank you.
Thank you.
Juror in seat 22. This is juror number 905. Welcome back.
Thank you.
How are you?
Doing good.
All right. So we're going to be asking you some questions. As I said, there are no right or wrong answers to these questions. There's just what you honestly think and believe. So just answer the question honestly, all right?
All right.
Last time you were here, you told me some issues about your daughter and Halloween, which had us all feeling badly. You said you were willing to serve. Is that still?
It is, and I've actually discussed it with my daughter already.
Okay.
We didn't go into detail, but I explained the process to her, and being 5, she understood to some extent. For being 5, we've had a lot of discussions overall of politics and justice and right and wrong. So this was just another add-on to all of that. So she understood.
Okay. She's a good child. So let me start with this. Have you heard anything about this case?
Yes and no. I was actually working right down the road at Massey Cadillac when all this transpired that morning.
Okay.
So what I heard about it was there was a shooting at the Walmart. Of course, it was on media news. I'm going to be honest, 4 years ago seems like such a long time ago. I haven't heard anything new except for Friday morning. when I was telling coworkers, oh, you know, I got to do jury duty today, I guess a little snippet had come on the news channel that they were watching, and they'd brought up this case and then another case in Texas. And we actually discussed the other case in Texas because I had no clue. I don't watch the news anymore. So.
Okay. Based on what you've heard, the snippets, any conversations you may have had with someone, have you formed an opinion as to whether or not Mr. Loyd is guilty?
No, ma'am.
Okay. Could you sit here and presume him to be innocent until and if the state proves he's guilty beyond a reasonable doubt?
Yes, ma'am.
Okay. The death penalty. Do you have any religious or moral objections to the death penalty?
No, ma'am.
On the flip side, are you someone who believes that if someone is convicted of first-degree premeditated murder, which is intentional murder, do you believe that that person should automatically be sentenced to death?
No, ma'am.
Okay. The state of Florida does not have an automatic death penalty for anyone or for any type of case. You understand that?
Yes, ma'am.
I described the process to you. State, you know, aggravators, defense, mitigators, they present evidence. I give you the law, you go back in the jury room. It's an individual decision. You're gonna weigh out those aggravators and mitigators. You can accept them, reject them. It's totally up to you individually. Whether you accept them, what weight you give them, you may find some are very important to you, some are not. But at the end of that whole process, you've heard the whole case, you've weighed the aggravators and the mitigators, you believe that the appropriate sentence is life without the possibility of parole. In this case, could you vote for that?
Yes, ma'am, if I believe that that was a just verdict sentence, I guess.
Okay. And if your conclusion was that the appropriate sentence is death, could you vote for that?
Yes, ma'am, I could.
Is the fact that count one involves the death of a law enforcement officer, would that lead you to automatically vote for death?
No, ma'am.
All right. The insanity defense that's been raised here, it's in the guilt phase. It's when you're trying to decide whether or not Mr. Loyd is guilty, all right? It's the only time in the guilt phase that the defense has a burden. They have to prove it by clear and convincing evidence. If at the end of the guilt phase, you've heard all the state's evidence, you've heard all the defense's evidence, you believe that the defense has proven that he was insane at the time of the offense, would you be able to return a verdict of not guilty by reason of insanity?
Yes, ma'am.
And lastly, you heard me tell you that he's been previously convicted of the murder of Miss Dixon and her unborn child. She was pregnant at the time, and received a life sentence without parole for that case. You can't use that to decide whether or not he's guilty. It's a different case. It doesn't have anything to do with whether he's guilty or not in this one. You understand that?
Yes, ma'am.
Can you set that aside until I tell you now you can consider it?
Absolutely, ma'am.
All right, thank you, sir. I don't have any other questions for you, but the attorneys do. Mr. Buxman, you may proceed.
Good afternoon, sir.
How are you doing?
Not too bad, you?
I'm here.
I have a couple questions off of your jury questionnaire that you filled out. You indicated you had been a juror in the past?
I have.
Okay, was that here in Orange County?
It was.
About how long ago?
Oh, man. 15 years ago, maybe?
Do you remember if it was a civil or a criminal case?
It was a criminal case.
And without telling me the verdict, were you able to deliberate and reach a verdict?
No, we were not. I don't know what the saying was, but we were, I guess, a hung jury. We couldn't come to a group decision in the back.
Okay.
And
did you come to the decision of whether or not who would be the foreperson?
Yeah, we had nominated someone, yes, sir.
Okay, were you that foreperson?
No, sir.
Got it. Is there anything about your past jury experience that just makes you not want to do this again?
No, sir.
Would you consider it a good experience, a pleasant experience?
It was fair. I mean, it's. I think I've said this before. It's my civic duty. So, you know, to be a part of this nation that we have, and I explain this to my daughter. This is part of what we have to do, and we need to be fair when we're doing this so everybody can have a fair shot. So I wouldn't say I was elated, but I'm not, you know, depressed about it either. It's just middle of the road.
Understood. You also indicated that either a member of your family, you or a member of your family has either been accused of, a complainant, or a witness in a criminal case?
Oh, yeah.
Can you tell me a little bit about that?
My siblings.
Okay. What about?
I actually have one in Seminole County right now without bail. Oh boy, I think another one's got a warrant out. I'm going to use the term, and excuse this, but my family is white trash. I am not. So that'll just draw the line right there.
Okay. Would your siblings' criminal issues affect your decision in this case in any way?
No, sir. I think that they deserve what they're going to get. So
understood.
Yeah.
All right. I'm going to ask you a few questions about the death penalty and your feelings about it and the process that we go through in this. Now, obviously, the death penalty never becomes an issue unless the defendant is found guilty of first-degree murder.
Yes.
Okay, and regardless of how bad the facts of the murder are, how egregious the murder is, how premeditated it was, what defenses were rejected by the jury to get to that point in finding him guilty, he is still entitled to a second phase of the proceeding where a jury listens to aggravating factors and mitigating circumstances. Okay?
Okay.
You agree with that?
Yes, sir.
All right. Do you think that that is a good procedure, that a person is entitled to have that additional procedure following a conviction?
Absolutely, sir.
In that penalty phase, the state would introduce evidence of aggravating factors, which are factors that make this murder more egregious than other murders. No matter how many aggravating factors are presented to you, no matter how egregious those aggravating factors are, you still have to hold off judgment and listen to mitigating circumstances before you make a decision of what the proper punishment should be. Can you do that?
Yes, sir.
All right. Mitigating factors are those factors that may cause a sentence of life to be the appropriate sentence in this case. There can be quite a few different aspects of mitigation. Can you agree to listen to each and every piece of mitigating evidence before you make a decision as to what the proper punishment should be?
I can.
Okay. This is not the time for us to discuss the details or the facts or the pieces of evidence that relate to each aggravating factor or mitigating circumstance. That's for the trial. So I'm not going to ask you feelings about individual mitigators, but do you think, would your answer be the same, that you would keep an open mind and truly consider the mitigating evidence regardless of what piece of mitigation is presented to you? Let me rephrase, that was a bad question. You agreed you have to keep an open mind and listen to the mitigating evidence. If I stood up here and talked about 100 different potential mitigating factors, would your answer be the same, that you would consider each and every one of those, the evidence that relates to each and every one of those, keep an open mind, and then make a decision?
Yes, sir.
All right. Even if at first blush you hear something that is presented to you as mitigation, and at first blush you may be thinking, well, I don't know if that's important or mitigating in my mind. Can you hold off that judgment until you hear the facts surrounding it?
Yes, sir.
Do you think that the integrity of the criminal justice system deserves to have jurors keep that open mind and listen to all the evidence before making a decision?
In fairness of everything that we go through as this country and our justice system, absolutely. If I was to be judged for something, I'd want everybody to listen to everything before judging me.
Okay. And once you go through and hear all the evidence, you then begin a weighing process of the evidence. You could determine, you have a few options. If you hear this evidence, you can determine whether or not the evidence has proven the aggravating factors and the mitigating factors, and you could say it has proven it. Or you could say the evidence hasn't proven that factor and I'm going to disregard it. Or you could say the evidence has proven that factor, but I don't really think that factor is important or weighty in my decision, so I'm not going to give it much importance. Or you could say that piece of evidence in my decision-making process as far as what the proper sentence should be is really important, and I'm going to give it a lot of weight. That's up to you. Can you go through that weighing process and that analysis in coming to your conclusion?
Yes, sir.
And once you go through that process, it is that point that you determine in your own mind what the proper punishment in this case should be. And that's an individual decision that you make. Okay?
Yep. Yes, sir.
If you go through that process and you listen to all the evidence and you felt in your heart that life was the proper sentence in this case, could you come back here and say, Judge, I think life is the appropriate sentence in this case, and be comfortable with that decision?
Yes, sir. Absolutely.
Okay. And on the other hand, if you came back and you deliberated and you examined all the evidence and you determined in your heart that the proper punishment in this case was death, could you come in and do that same thing?
Yes, sir.
Is there anything in your life, your background, that makes you think you may not be a good juror for this type of a case? Anything that just jumps out in your mind?
No, sir.
Okay, great. Last area of inquiry, the judge mentioned the insanity defense. And that, with that defense comes obviously mental health issues and mental health illness evidence. I'm going to ask a couple personal questions for you. You can understand why. Either you, a close friend, or a family member, have you, any of those individuals, experienced any kind of mental health issues in your life?
Yeah, absolutely, sir. I suffer from depression.
Okay.
So, and I take a day leave for it to help me along, and yeah, so 100%.
So obviously you think mental health issues are real? Okay.
Trust me, if you knew me when I was on all my medication, you'd think they're real too.
Some people have the opinion that it's not a legitimate issue in society. So would you be able to listen to all the evidence before you come to a final decision as far as whether insanity has been proven to you?
Yes, sir.
All right. I think we have one moment, Your Honor. No further questions, sir. Thank you for your time. Thank you, Your Honor.
Hello.
How are you doing, ma'am?
Well, I'm well. How are you?
I'm here.
I'm going to start a little bit where Mr. Buxman left off.
Okay.
Mr. Buxman asked you if you could consider mitigation. And you said, I can, and kind of trickled off, and it sounded to me like you were going to say something else. What was that thing?
Well, so I'm not 100%. What paused me there was the phrase of the question. Yes, 100% I can consider mitigation towards the aggravators. But, you know, it's one of those things I can consider it. I consider both of them. And the weight of each one, I can consider that. And I think that's where I wanted to elaborate a little bit more is, you know, even if a mitigator's there, you know, it might be a small mitigator, but it still may have an impact or a weight towards even a larger aggravator. So that was just it.
Okay.
And I just remember the judge from the first, don't give more than your ass. So that's where I kind of went, let me stop. Yeah, okay. Sorry.
Legal advice, but I'm going to ask you to do the opposite. So if there's anything you think we would want to know or would be helpful information, share it, please.
Right.
And that's exactly correct, right? The state is limited by the law. There's only 16 aggravating factors, and they have to prove the existence of at least one of them beyond a reasonable doubt before Mr. Loyd is even eligible for the death penalty if we get to this penalty phase.
Okay.
Right? Mitigation can be absolutely anything to anyone, and it doesn't have to be unanimous. That is, all of you don't have to agree. So you could say, I found it mitigating just a smile I observed between the defendant and his family member. And for me, that's something I'm going to assign the weight of life to. And the law allows that.
Okay.
Okay, so it's not like a weighing, it is a weighing process, but it's not like a balancing where does the, mitigation have to be more weighty than the aggravation. You just don't have to vote for death under any circumstance.
Okay.
Okay? You also, when Mr. Buxman asked you if the law required it, could you impose a life without the possibility of parole sentence? Do you recall?
Yes, ma'am.
And your answer was, if I believed that was a just verdict.
Yes, ma'am.
Tell me what you mean by that, please.
Well, I'm going to refer to my daughter. I'm sorry, because I try and teach her a lot of life lessons, and all life is precious, okay? We don't kill insects in our household. We catch them and release them. With that being said, mosquitoes are killed, without question. Spiders are killed if I can't get them out. And then we also, when we see a dead lizard or an ant, she cries, and we explain the circle of life. So I think all life's precious, and the answer still stands. If it came back and, everything was proven beyond a reasonable doubt, yes, I could come back and say life is a fair sentence. So that's kind of where my weight comes in on that. And it's just a belief that all life is precious. It's not a religious thing. It's just we respect others, we treat others with respect, and we respect all life. So.
Yeah. And I'm not asking you to tell me, these are the things that I find aggravating and these are the things I find mitigating. Right. But how do you make a determination about what a just verdict is when you're determining whether somebody lives or dies?
Ma'am, to be honest, I don't have a clear, defined answer on that. I would assume that it would be presented to us and that during the process, I think it would be one of those things that click and say, you know what, I could see where this is a merit of the death penalty, or, I don't see him being guilty because of this. I just think during the process, it'll, I don't want to make a judgment on anything or anyone without hearing everything, and I think that that's where I kind of stand on that.
I got it. When you say everything, what do you mean?
Well, I mean, so let's face it, we've all watched TV shows, right? Whether they hold any truth or not. But I've been in, a juror before, so I know that it's got to be proven beyond a certain reasonable doubt. So if during the process it's not proven, then I can't come forward just a blatant disrespect for life, I think that would be a death penalty for me. If, let's say it wasn't any of those, but they still committed the crime, then a life sentence. You still took a life if you're proven of that.
Right.
Right? So I think that would kind of merit my decision on the death penalty or not. Once again, I'd like to refer back to raising my daughter as a good human being. All life is, equal, and we need to respect life.
What, when you say, that's what I just don't know what's in your mind. Only you know that. When you say vicious, what do you mean by that?
Let's just say that whoever it is that we are talking about spit on the body after they maybe shot the person down. To me, that would be a vicious, malice, like just disrespectful, and that would be, for me, kind of a lean towards, hey, this is a death penalty because you just had no regard for that other person's life whatsoever.
Okay. And so fair to say this all comes back to your feeling that life is precious.
Correct.
So even if a life is taken showing like a heightened level of disregard?
Correct.
Okay.
Yeah. I mean, that's me.
Yep, I got it. The innocent victim in this scenario, right? So intent, and you talked about vicious and with malice. First-degree murder in Florida is defined as the intentional premeditated killing of an innocent victim.
Okay.
Okay? So let's assume that's true, and now also that the innocent victim is a law enforcement officer.
Okay.
Is death now the automatic penalty?
No, ma'am.
Why not?
I would say there's probably a lot of factors that go into that, which obviously what plays into a death penalty. A blatant disregard for life. No, ma'am. The answer is still no. No,
Okay.
It doesn't make it an automatic death sentence.
If those things are true, the blatant, the disregard for life, the vicious, are you still able to consider mitigation or things that would weigh against that?
Absolutely.
Let me ask you some specific questions. Do you think that if you heard a defendant had been exposed to the effects of racism over the course of his life, would that be compelling to you one way or another?
The effects of what, ma'am?
Racism?
Okay.
Reject the term compelling, Your Honor. It's not the standard.
Can I just answer in just a little bit towards that without? Okay.
The question is, could you give that meaningful consideration? Okay, and I think you're a thoughtful person. I don't think you're going to sit there with your fingers in your ears and not listen to the information, right? But you know what's in your head. And so some people say, listen, if I'm being honest, I'm not going to meaningfully consider that.
No, I'm going to consider that. And in regards, I grew up in Pine Hills.
Okay.
Okay. So I was actually the minority in my neighborhood, and I was the subject of a lot of racism. It doesn't affect how I carry my life out. I have coworkers that are of other ethnicities, races. It does not affect me unless they are disrespectful towards me. So I understand being the subject of racism. I do. How it affects people is completely different in every individual. Some people let it rule them and destroy their lives, and some people move on. I understand that, and I get that. It wouldn't be a determining factor, I think. If he was the subject of racism his entire life. Once again, like I said, I grew up in Pine Hills. I was a minority there. I was the subject of racism in Pine Hills. My friends have had guns pulled on them, have been attacked. It is what it is. We move on, we live and learn. Everybody handles everything differently. I would have to hear how that all played out. In regards to me, no, I don't think I could let that be a true factor, mitigating factor, but if it was compelling enough, I'm sure I could. Absolutely.
Okay. Since you mentioned it, tell me about the conversation with your coworkers about this case and the case in Texas, please.
Once again, I don't watch the news, and they were talking about the young man, I guess there was 2 high school students maybe that were wrestling. One of them pulled a gun, shot the other kid in the classroom, the teacher's in the background, not breaking the fight up. They were talking about that, and one of my coworkers just said, yeah, Markeith Loyd's gonna be going to trial soon. I wanna know how that plays out. That was really the extent of that conversation, because I really didn't have time to sit on the front counter and continue conversation. I had the shop to go back into and work, so that was it. But I had heard something here recently about the Markeith Loyd case, so.
And there wasn't any follow-up either from you or somebody else, like, who's Markeith Loyd? What's he going to trial for?
I knew who he was, so no, I didn't need that aspect. I didn't know what he was going to trial for, and they didn't tell me that it was this one. I didn't even know he had already been to trial over the girlfriend, so I really had no clue.
So when you say you knew who he was, but didn't know what he was going to trial for, I don't understand. What did you know about him or know?
Well, like I said, 4 years ago, I worked right down the road on John Young Parkway at Massey Cadillac.
Yep.
So when this all transpired, our entire neighborhood, the Rosemont neighborhood, there was law enforcement officers everywhere. So, obviously I watched the news to see what was going on at that point in my life. And so I knew about the Markeith Loyd and, the fleeing and just what the news had said, suspected of shooting an officer. That was really it on that part. So yes, the name stood out, but I haven't followed news.
Well, right. Most people have been exposed to some media attention regarding the case, right? The question is, did you form an opinion about either Mr. Loyd's guilt or what the appropriate penalty should be in this case based on that?
No, ma'am, I did not, because I don't know what truly transpired, okay? Once again, my family is entwined with law enforcement, so I've got my dad who thinks law enforcement's out to get his family. So I don't just take everything at face value when I hear something in regards, because I don't know the circumstance and why and what happened. Once again, I don't know if she was in plain clothes, pulled a gun on him. I don't know that. I didn't watch the news enough to know any of that. I don't know the situation. I don't know the circumstance. For the longest time, I had my concealed weapon permit. I let it lapse. I got rid of all my handguns when my daughter came along, just because I was like, you know what? I don't want to take a chance until she's old enough. So, but I'm going to tell you, if I saw someone draw a gun in public and point it at someone else without identifying themselves as some sort of law enforcement, I would have drawn my own concealed weapon on that person. So I don't know the circumstances. So no, I did not form an opinion.
Okay. And then last question, your conversation with your 5-year-old about this case. I am curious what you were able to communicate or what you guys discussed.
So this is on our car ride home the other day, and she was actually kind of funny about it, because this is where, like I said, she didn't understand. I explained to her that I might be going away for 2 to 3 weeks to go to court over, and I use Markeith Loyd's name because it's my 5-year-old, it's just her and I said, he's being accused of doing something and we have to give him a fair trial. She asked what? I said, taking someone's life. And the entire time she thought that, this is going to be funny, I'm sorry, this is from a 5-year-old, she thought that me and Mr. Markeith Loyd were going to be fighting ourselves. So I had to constantly reassure her, no, sweetie, we're there to make sure that justice is carried out and that he has a fair trial, because that's how our system works, how society, and then we got into a discussion about society and the United States and so on and so forth. So,
teaching moment.
It was a very solid teaching moment. I think at some point, though, I corrected her grammar and she got mad at me. So
sounds right. Is that when you say you talked to your daughter about justice?
Oh, right. Just the justice system and what's fair and right. Yeah, we had a conversation on that and how we don't judge people until we know everything about what's going on.
Okay. And just want to move topics a little bit.
Okay.
Death, as we've discussed, never required. Not in any case.
Correct.
This case, some other case, the worst imaginable case you can conceive of, it's never required. With me?
Yep.
And that if one person decides, one juror decides that life should be the verdict, then life will be the verdict.
Correct.
Comfortable with that?
I am, because I kind of understand how this works if we can't unanimously agree on a death sentence, if that was what some of us were going for or some of us were not going for. We can't unanimously agree on that. I understand 100% that it's life without possibility of parole. Yes, ma'am.
Interesting because of your experience as a juror, right? So the first part of this case, where you have to decide if the state has proven Mr. Loyd, guilty beyond a reasonable doubt, or if the defense has proven him not guilty by reason of insanity, right?
Correct.
One of those two things, that has to be unanimous. All 12 of you have to agree.
Right.
In the second part of this, the law asks that each of you make an individual moral assessment about what the appropriate penalty is, okay? There is no such thing as a hung jury. You could have a hung jury in that first part, just like your other experience.
Okay.
But in the second part, that doesn't exist.
Okay.
Right? The law wants all 12 of you to come to your own individual moral assessment. And we talked about mitigation a lot, and it's why any one person would choose life or not choose death. And as we discussed, it doesn't have to be unanimous. It can be unique to each individual juror. You just say, this is the reason I'm not giving the death penalty today.
Okay.
It is your duty, your right, and your responsibility to make sure that your individual moral assessment is heard in this courtroom. It would be a miscarriage of justice, right, if somebody was able to bully or badger another juror into just agreeing with what that juror thought. Would you agree?
Yes.
And you're going to respect somebody's opinion, even if it's different from your own.
100%.
And you'll step in if you see somebody trying to bully or badger someone into changing his or her own individual moral assessment.
100%.
If you have reached a verdict and it's for life and it's not being respected by your fellow jurors, you can say, listen, we're done here if you're not the foreperson. But you can say, listen, we're done, write it down, get the deputy, get the judge, going home. I've reached a verdict. Can you do that?
I can, yes, ma'am. I mean, I would definitely, with my fellow jurors, you know, if someone asked why did I reach my opinion, I would definitely explain that to them. But I wouldn't force my opinion on anybody. I wouldn't allow anybody else to force their opinion on me or someone else. If I felt as if anybody was being bullied, I would definitely intervene. That's just my personality. So,
what I can say this because it's true of me, you're chatty, right? And so some people say, yeah, I have no problem sharing how I've reached this decision. And some people say, I don't know, and I don't want to talk about it. I just know in my heart of hearts or in my gut that this is going to be the verdict. And that's okay too, right? We encourage folks to deliberate. We just don't encourage people to bully or badger each other into changing their own individual moral assessment. Make sense?
Yes, ma'am.
Just one moment, Your Honor. I have nothing further. Thank you. No, ma'am.
No, Your Honor.
All right. So we're going to bring back for last round of questions, okay? And that is the day that we're going to pick the jury. So, first thing that's going to happen is you're now a purple belt.
No.
I'm sorry, you're a never research. Okay? If you are present, please.
Okay.
going to get a purple dot. You're going to get a purple dot, and we're going to give you a package, a sequestration package. The color purple is just because that's what you're listening for now.
Okay.
Start calling. Don't start calling before Friday after 5. So call Friday, Monday. Eventually, you're going to hear purple dots return at this, on this day, at this time. I don't know what that is. It will not be before next week. I have to get enough jurors who are purple dots to get them out here.
Okay.
That day, we're taking the jury and we will also question. So you need to have that. That should take, leave it in the car, not take it to the jury. You just have to unpack it, or take it to the jury, one of us out that day. That package you includes the slip of phone number call, and instructions for jurors that are being sequestered using the same number, and explain being sequestered. Any questions?
No, ma'am? Believe it or not, I eat a lot. That's and I get hungry. I get hungry a lot throughout the day. My fiance packs me a sandwich. Okay, perfect. You too. Thank you, ma'am.
All right, the juror in seat number 26, juror number 308.